is with great pleasure and anticipation that I welcome you all to the first international roundtable on confronting global conflicts and the rule of law, with a particular focus on the complex dynamics between Russia, Ukraine, and Israel-Hamas. I'm Varudhini, the diligent research assistant who probably would have bombarded your emails, your inbox with lengthy emails yesterday. But worry not, today I promise to keep it concise, engaging, and hopefully a tad effective. This momentous event, hosted by OP Jindal Center for United Nations Studies, represents a significant milestone in our ongoing commitment to fostering dialogue, understanding, and actionable solutions to some of the most pressing challenges facing our world today. At OP Jindal Global University, we pride ourselves on our dedication to academic excellence, innovation, and global engagement. Our institution stands as a beacon of knowledge, fostering critical thinking and interdisciplinary collaboration in pursuit of a better world. It is within this spirit that the Center for United Nations Studies at the Jindal Global University was established in 2015 with the aim to identify knowledge gaps and undertake individual and collaborative research unrelated to the UN institutional developments and its role in international peace and security. By bringing together leading experts, policymakers, and practitioners from across the globe today to engage in constructive dialogue, the Center seeks to explore pathways towards peace, justice, and stability. Before I resign to the silence as an amiable assistant would and let my professor take the stage, I would like to speak a little about the objective of today's event and the challenge of trust we are confronted with in the present time. The objective of today's roundtable is multifaceted. We seek to delve deep into the root causes of conflicts between Russia and Ukraine, as well as the long standing tensions between Israel and Hamas. By examining these complex issues through the lens of international law, human rights, and diplomacy, we aim to gain a deeper understanding of the underlying dynamics and to identify potential avenues for resolution and reconciliation. In 1953, the first UN Secretary General Trygve Lie welcomed Dag Hammarskjöld, the second Secretary General, arriving in New York, saying, "Welcome, Dag, to the most impossible job on this earth." The UN has been often criticized and turned into a scapegoat when states fail to live up to their initial expectations of its founders. I was going to give an elaborate and somber description of the increasing number of deaths in Gaza and elucidate on the numerous claims of the UN's inaction and its troubled diplomatic stand that exists at the center of the conflicts. But scorning over the dead wouldn't but scorning over the dead but scorning over the dead wouldn't stop the dead from taking more lives. Identifying war crimes and admonishing and punishing the perpetrators would. As people of law, we don't simply state that the world has lost faith in the UN. What we do is that we delve into the intricacies of the rule of law and understand how numerous number of legal instruments bring about substantial change, which is often invisible and under the wraps in conflicts such as these. We also seek to identify structural problems in the rule of law as it exists today and alter and evolve it so as to wholly and completely curb conflicts that severely shatter the very fundamentals of humanity. Therefore, here we are, ladies and gentlemen, to do exactly that and generate avenues for peace and resolution. Dag Hammarskjöld famously once said that the UN was not created to take us to heaven, but to save us from the hell. Curious youngsters and amateurs such as me and my fellow students here are looking up to you dignitaries to guide our conference and to reinstate it in peacekeeping bodies and to pave a path that would empower us to bring about real and material change to the status of humanity, to the rule of law that the justice systems labor to preserve. And finally, to guide us through these discussions, it is my privilege to introduce Professor Pier Paolo, whose expertise, leadership, and dedication have been instrumental in shaping the vision, and direction of this event today. As a renowned scholar in the field of international law and conflict resolution, Professor Paolo brings a wealth of knowledge and experience to our deliberations. I have no doubt that under his guidance, today's roundtable will yield valuable insights and chart a course towards meaningful progress. And thank you for being here. Thank you for your unwavering commitment to peace and justice. And thank you for allowing me to be a small part of this incredible journey. Thank you.
Ladies and gentlemen, esteemed colleagues, distinguished guests, and dedicated students. Thanks, first of all, to Varudini for this warm introduction. Good morning, good afternoon, good evening, depending on where you are joining us from today. I am Pierpaolo Petrelli, Associate Professor and Senior Fellow at the Center for the Study of the United Nations here at OP Jindal Global University School of Law. It's with great honor and anticipation that I welcome you to the first international roundtable titled Confronting Global Conflict and the Rule of Law, a focus on Russia-Ukraine and Israel-Hamas. Yesterday, when I was preparing my welcome speech, I was thinking what I can say to introduce this pivotal event. No? And then I reached the conclusion, okay, maybe it's important to try to explain to the audience what is the aim, the objective, why we scheduled this, we made this event. And I think it's important to understand that today marks a significant moment as we convince scholars, practitioners, and policymakers from around the globe to engage in critical discussion that shape the intersection of international law and global politics. This forum is not merely an academic symposium. It's a crucial confluence of mind aimed at unraveling and addressing the intricate challenges posed by global conflicts through the rigorous application of international law. In your world, where conflict transcend border and impact global peace and security, the role of international law becomes even more crucial. This roundtable provides us with an opportunity, a platform, not only to dissect or understand this complex issue, but to contribute to the discourse and how law can confront global conflict and the mechanisms that govern this interaction. This roundtable represents a significant commitment to enhancing your understanding of the complex issues. It serves as a bridge, connecting diverse perspectives from around the globe to delve into the role that international law plays in mediating conflict and fostering global cooperation. Your objective today is to engage in a comprehensive examination of how legal norms and frameworks can be effectively enforced in time of international turmoil. As we dive into today's agenda, we found yourself focusing on two critical areas of geopolitical tension: the ongoing conflict in Ukraine and the protracted struggle between Israel and Hamas. This situation tests the limits of your international legal frameworks and challenge the global community ability to enforce justice effectively. We are here to dissect these conflicts, to understand the challenges and opportunity they present for the enforcement of international law. It's a crucial endeavor, as this discussion not only casts light on pathways to justice, but also reveal the complexity inherent in global governance. We have an exceptional lineup of experts joining us today, thinkers and practitioners who stand at forefront of international law. Their diverse experiences and insights are set to enrich your conversation significantly. I encourage everyone to dive deep into this discussion, ask the hard question, share your perspective, and engage fully with your panelists. This roundtable is more than just a series of talks. It's a platform for lively dialogue, a space to challenge the status quo, and a chance to propose innovative solutions to complex global issues. The relevance of our discussion today goes beyond academic inquiry. We are here to influence real-world policy and practice that shape international relations and conflict management. We are here to envision and advance a world where justice is reality in the face of conflict and peace is pursued with dedication. So let's use today as a catalyst for change in international law and global governance. In conclusion, I wish to express my profound gratitude to all our participants. Your presence here is a testament to your commitment to fostering a world where justice and peace are pursued rigorously through the power of law and through truthful governance. I am confident that the insights shared today will contribute significantly to our understanding and action in global arena. So let us proceed with a spirit of collaboration and determination, ready to engage in a rich discussion and to draw from them actionable technology that will guide us in your continued quest for a just global society. As we move forward in your agenda, it is my distinct privilege to introduce our keynote speaker, Professor Veselin Popovsky. Professor Popovsky serves as the esteemed executive director of the Center for the Study of the United Nations and vice dean here at OP Jindal Global University School of Law. His remarkable career spanned various continents and crucial roles, each underpinning his profound commitment to international law and justice. As we set the stage for a day filled with rich discourse and insightful deliberation, it is a profound honor for me again to introduce this luminary in the field of international law and global justice. Before joining us at Jindal, before of me, to be honest, Professor Popovsky held significant position at the United Nations University in Tokyo, where he led pioneering research on international law, peace, and security. His academic journey is complemented by a robust portfolio of research that include extensive publication topic critical to our understanding of international law and its implication on global peace. Veselin's expertise is not just academic, it's profoundly practical. He has worked on the ground, seeing firsthand the complexity of international law as it intersects with global conflict and humanitarian crisis. His insights into how international institutions can effectively respond to global challenges have influenced policymakers and academics alike. Beyond his professional endeavors, Professor Popovsky influenced also student, next generation of legal scholar and practitioner into his passionate teaching and mentoring. His contribution to the field have not only reached the academic community, but have also provided practical framework for addressing some of the most pressing issues of your time. For me personally, it's an immense honor to call Professor Popovsky a colleague and a mentor. The opportunity to collaborate with him, to learn from his insight, and to contribute to his initiative, it's truly inspiring. It's a privilege that enhances my own work and commitment to the principle of international law and justice. Today, as a Professor Popowski addresses us with his keynote on navigating the complex landscape of international criminal justice, we are afforded a unique opportunity to gain from his extensive knowledge and his visionary perspectives. His keynote address promised to offer profound insight into the challenges and opportunity that lie ahead in your quest for global justice and peace. Please join me in warmly welcoming Professor Veselin Popovsky. Professor Popovsky, please, the floor is yours.
Thank you very much, Pier Paolo Petrelli. I'm very pleased to be introduced in such a lovely manner. Indeed, as you said in your introduction...
I cannot hear you, Professor Popovsky.
How about now?
Yeah, now works.
Yes, my pleasure and honor to be invited to deliver the keynote speech for this roundtable. Thank you, Pier Paolo Petrelli, for the introduction and also for bringing such a great set of scholars and experts on an issue which cannot be higher in the international agenda as how to address the protracted conflict between Hamas and Israel, but also the continuous war between Russia and Ukraine. I'm going to focus on international criminal justice, but later in some of the panels, I'm also happy to give some opinions when it comes to reforming the United Nations and other institutions so that these institutions deliver a better protection from such international crimes. I'm going to display some slides. I wonder whether the screen is visible. Can you confirm?
Yes, it's visible.
Okay. So, well, as you can see now, the criminal justice generally serves 4 purposes. And the first of these purposes is to establish crimes and also to prohibit conduct which is determined as international crimes. Now, the next purpose of the criminal justice is to investigate these crimes, effectively to prosecute the perpetrators, to issue sentences, guilty or not guilty, following the rule of law and the due process, and finally to compensate the victims. Why do we need international criminal justice? The answer is simple, because not every domestic criminal justice can exercise the necessary work, because some states have been ruined after wars, after armed conflicts, or in some other manner they could be incapacitated to investigate and prosecute. Just to give you examples, Germany and Japan after the Second World War, Bosnia and Herzegovina and Rwanda in the 1994, 1995, and various other situations. We can think of Sierra Leone after the civil war there. So one reason why we need international criminal justice is for situations where the domestic judiciary doesn't exist, and therefore the only possibility is to have an international court as to take care of the task to deliver justice and prosecute the perpetrators and to compensate the victims. But there is also another situation where we need international criminal justice, and this is when leaders who are allegedly committed crimes are still in power, and they are unwilling to investigate and prosecute, obviously, for obvious reasons. So either we have a situation of impossibility because the leaders don't want to investigate, or because there is no judicial system domestically which is able to do the work. Now, and let me go quickly through some examples in the past as to illustrate how the idea of international criminal justice has developed over time. After the First World War, in the Versailles Treaty on the agreement between Germany and victorious states, we have Article 227 that suggests that Kaiser Wilhelm, the major war criminal of the First World War, should be prosecuted for supreme offenses against international morality and sanctity of treaties. I think this is a revolutionary moment in the history of international criminal law, when a peace treaty demands the prosecution of a former head of state for the crimes. In this case, it was a bit formulated in an ambiguous kind of abstract manner: supreme offense against international morality and sanctity of treaties. Unfortunately, it didn't work in practice, but the idea to put this into the peace treaty in Versailles, I think, is admirable. It didn't work because, interestingly, Netherlands gave refuge to Kaiser Wilhelm, quoting a principle of law and saying that the Dutch law doesn't have the crime as described in the Versailles Treaty. There is no supreme offense against international morality and sanctity treaty in the penal code of the Netherlands. And for that matter, they cannot extradite the Kaiser to face a tribunal elsewhere. The British demanded that. It didn't work. He remained there. Paradoxically, because today we have The Hague, the capital of the Netherlands, as the place where we have the International Criminal Court, and also previously other International Criminal Tribunal. What happened, though, in Germany is that there was an inquiry commission that collected more than 10,000 of evidence of crimes committed by various German officers and soldiers, and those were given to the prosecutors in the Leipzig trials. And out of 10,000 cases, only 3 sentences finally ended up being issued. And even those 3 officers that were put in jail for very minor sentences were like between 1 and 3 years. And even those were not served in jail. They were let go by the guards of the prison. And all the German population basically cheered that moment because they didn't want to see their own soldiers being in jail. Which means that in a situation like I described, after a major war, after a major armed conflict, it's very difficult, not to say impossible, to apply international criminal justice. And the same happened, by the way, with the crimes committed by the Turkish military, the notorious genocide against the Armenians in 1915, again, similarly remain unpunished. Although, again, in the Treaty of Sèvres, which is 1920, the first treaty for Turkey, we have a text to prosecute the Turkish military for crimes against Armenians, but later in 1923, after the revolution in Turkey and Kemal Atatürk coming to power, the Allied powers, Britain mostly, decided not to follow up on that, and the Treaty of Lausanne, which replaced the Treaty of Sèvres in 1923, deleted that text and effectively gave a blanket amnesty to the Turkish military. Interestingly, some of them hiding in Germany or other countries in Europe later were assassinated by Armenian men who simply exercised the revenge for the fact that their families perish in the genocide. And in one famous case, when the Armenian assassin was brought to trial for the assassination of Sultan Pasha, one of the architects of the Armenian genocide, he was acquitted by the German court because he produced evidence in defense showing that his family has been killed by the policies introduced by the Turkish general. And that led, by the way, interestingly, Rafa Lemkin, who is the Polish lawyer who introduced the concept of genocide, watching that trial as a young student in Lvov in 1926, came up with the idea that some crimes are so notorious that if there is no international criminal court, Lemkin argued, then there should be specific determination of those crimes committed against ethnic, religious, or national group. He later came up with the definition of genocide. To move next, after the Second World War, what we see is already an establishment of tribunals such as Nuremberg and Tokyo, a step further, I must say, in international justice. Here we have already the German and Japanese military leaders and political leaders, including, being in the dock for what they committed, crimes against peace, crimes against humanity, and war crimes. So three scopes of jurisdictions in the international military tribunals. Obviously, there is a lot of legal criticisms, and we all know that those were considered to be victors' justice because the tribunals prosecuted only those crimes committed by Germany and Japan, but not similar crimes committed by the Allied powers. In one notorious incident, the massacre of Polish officers in the forest of Katyn in East Germany, committed by the Soviet army, was placed as a charge on Nazi Germany, although those murders were committed by the Soviet army. Also, the Nuremberg and Tokyo apply selective use of law. They effectively had to choose certain language, for example, from Brian Kellogg back in 1928, as to formulate the crime against peace as a violation of the pact. It was not easy. They had to use crimes against humanity, which is still not very developed internationally concept. They were acting before the Geneva Convention in 1949, so basically they had to rely on the Hague Conventions, 1899 and 1907. But nevertheless, I would like to say that although we understand the legal shortages of Nuremberg and Tokyo, I don't see any alternative here. In that situation, this was the only possible way to give some opportunity for those Nazi leaders and Japanese leaders to be put on trial. Because the alternative to the Nuremberg and Tokyo was simply extrajudicial punishment, by the way, discussed by Stalin and Churchill for some time initially, until at the end they agreed with Roosevelt, who insisted to create a tribunal, a military tribunal for those leaders. What also I think is the legacy of Nuremberg at Tokyo is the idea of the end of impunity for heads of state. So again, for the first time in history, we have heads of state prosecuted in international tribunal, including the Prime Minister of Japan and the German leaders, which creates an interesting challenge to the absolute sovereignty status of those leaders. For the first time in history, also, we have individual accountability for international crimes. This concept has quickly developed after Nuremberg and Tokyo, and individuals became subjects of international law, which means not only international humanitarian law, but also human rights law. In a way, if individuals can be prosecuted as perpetrators, similarly, individuals have to be protected as victims. In other words, we have two major developments here. On one hand, individuals as perpetrators, the codification of international humanitarian law, but also the development separately, in parallel, of the international human rights law with the Universal Declaration of Human Rights in 1948. And many other later, the European Convention of Human Rights 1950, many other developments, which suggest that individual rights are important. Individuals can be perpetrators, they can be also victims of violations. And I think that is the legacy of Nuremberg and Tokyo. So we have to acknowledge and to speak positively about these two tribunals, no matter how imperfect legally they could have been. As much criticism as we can raise in terms of the shortages and legal problems, we still need to recognize that Nuremberg and Tokyo paved the way for development of international humanitarian law on one hand and international human rights law on another hand. Which then brings us to the more modern times with the establishment of various criminal tribunals. In the last 20 years, we have the tribunals for Yugoslavia and Rwanda set by the United Nations Security Council with limited jurisdictions in time and place. We have the Special Court for Sierra Leone established as a hybrid court, which applies international standards, but within the jurisdiction of the penal code of Sierra Leone, with a lot of international involvement. We have later today William Shabas in one of the panels who was very much engaged in that court. We have also David Crane, another judge who served in Sierra Leone. They will probably talk more about that tribunal. We have extraordinary chambers in the courts of Cambodia to prosecute the Khmer Rouge, who committed massive crimes against humanity in the late 1970s in Cambodia. A bit late, I must say, because only more recently those people were brought to trial. It took a long time for the extraordinary chambers to be established first and then to prosecute. But still, nevertheless, symbolically even, we can say the chambers did their work, putting international criminal justice as a stepstone in the development of a peaceful today Cambodia. We have a special tribunal for Lebanon, a kind of a different story here because the ex-prime minister of Lebanon was assassinated, and apparently the political influences and complicated situation in Lebanon didn't allow for an independent investigation and prosecution. Therefore, we have again a situation where domestic justice cannot be served, and that leads to a special tribunal, international special tribunal for Lebanon. And very recently, virtually, I think last week, we have a new development in Central African Republic with establishment of a special criminal court to prosecute the former president Bozize. So as you can see, there are major developments, starting with International Tribunal for Yugoslavia 30 years ago in 1992 till today. Sometimes there is no tribunal, but there were inquiry commissions, as those in Timor-Leste and Kosovo, and the material out of those investigations is given to the domestic courts, etc. Now, the ICC, somehow the ICC comes as a final point in this development, with jurisdiction of aggression, genocide, crimes against humanity, and war crimes. We have the triggers of jurisdiction of the ICC by first, state party, second, the Security Council, and third, the Office of the Prosecutor. Quite a comprehensive list here because, in fact, the purpose was not to allow any crime to be put under the carpet. So if, for example, state parties do not want to make a referral, then there are two more options. One is by the Security Council, and if the Security Council cannot do it because of a veto, then the Office of the Prosecutor still has the chance to collect evidence and to initiate the case and to persuade pre-trial panel of three judges that there is enough evidence to continue. We have an interesting situation between the Security Council and the ICC. I'm sure later in panels we can also discuss that. Article 16, the Security Council deferral for 12 months. Although it never happened, it's an opportunity of the Security Council to exercise its power. And the important Article 17, where states have the first go, like complementarity principles. States within their domestic jurisdiction can go first, but if they are unwilling or unable, I already explained in the beginning that, then only the ICC steps in. And that makes the difference here between the ad hoc tribunals and the Permanent International Court. The ad hoc tribunals established by the Security Council have a priority over the domestic court because of the mandatory binding power of the Security Council resolutions, where the ICC as a treaty has Article 17 complementarity principle. What is also one of the achievements of the ICC is that victims can be represented in the proceedings. It was the first time in history where we have a third bench. In addition to the prosecution and the defense counsel, we have also legal representation of the victims. And also we have another innovation, which is the compensation fund for the victims, which did not exist with the ad hoc tribunals. Now, something important also to mention here is that there are many kind of people who are easily dismissing the ICC and say very few cases were completed, it took long time, it is very expensive, and all sorts of other criticisms. But let's not forget that the success of the ICC is not only in the numbers of those who are brought to The Hague and prosecuted and sentenced. It's also in the standards setting. In other words, the fact that 124 countries in the world signed the Rome Statute means that those 124 countries accept the jurisdiction of the Rome Statute and they apply that jurisdiction in their domestic courts. So the success of International Court is not simply in the numbers of those in The Hague. I will say even more that one day we might not have International Criminal Court. If all the countries in the world properly investigate and prosecute in their domestic systems, the ICC will become redundant. So kind of let's remember that. The ICC brings criminals to The Hague, but also it brings standards from The Hague to all domestic courts. Unfortunately, some big countries in the world are not yet members, and I wish I can see some of those joining, but we don't have good news so far. But nevertheless, the court continues its existence, it goes ahead, it doesn't ask permission from anyone, and it investigates and prosecutes. And I will put in a minute something important on that. Before that, I want to address interesting relationship, I'll call it this way, between peace and justice, saying that the two concepts often are regarded as one. We often see no peace without justice campaigns, which is all good. We should do that. We should demand justice, and we should look at peace and justice collectively. But let's remember that peace is following a different logic. The peace is looking into the future, whereas the justice is looking into the past. And for that matter, they have different agendas, different priorities. For peacemakers, sometimes it's important not to focus on justice, but rather to try to bring the conflicting parties together and to make peace, to make them shake hands and sign an agreement. Whereas for the prosecutors and the justice, it will be the opposite. They will not be concerned with the future and the peace. They would like to dig into the past and to find the evidence of crimes, to exhume the graves and the skeletons, and to although that work might be seen as counterproductive for the purposes of peace. And that's for that reason we need to separate peace agents from justice agents. We should never ask prosecutors to deliver peace. Their job is not peace. Often I see that general criticism that the ICC may jeopardize the peace process somewhere. Well, the ICC is not peacemaker. Leave peace to UN, peacekeeping, mediation, Secretary General missions, everything else in the UN system is about peace. Blame them if peace doesn't work. Don't blame the single prosecutor of the ICC, whose job is not peace, whose job is justice. So don't ask prosecutors to deliver peace, and on the opposite, don't ask peacemakers to testify in courts like they often did in the past. In ICTY, Akashi, the famous Japanese special representative for former Yugoslavia, was very frustrated when he had to appear before ICTY and explain why did he tell Radovan Karadzic to disappear. Well, he's a peacemaker. He wants a peace in Bosnia and Herzegovina. At that time, that was the way to achieve peace. In other words, and my final point on this is just creates short-term tension, but builds long-term peace. And again, if we look back 30, 25 years ago, we will see that every time when we have a investigation or arrest warrant, like against Pinochet in Chile, like Milosevic and Mladic in Serbia and Bosnia, like Charles Taylor in Liberia. Always there are voices saying, don't do that. Don't touch these people because there will be another cycle of war, another cycle of violence. Look at those countries 20 years later. Serbia, Chile, Bosnia, Liberia, Sierra Leone. They are very peaceful. Their presidents were prosecuted. People accepted that. By the way, Milosevic lost elections. He was not removed by force, by military force. He simply was outvoted in elections. And then the next government in Serbia delivered him to the cave. And hopefully others will follow in the same way. Like Syria after Assad, Russia after Putin, and Israel after Netanyahu. Again, as I said, it doesn't work quickly. It takes time and effort, and that's why we are here for, to do those efforts and bring justice for all. Now, I'm sure the later panels will do in more details all this deliberation about Russia, Ukraine, and Israel, Gaza. All I want to just mention is what are the options, somehow to list them, to kind of set the ground for future discussions today. In Russia, Ukraine, we have 4 options for justice. One is obviously the International Criminal Court, which already did a good work by issuing an arrest warrant against Vladimir Putin and Belova Orlova, the ombudsman for children in the Russian Federation. And it was a very clear crime. Abduction of children from occupied territories, par excellence, a crime. there was no need to do much because it was announced on the first channel of the Russian television in an interview between those two. They admitted what they had done, and that was perfect for the prosecutor in the ICC, simply to take the video out of the first channel of the Russian television and to issue an indictment of Vladimir Putin. I think it's a significant step. Again, we have a permanent member of the Security Council, President Putin, being issued international arrest warrant, which limits his travel. He cannot go anywhere. And he didn't go to BRICS summit in South Africa. He is worried to go in India. He cannot travel. He's effectively a prisoner in his own country without being able to go. Apart from North Korea, probably he cannot, or China, he cannot go anywhere else. The second possibility on Russia-Ukraine is something which has been very much discussed over the last 2 years, is to have a special court only on the crime of aggression because of the difficulties to bring the charge of crime of aggression in the International Criminal Court. In other words, here we might have something similar to Nuremberg, a special court by the United Nations, for example. It could be with the resolution of the United Nations. There are already a lot of supporting, over 100 countries support such resolution by the United Nations General Assembly to establish a special court on the crime of aggression. And hopefully very soon, Professor Piero Petrelli will tell us more about this later. The third option is the domestic courts in Ukraine. I would say even the first option. They already have all the evidence. The Prosecutor General Kostin has, as I heard, 120,000 cases already with evidence of war crimes committed by the Russian army on the Ukrainian territory. And this, at some point, will also be opened for, and some were already when the perpetrators were in custody in Ukraine. So obviously, I put a lot of hope for the domestic court in Ukraine to undertake a massive amount of work. Again, once the time is right for that. And finally, other courts under universal jurisdiction. We shouldn't forget that in addition to everything else, there is always kind of a last option, which is universal jurisdiction. Anybody in the world using the principles of universal jurisdiction, collecting the necessary evidence, satisfying the judges, can prosecute under universal jurisdiction of crimes. It happened several times in the past. We have also a positive story here with Hissène Habré, the former dictator of Chad, under universal jurisdiction, being finally prosecuted in the court of Senegal, and other similar situation. In Israel-Gaza, a news from, again, a few days back, is that there are serious evidence already collected about deliberate starvation of civilian populations committed by the authorities in Israel, which also constitute a war crime, and probably they will start with that because the evidence already exists. And I think it's absolutely impossible to defend because repeatedly Israeli officials denied the entry of food supplies. They blamed the United Nations Relief Agency for being infiltrated with Hamas fighters, which happened to be a complete lie, a manipulation. Those 12 UNRWA officers were never actually found with any connections to Hamas. So all these obvious lies by Israel will at the end of the day result in the charge of deliberate starvation of civilian populations, a clear war crime, and one may argue crime against humanity, but there are also other crimes. It's not difficult to prove war crimes when the military do not take enough precaution to reduce the civilian casualties, and in a fighting which produces already 35,000 victims in Gaza. Well, we don't know yet how many of these are civilians. There are probably some Hamas fighters among the same numbers that still need to be established. But no matter how many, even if half of them are Hamas fighters, and if we take 18,000, it's still a very high toll. So the war crimes committed by Israel in Gaza should be prosecuted, again, ideally by the Office of the Prosecutor in the ICC, eventually, possibly by domestic courts under universal jurisdiction. So the options are open there as well. Okay, my time is up. If there are, I can give 5 minutes of question time if somebody wants to raise or to ask something in terms of clarification, but then we should go to the next panel. Thank you very much, everyone. Good to see you, some common faces in the audience. So please, if you have questions, this is the time to ask. Any questions? Then I pass the floor back to the, oh, sorry. I see someone who wants to ask a question. Please go ahead. I'm listening, please.
So thank you, Professor Popowski, for this comprehensive and such informative keynote on the evolution and challenge of international criminal justice. Again, if someone want to ask, who is online or here physical, want to ask question to Professor Popowski, now is the moment. I would like to avoid to ask you question about the challenge in prosecuting in international crime in Israel, Palestine, and Russia, Ukraine, because I think we will talk about that during the panel. But I am really interested on your point on peace versus justice. So we have now different proposal for peace agreement, most of all in Ukraine. My question remain, do you really think that we can reach a lasting peace without justice? Or we can accept that?
Thank you, Pier Paolo. Obviously, I will say peace is the priority today because it's still ongoing conflict, both in Israel, Gaza, and in Russia and Ukraine. And it's very difficult to see how justice can be done when all those who committed the crimes are still under the shield of the power in Kremlin in Moscow, as well as in Tel Aviv in Israel. So justice needs to be done once it is possible. We are realistic, we are not naive. We have to set the ground. What I'm saying is that we need to collect the evidence, and many NGOs do that. They collect properly, scrupulously all the evidence of all war crimes committed by Israel in Gaza and by Russians in Ukraine. And that evidence one day, once the conflicts are over, will be immediately taken by the proper authority. And as we know from the past in Nuremberg and Tokyo, in Yugoslavia and Rwanda, there is a time once the peace agreement are accepted and signed, then justice comes to look back and to investigate and prosecute. And I'm sure the moment will come, but what we can do now is to collect the evidence and to be prepared legally, jurisdictionally, with capacity to start once the moment comes. Now, if you ask me about when the peace will come, it's a very difficult question, and it's probably different to address that. In a different lecture, I talked about how I see the conflict in Ukraine ending, and my position remains the same, which is that I compare this with Adolf Hitler invasions of Czechoslovakia and Poland and all other European countries. There is no difference between what Hitler did in 1939 and before and after with what Putin does in Ukraine. And the end should be the same: capitulation. Military defeat and capitulation will bring finally an outcome, which, by the way, will be the best for Russians themselves. Russians will be happier once their military lost the war and they have a different, better government and president and so on. So in terms of Gaza and Israel, it is different, obviously. Here we have victims from both sides. We have Israel army committing war crimes, and before that violating agreements and holding Palestinians in occupation and building settlements and all of that for 70 years. But also Israel has the right to self-defense, which is historically very sensitive because of the Holocaust. So I'm not going to more details here, but that conflict will be very, very difficult to solve militarily, but also politically and diplomatically. But if we talk about international criminal justice, I am very certain that it will not go unpunished. And for that matter, final word is that I would like to see reforming the institutions. I would like to see the Security Council reform. The elimination of the veto of the Security Council is the first priority of the member states. And I'm kind of tired to see, many ambassadors and many prime ministers kind of expressing complaints about the Security Council and its passivity and the veto. But why they don't gather together in New York in the General Assembly with two-thirds majority and abandon the veto? For 30 years, those ambassadors are talking about Security Council as dysfunctional, as nonsensical, and all of that. It's easy. And I wrote about this. Probably people know my latest publication. There is a way for the General Assembly with two-thirds majority in a resolution to abandon the veto and put the five into the difficult choice of either agreeing to that or isolating themselves from the rest of the world. Thank you. I'm happy to take some of those issues later in the panel.
We have another question for Professor Sobolski. Please go ahead.
I wanted to know if there is any point of actual justice before this. So if there is any point of prosecuting before any peace agreement or capitulation. Both is Gaza.
Professor Sobolski, do you hear the question?
No, can somebody tell me the question? Yes, I didn't hear. Can you speak to the microphone?
Up to the volume.
Or write it in the chat.
Can you hear me, Professor?
Ask the question and I will reply.
Yes, if Pierpaolo, if you can just tell me what the question was.
My question is if there is any point of actually justice and reading the prosecution in its demonstrator before reaching to a peace agreement or demonstration.
So, if I'm correct, the question is if we could have both. In one side, prosecution, and then reach a peace agreement in future.
Yeah, this go in parallel, you know. The peace process and the peace agents do their work. They negotiate. They, like in Israel and Gaza, we have a constant process of negotiations mediated by Egypt and Qatar, mostly to the point of the release of the refugees, attempts to reach ceasefire. Other countries, United States, United Nations, they also exercise some efforts to reach an agreement. And I think there is already kind of a pretty solid proposal on the table to have 6 months ceasefire in return for release of all remaining hostages and the return of the displaced back to their homes. If that is agreeable, probably that may happen very soon. But in the meantime, the justice agencies should do also their work. If there are war crimes and crimes against humanity committed by Israel army or by Hamas, by the way, Hamas is also violating all the rules of war. So we have here both sides, both Hamas and Israel committing war crimes and crimes against humanity. And they should also be brought to justice. As I said, the two conflicts are quite different. Russia and Ukraine is an invasion of one country to another country. And also that country, the invader commits weekly, if not daily, war crimes and threatens nuclear weapons in addition to all of that. So something which, in my opinion, even go beyond what Hitler did. Hitler even didn't threaten the weapons. What Vladimir Putin does is much worse than what Hitler did in the Second World War. So Russia and Ukraine is very different conflict and very difficult because it might take some time for the military defeat of Russia. And for that matter, I'm very disappointed with the late decision-making and delivery of weapons to Ukraine. It should have been done a year ago, not only now. Anyway, so the two processes go in parallel, but by different agencies. We shouldn't mix the two. The same agency cannot do peace and justice. As I said, you cannot expect a prosecutor, you cannot blame a prosecutor if the peace fails. Blame the peacemaker, the mediator, the peacekeeper, the peace agent, and the opposite. Thank you. Good question. Anybody else? Or actually, it's probably time for the first panel. Huh? What time are we?
We should move to the first panel, Professor Popovsky.
I'm happy to stay and talk and discuss. I'm here for the rest of the day. So yes, let's go to the first panel. And
I'm glad that you will remain with us for the other panel. So let me introduce the first panel of today's roundtable titled Geopolitical Case Study and International Justice. We will explore the legal and humanitarian perspective and challenges in the Russia-Ukraine and Israel-Hamas conflict. In this panel, each of the speakers will share their expertise and the current legal and humanitarian issue in these regions, helping us to better understand the application of international law in time of conflict and to pursuit of justice and human rights. It's my immense pleasure to introduce the first speaker of the day, Dr. Mutat Quafiche. He's an esteemed scholar and venerated practitioner of international law. He serves as an associate professor at Hebron University in Palestine, where his dedication to the study and practice of international law has significantly shaped both academic curricula and real-world application. Dr. Quabish's journey in international law is not just marked by his academic posts, but is enriched by his deep involvement with the United Nations. In his role, he navigated the complex corridor of international policymaking, contributing to the framework that aimed to balance the scale of justice globally. His story from this time include intense negotiation and rapid session that extended into the early hour of the morning, are testament to his commitment and passion for the law. At Hebron University, Dr. Quabishe took on the mantle of leadership as a former dean, where he was instrumental in pioneering an initiative that brought international legal standards to the heart of legal education in Palestine. Today, Mr. Quabishe will share his unique insight into the legal and humanitarian perspective and challenge into conflict between Israel and Hamas. His presentation will draw from his depth reservoir of knowledge and direct experiences, providing us with an announced understanding of how international law operates on the ground in this tumultuous region. Please join me in warmly welcoming Dr. Mutat Quabishe, a true advocate for justice and a beacon of knowledge in the field of international law. Please, Mutat, the floor is yours. Thanks.
Thank you. Thank you very much. And good morning to all those who are in the morning, especially those who are in Palestine, and especially also my students. I have a number of my students in the diplomacy master, as well as a number of my bachelor students in international law. And of course, I welcome all attendees in India at Jindal Global University. I had the pleasure to visit your university in 2013, and I was impressed by the arms. It is a truly very much the organizers of this amazing event, historical event that is taking place in India, one of the leading countries in the globe. I would like particularly to thank Dr. Professor Pier Paolo Petrilli, I hope I pronounced it correctly, for this opportunity. My discussion today will focus on the Gaza war, or the war on Gaza. And I would say the war on Palestine and its impact on the global legal, how international law would not be the same September 7th. So as international and after September 11th, I think international October 7th, and I will try to show how this is the new reality at the global scene. Speaker, Dr. or Professor Bobesky, regarding the Gaza-Hamas war and the title of this presentation in the program, because the fact is that this war is not between Israel and Hamas. It is a war on the Palestinian people all together. So I'm speaking from the West Bank, from Jerusalem, and we are all Palestinians, including all my students, are under attacks on daily basis by Israeli forces. You know, I live in Jerusalem and I work in Hebron. Every day when I travel to my campus to meet my students, I go through many Israeli checkpoints, and there are so many Israeli settlers in the way who are violating, attacking Palestinian cars, shooting, killing of course, in the top of confiscating land and expelling Palestinians from their neighborhoods and from their communities. So it's a war on all Palestine and all Palestinians. And all, I would say, all the 15 million Palestinians all over the world are victims of Israel. 2/3 of the Palestinians were expelled by Israel in 1948, and the remaining Palestinians, almost 1/3 of Palestinians, are undergoing daily attacks, crimes, violations by Israeli forces based on Israeli policy and supported by the international community. So in other words, I would say it is a world war against Palestine. It's not even Israeli war against Palestine, and I will try to show how this is a global war on Palestine. My other comment is on the previous speaker is the fact that Israel has the right to self-defense, and I think it is no. Israel has no right to self-defense in and within the occupied territories, and this has been decided by the International Court of Justice in its 2004 advisory opinion on the wall, particularly in paragraph 139, where the court said the occupying power has no right to self-defense in and within and against those who are occupied, because according to the law of self-defense, Article 51 of the UN Charter, the right to self-defense is legitimate when a country or a state or member of the United Nations is under attack. And in fact, is that Palestine and the Palestinians are under attack. So it is the Palestinians who have the right to self-defense and not Israel, because Israel is the aggressor, Israel is the occupying power, so the Palestinians have the right in law to self-defense. That includes the right to self-determination in all means, and this is it's part of international customary law. My third and final comment is the equation between Palestine and Israel and the so-called both sides. There are no both sides. There is only one side who is attacking, killing, murdering, committing genocide against the Palestinian people, and all Palestinians again are victims of this Israeli attack. And of course, the Gaza war is just a recent example, because but otherwise the war has been taking place for almost a century, when Great Britain decided to create a Jewish national home on the land of Palestine. So it is a land of Palestine to which the international community or the European countries, the colonial powers, decided to create a state in other lands, in other people's lands, state which is Israel. And we, the Palestinians, we accepted the state of Israel. We recognized the state of Israel in 1993 Oslo Agreement, but yet Israel is not recognizing Palestine, and yet the international community and many European Union countries, as well as, of course, the United States, are blocking the recognition of Palestine as a member of the United Nations, and the veto that was used by Israel last week is a clear example of this international hypocrisy. So let me move now to my presentation, and I will divide it into three parts. Or now it's 2 parts. I already had the introduction. The first is the particularity of the Israeli or the current war of Israel against the Palestinian people, and particularly in Gaza. The second is the change of law, of course, the politics, and therefore the law as a result of this war. And I think the emerging terminologies, legal terminology that can be thought of and discussed, of course, by the audience after my presentation. And the third, which is the core of my presentation, is the gaps in international law. So, and the need for reform. And here I will not speak about the gaps of the security system and the Security Council, but in the international law itself. And I will identify 10 fields of international law that need reform. and I think it should be reformed after probably the conclusion of this war. So let me start by the particularity of the first component of the presentation is the particularity of this war. This war of genocide is probably unprecedented at the international level for several reasons. First of all, because it is taking place on camera, like everywhere in the world, online. It's taking place online. So everybody is watching and seeing this war unfolding before our eyes. We see the systematic killing, systematic destruction, systematic displacement of the entire people, entire neighborhoods, precedented at the international level. Even Hitler, during the Second World War, did not target willfully hospitals, destroying all the entire universities, 12 universities in the Gaza Strip. All our colleagues, our students in the Gaza universities are unable now, for example, to participate in this panel, in this discussion, because all their universities and all their facilities were completely leveled by Israeli forces. Of course, using the famine, the war, the hunger as a method of war, also systematically and publicly declared by Israeli establishment, Israeli ministers, the prime minister, the minister of defense, almost, I would not say all, but the majority of the parliament member, Knesset members, all cabinet members in the Israeli government, they declare publicly that we are going to destroy the entire Gaza Strip as a first step to destroy the entire Palestinian people, which is based on a strategy, based on a policy that has been determined many, many years ago by the Zionist organization. And yet the international community, and this is the second feature of this war, I would say, okay, there were several other genocide that were taking place in various parts of the world. We have the Armenia, Bosnia, some say Ukraine, as well as Myanmar, but none of these cases were supported by the international community, by the architects of international law. Those who created international law are supporting this genocidal war in Palestine, and I think this is unprecedented at the global level. So states can be divided into three parts. Either they are participating in this genocide directly, like the United States, or indirectly by transferring arms to Israel and supporting Israel diplomatically, like United Kingdom, France, Italy, or they are just watching, of course, some of and keeping silent. Very small and tiny states who are really taking some shy steps or measures against Israel, like Brazil, Colombia yesterday or the day before, by cutting the diplomatic relations with Israel, or Turkey by suspending trade to Israel. Otherwise, most states are either participating, complicit, silent, or just doing little to nothing to end this war against the Palestinian people, and systematically against civilians, which we could say, a new term that can be created here is that we can call Palestino or Palestinicide, the elimination of the Palestinian people from the surface of the globe. So this is my first component. The second one is maybe the new crimes. Of course, we are familiar with the general war crimes against humanity, the crime of aggression, and the crime of genocide. But I think there are new crimes that are emerging and taking place in Gaza, in the Gaza Strip, and in the West Bank as well. We could talk about the idiocy, the destruction of schools, systematic destruction school. I would also add a new term, unicide, the destruction of the universities, systematic destruction of universities that I mentioned earlier. Domicide, the destruction of Palestinians' home. More than 300,000 Palestinians' homes were destroyed. More than 80% of the Palestinian of homes were destroyed in Gaza Strip. Herbicide, the urban side, the destruction of entire cities, not only neighborhoods, entire cities, erasing them completely, bulldozing them, leveling them, and taking their rubble to the sea to create the pier that will be used to so-called humanitarian assistance to Gaza. Sociocide, destroying the entire international, the entire Palestinian community, if they don't exist at all. I think this is not taking place in any any place in the world. Bedicide, which is the common name, like we know before, which is the systematic killing of children. 15,000 children killed in just a matter of in a span of 6 months. And here also I disagree with my predecessor, the previous speaker, saying that half of those killed are probably Hamas fighters, and this is not correct at all based on the statistics, because we have almost half of those killed are children, kids, infants, children in incubators. Some pregnant women killed with their babies in their while their children in their bellies. So this is not Hamas, and those kids, infants, are not Hamas fighters. What we can say, femicide, the killing of females, almost 10,000 or plus women were killed, and these are not Hamas fighters. Femicide, the destruction of our family. We say femi, with the females, and fami with families. Entire families, parents, grandparents, children, grandchildren, they are all eliminated all together with their neighbors in building full of families, erasing them completely from the civil registry. So the entire families, they don't exist at all in Gaza Strip, and I think this has not been taking place systematically in any part of the world. Of course, we can add many. The list could be much longer. We can see medicide, systematic destruction of medical institutions, hospitals, we could say ambulance side. I don't know how to say it, but it could be also emerging that is systematic destruction of ambulance, and even burying ambulance under not only the rubble but also under the mud and under the soil. Hospital side. We could say mosque side, the systematic destruction of mosque. Church side, all the 3 churches in Gaza were targeted, and some of them were destroyed completely. Electricide, the destruction of electricity. Gaza has no electricity almost at all. Agriculture side, or agricide, the destruction of Gaza, and Gaza is mainly agricultural region. So all the agricultural land has been bulldozed, destroyed almost completely. Media side, the systematic killing of journalists and media. More than, I would say, 200 or 150 journalists were killed, more than any conflict in the entire world. What we can say also, water side, animal side, killing the animals. Almost Gaza has no livestock or animal life. Gaza killing sheep, cows, chicken, and all these animals in Gaza. Even cemetery side, even destroying cemeteries. Cemeteries have not been survived in this conflict. Systematic bulldozing of those dead. So they were not survived. Museum side, destroying Palestinian municipality side, and the list go on and on. We could maybe create 50 new terms that the international community has not ever seen in the entire legal discourse at the global level. So, ladies and gentlemen, this is a conflict that is not really and has not been precedented in any part of the world before. So what would be the impact? And this is my third and probably final component of discussion. What would be the impact and the result of all this issues, crimes to the international law discourse and the discussion that needs to be addressed at the global level. As we know, and as has been also discussed correctly by my previous speaker, the world is going a process of transformation. Already when Russia attacked Ukraine, we said that the globe started, or the world started to change. Some say we are moving from unipolar system to multipolar polar system. But I think the Gaza war will accelerate that process even much, I think, quicker. So my discussion now is about the changes of the needed reform in the international law itself. And I will try to identify gaps in 10 branches or fields of international law. First of all is the human rights law, and here some of my students in international law course are joining. I would say there is a clear gap in the international law field. I worked in the international in the human rights law for over 30 years in Geneva, Beirut, and other Middle Eastern countries. And I think international law has international human rights law has witnessed unprecedented violations, and the international human rights monitoring system is unable to cope with these crises, and this shows that there is a problem in the system itself. Of course, probably the provisions of international law, the articles, the Universal Declaration, the core human rights conventions are nice pieces of words, but the system that is monitoring, so if we say the treaty bodies, if we talk about special rapporteurs, if we talk about investigation commissions, the Human Rights Council, I think all these mechanisms need to be reformed to be more effective, and to have the international human rights law system, I would say, and mechanisms to be more truly international, because now it's the machinery is dominated by the West. And I'm saying I know what I'm saying, because most of the mechanisms are controlled either by the West, the Western funded, or the Western staff who are running, of course, the politicians who are running this system, which is making it just a bureaucratic system that is unable to respond to major global crises. And even we see some complicity and some silence from certain international human rights monitoring bodies, including the High Commissioner for Human Rights, who is not speaking up clearly. And its offices, including its office in Palestine, they are not really doing what ought to be done on the ground. And the second international law is the international humanitarian law. Humanitarian law is meant to be applied during armed conflict, and we know that Geneva Conventions are applicable. And if we look at the principles of international humanitarian law, the three major principles: the principle of distinction, principle of proportionality, the principle of necessity, all these principles have been smashed, violated systematically by Israel in Gaza. And if we look at the common Article 1 of the Geneva Convention, the 4 Geneva Conventions, it is clearly saying that all states, member states, or state parties are obliged to respect and ensure respect of the Geneva Conventions in all circumstances. And what? How states are respecting or ensuring respect of the four Geneva Conventions. What the states are doing, as I said before, they are either participating, directly participating, complicit, or just watching, keeping silent so I would say here the reform is on the mechanism. Of course, the law itself is good, but the mechanisms to ensure respect of this law. There is no mechanism at all. There is no mechanism to ensure respect of international humanitarian law. Of course, we have the ICRC, but they are just okay, maybe going around taking the hostages out of Gaza, sending them to Israel, probably having some meetings, secret meetings with the Israeli army to make to ask them to be nicer when they target civilians. But of course, we have the International Criminal Court, but I will talk about International Criminal Court now. My previous speaker mentioned that we should not blame the prosecutor. No, sir. I think we need to blame the prosecutor. Of course, we blame also the system. The Rome Statute itself is giving the whole weight or putting all the burden of investigation on the prosecutor. And I think this is not logical. This is not reasonable. How one person who could be corrupted, I hope that Karim Khan will not be corrupted. I'm not accusing him to be corrupt, but if suppose that the prosecutor is corrupted, either politically or personally, the whole system will be blocked. And of course, we could see the double standards that been used by the prosecutor itself, by Karim Khan personally, how he rushed to Russia, to Ukraine, to investigate and to bring many investigators, of course, supported by more than 30 Western states to accelerate the investigation in Ukraine. And until now, he has not moved. And even before, rather than issuing arrest warrants against Israeli criminals, they are leaking some information from the court saying the court might investigate, enabling the Western countries, the United States, the Congress members, many European countries to put pressure on the court and the prosecutor to suspend their investigation in Israel. But when it came to Russia, he just issued arrest warrant against Putin and another person. So I think the system, the International Criminal Court system, needs to be reformed. Of course, in addition to the prosecutor powers, there is also a problem with the funding, because I think probably the prosecutor is not corrupt. Probably he's afraid. He's worried about the future of the court, because you know, if he starts to prosecute Israelis and probably Americans for the wars in Afghanistan, the court itself will be in jeopardy, will be at risk of collapse, because the European countries are the major donors of or funders of the court, and that might lead to the non-existence of the court itself. But that, if it is the reality, I think that should be reformed. The issue of responsibility to protect. We know the intervention, humanitarian intervention, and the responsibility to protect is a general principle. I would say a general or emerging law that emerged after the end of the Cold War, and many peace missions were deployed in various parts of the world. But this responsibility to protect and the so-called erga omnes obligations of states needs to be reconsidered again. What are these erga omnes principles? Okay, they are principles, but they are principles on paper. They are either with the jurisprudence. Of course, I wrote about erga omnes and Hughes Cogan's principles. But how these Hughes Cogan's principles and erga omnes obligations on states can be enforced. What they entail, how states can observe these obligations in effect. The Gaza war shows that erga omnes obligations do not exist in practice. Of course, they exist on paper, either in jurisprudence, sometimes in court decisions. And we saw the last decision, or the last week, or this week actually, decision by the International Court of Justice regarding the responsibility of Germany and other states with regard to arm transfer to Israel. The court stated clearly in paragraph 24 of the order that all states, including Germany, are bound under international law to refrain from exporting, transferring weapons that can be used to commit suicide or to commit genocide or war crimes or violations of Geneva Conventions. But the court did not elaborate, and it seems that there is a problem also in the mentality of the judges who are ruling, who are controlling the International Court of Justice, who are trying to be balanced, to just say compromise among themselves in order to probably to convince their conscience that we are saying something. So, but the court did not say that what these countries should do, and it refrained from issuing provisional measures to stop these states from transferring the arms to Israel. Although all judges, they know that Israel, without the support of the United States, the United Kingdom, and a number of European countries, including Germany, Israel would not be able to commit this wide-scale genocide in Gaza. So there is a need to reform the so-called responsibility to protect and the obligation of third states when it comes to major violations of international.
So,
The issue that I will try to. Okay, I will try to conclude in 2 minutes. Is it okay?
Yeah. Thank you.
Okay, in 2 minutes. The fifth or sixth component of field of international law that needs to be also reformed is the genocide law and the responsibility of states and governments in complicity of genocide, because the Gaza war showed unprecedented complicity with the state that is committing genocide. The question of universal jurisdiction as well, so which also needs to be reformed in order to enable national courts to prosecute war criminals, because until now most these attempts, I would say all these attempts to prosecute Israeli criminals has failed, mainly not for legal reasons, for political reasons, and for political interventions by governments towards their either legislators or their court, and that needs to be thought of and reformed. So just to conclude, there are several other branches of international law that can be discussed. It's just to think of the international hypocrisy. Who is violating and destroying international law and showing that international law is not worth it? It is the very creators of international law, namely the European countries, the superpowers. They are showing in practice that international law is not worth it, and international law is based on double or multi standards, and probably international law is made for some, justice for some, according to one of my colleagues in her book called Justice for Some. So what is needed? We need an international legal order that is applicable to all, without any distinction based on race, religion, region, etc. And here I think the civil society, the media, the students who are with us today, and of course the students who are demonstrating from Tokyo to Los Angeles and from Stockholm to Johannesburg, who are calling for the true international legal system And I think this process and this so-called global intifada, global revolution against the system itself, might yield a new system in the, I think I would say in the upcoming years and probably 2 decades. And thank you.
Let's extend your heartfelt thanks to Dr. Mutat Wafishe for that insightful and illuminating presentation. It's really a testimony of what are just happening right now in Palestine. He is there in Jerusalem, so he can report who better than him. Thank you so much for this testimony. I will invite now the audience here in presence and online to ask questions and take the opportunity to go more in depth.
Thank you so much for the presentation. I just wanted to ask, you had mentioned that there needs to be a more robust monitoring system for human rights across the world. What more would this system look like? How would it function? If you could give us some sense of that.
You're mute. You're mute, Professor. Still mute. We cannot hear you.
I just said, I did not hear the question. So if you can just summarize it to me, just to, because the stuff, yeah. No.
I didn't hear your question.
The sound system is not good. So if you can, Professor.
Yeah, tell me in the level.
Yes, Professor. So Professor Pakshay mentioned that there needs to be a more robust monitoring system for human rights across the world, which is not in place right now.
I can't hear the question.
So the question is about the monitoring system that you mentioned in your intervention, and he said that given that she said, given that is not implemented at the moment, how you think or you believe we can function this monitoring system? So that's the question. Yeah.
Yeah, but if the question, if the system is not functioning, I think there is something wrong in it. So and it needs to be reformed. Of course, personally, probably I used to share that opinion that the problem is not in the system itself. It's not in the law itself. Of course, definitely it is not in the law itself. But I think there is a problem in the system. The system, a new system needs to be emerged and reformed because we have been stuck in this system. If you look just at the Commission on Human Rights that has existed before the Human Rights Council, we have been discussing issues of human rights monitoring, special procedures, the treaty bodies, peacekeeping operations, the human rights violations, women rights, children rights, disability rights. Of course, we produced good instruments and good standards, but how these issues can be safeguarded and respected at the global level. Of course, I'm aware. I'm not naive to ignore that there are so many issues: economic level of development, social issues that the dysfunction make the system dysfunctioning. But I think there is also a problem in the system itself, the construction of the system, how this system is run, the control of the former colonizers of this system. And some say the international organizations entirely, not only the human rights system. and probably the humanitarian system, is run by the former colonizers. So the international system, international organizations are just, of course, this is an opinion of some of my colleagues, and the third world approaches, so-called third world approaches to international law. The entire system, international organization system, is a replacement, a new phase of colonization. So, and that needs to be discussed and reformed. I know this is shocking for some, but I think it's important to tackle.
Okay, thank you so much, Professor. Other question? We have to conclude here. If you can stay with us, Professor Wojciech, we can have other question maybe at the end of the panel.
Sure.
Okay, so let me continue, and it's with great enthusiasm that I introduce to you Dr. Giovanni Chiarini. He's a scholar whose work has significantly contributed to the field of international humanitarian law and military justice. Currently serving as a lecturer in law at the University of Huddersfield, Dr. Chiarini brings a wealth of knowledge and unique perspective to today's discussion on the complex legal and humanitarian landscape in conflict zone. Dr. Chiarini's journey in the realm of law began in Europe, where he honed his expertise in international law, focusing particularly on its application during time of war. His passion for understanding and resolving the challenges of wartime legality led him to the prestigious role of an international fellow at the National Institute of Military Justice in Washington, D.C. Here, he worked alongside other distinguished scholars to take some of the most pressing military justice issues facing the international community today. Dr. Chiarini's contributions to the academic community are extensive. His research and publication address critical issues such as treatment of prisoners of war, legal definition of combatant and non-combatant, the complexity surrounding war crime and their prosecution, etc., etc. Today, Dr. Chiarini will share his insight into the ongoing conflict in Ukraine, and I am really glad to have him here because it's a question of personal estimation that I have in front of Dr. Chiarini. So please join me in warmly welcoming Dr. Giovanni Chiarini to our panel. And Giovanni, please, the stage is yours.
Thank you very much, Dr. Petrelli. Just special thanks to all the organization of GINDA to brought about all the scholars and estimated colleagues. So I think we're running a bit out of time. And I have like 7 minutes before 2 p.m., if I'm not wrong, with the Indian time. So I'll be shortening massively my presentation and focus the attention only on one aspect of the Russian-Ukrainian war and its consequences. Could I ask the organizer if they can upload my slide, or should I just share my screen?
If you want, you can share your screen so you can control by yourself your presentation.
Could you please tell me if you can see the slide?
Yes, confirm.
All right. So one of the principal aspects of this presentation, and I'm trying to shorten in 7-8 minutes to leave the other colleagues next, Professor Crane and judges Tarfusser, Sylvan Arbia, which I personally know, and they are very esteemed colleagues. So I will leave them to the panel in 5 minutes, is essentially the environmental consequences of the war in Ukraine. Let me just summarize some of the environmental consequences. The war in Ukraine. The environmental consequences are quite massive. As you can see, there are not only air pollution, but soil pollution, ecological damage, in general, biodiversity damage, and water pollution. There are different studies, scientific studies, as I mentioned in the slide in my latest publication for the Case Western Reserve International Law Journal, that they are studying the forecasting air quality in Kyiv during the military conflict, using a special Sentinel-5P and machine learning to optimize machine learning. So this is quite evidence that then can be used eventually in a prosecution at the International Criminal Court, at least for crime against the environment, war crime against the environment. There's Article 8, Paragraph 2, Letter 4, Number B, if I remember well, of the Rome Statute. And especially the atmosphere pollution consequences of the war in Ukraine. As I said, every war in general is responsible for a high emission of greenhouse gases. This is due to the inversion of military equipment, which is dependent upon oil, even in 2024. And a study on the air pollution evolution during the first months of conflict, either performed using satellite data, showed that the nitrogen oxide and fine particulate matter correlated the most with war activities. Carbon monoxide and ozone levels increased. Should be taken into account also the modern warfare equipment, especially cluster bombs, which are sources of fine particulate matters. So one of the aspects of this presentation, and sorry I had to shorten to respect the time, is if the air pollution consequences can be potentially prosecuted at the international criminal law level. I use this slide to show, in a nutshell, if using the current definition of ecocide as proposed by the Stop Ecocide Foundation, would be suitable to prosecute environmental consequence regarding the atmosphere pollution in the war in Ukraine and after the Russian aggression. As you probably already know, the element of crimes of ecocide, and I stay in a nutshell, so I'm shortening a lot, is that any act against the environment shall be wanton or unlawful. And in this case, air pollution is the implicit result of an unlawful act, which is the crime of aggression in 2022. The damage should be severe. In this case, fine particulate matter, carbon monoxide and ozone level increased. And scientists already urge that the war involves extreme adverse change to the air. So in my opinion, the severe requirement can be fulfilled in this case, and shall be either widespread or long-term damage. In this case, we don't know about the long-term damage according to the scientific evidence available, but for sure, 100% damages to the atmosphere, to the environment after the Russian aggression is widespread, extended beyond a limited geographic area. This because it doesn't involve only Ukraine, but Germany, Poland, Czech Republic, and Romania, at least. And regarding the mens rea, of course, the knowledge could be proved from the decision to launch the aggression and to sustain the conflict. So this is another slide from a scientific study, as I mentioned in my latest publication, which is a schematic of potential mechanism for war impacts on atmospheric radical cycling. As you can see, the damage is not only to one component of the environment, but to the environment as a whole. So not only to the atmosphere, but even to the soil. And it, of course, is radial cycling. I can then send a slide to the organizer if some students are interested in deepening this topic, which I believe could be a good idea for a LLM or JD dissertation. And again, we don't have time to go in depth into the analysis of all the evidence. I'm going to conclude in a couple of minutes. Those are the short-term and long-term damage to the environment due to the Russian aggression and the ongoing conflict in Ukraine. Just to mention some, even water pollution, a shortage of water, in addition to deterioration of air quality, can fall under the definition of the short term, and several damages of the long term, according to this study, which I mentioned, it's Ratwani, the Science of Total Environment, can be identified, including biodiversity loss. One concrete example of the war in Ukraine, it's what they called, at least at the journalistic level, the biggest ecocide in Ukraine, by Brzeź-Kakova Dam. This threat to the environment involves not only the environment as a soil pollution or atmosphere pollution, but even a threat to the animals. As you said, as you see, 106,000 birds and over 20,000 wild animals were at risk of death. A massive damage to the houses and to the population as a whole, like any crime against the environment, especially ecocide, bring effect to civilian population. And here there was an image of war crime prosecutor analyzing a dolphin, because dead dolphins and actually the risk of extinction suffer by the war in Ukraine. And there was an interesting study again about the possibility of prosecuting the killing of wild animals or species under the crime of ecocide or under war crimes against the environment. I'm going to conclude. Another interesting topic will be how the investigation and the collection of evidence regarding war crime against the environment and ecocide can be carried out. And EcoDozor is an interesting experiment that allows all the civilian population to submit to the authority evidence in form of digital evidence, photo or video, in order to collect all the necessary material to investigate war crimes against the environment. The last question will be, and I think we should ask ourselves if the ICC could be the viable court for ecocide prosecution. Again, we don't have time to go in depth into all the procedural issues, but I have identified at least 7 ICC statutory law issues in the last publications that I will also share with the organizer. I've talked about it, and I proposed procedural amendments to confer to the ICC effectiveness, at least in terms of prosecution. So, Pier Paolo, I think I can conclude here and leave to the next panel, which is quite interesting.
Thank you, Giovanni, for your rigorous analysis and for shedding light on this interesting topic. I think that we will have to organize something to have more knowledge about that. For now, I will ask to the audience if there are any questions for Dr. Chiarini. Do you have a question? Please go ahead. Go ahead.
Thank you, Professor. You mentioned that Russia's war on Ukraine had many devastating environmental effects. I wanted to ask, in a case where both the countries are warring with each other, would the liability for causing environmental devastation only fall essentially on the country which could be positioned as the perpetrator and aggressor, and if the environmental effects that are caused in the context of self-defense be excused?
Well, thanks for the question. It's quite interesting. Well, you know that the environment is protected by several conventions at both international level and domestic level. I think the question is quite generic. Generically speaking, in my opinion, the environment should be protected as civilians are protected. That's why, just to give another practical example, with the National Institute of Military Justice, we just submitted a proposal to the ICC prosecutor to consider the environment as a civilian object. But yet there is a problem even of self-defense. And in the current legal framework, the Article 8, number 2, letter 4, paragraph B, which is the only war crime against the environment, has never been prosecuted at the International Criminal Court because it's quite impossible for the ICC prosecutor to prove the element of all these crimes. And any crime, any damage against the environment do not fall under the definition of this war crime if it's committed in respect of the principle of military necessity, which is another problem regarding to the environment. So we can talk a lot about it. We can probably organize, if Pierpaolo agree, a couple of hours of lecture dedicated to this massive topic, but thanks for the question, by the way.
Of course, Johan, of course we will. Other question? So I think that we can conclude panel 1, and I want to express my appreciation to your speaker. Thanks to them again to join us today. And we can move to panel 2, titled Navigating the Complexity of International Criminal Justice. So this panel will focus on the real-world application of international law in conflict situations and its role in upholding justice and accountability in the global stage. Each speaker on this panel will share their view and analysis, drawing from their extensive career in international law. So we expect a robust discussion on the evolving nature of international criminal prosecution and the ongoing effort to hold perpetrators accountable on the global stage. I have the privilege to introduce the first speaker of this panel, Judge Silvana Arbia, a distinguished figure whose contribution to the field of international criminal justice are both impactful and inspiring. At the same time, I see Judge Kuno Tarfurfer here, and hello, Judge. Judge Arbia's extensive career began with her pivotal role as a senior prosecutor at the ICTR, so the International Criminal Tribunal for Rwanda, where his prosecutorial acumen helped bring justice to the victim of the 1994 genocide. It's important to remember that this year is the 30 years from the Rwanda genocide, so it's particularly important to have a guest like Judge Silvana Arbia with us today. Today, she will be sharing his expertise in a presentation titled Rule of Law and International Justice, particularly international criminal justice as a guidance reference for navigating the overwhelming ocean of rhetoric on war and world security and peace. So please join me in warmly welcoming Judge Silvana Arbia, a true guardian of justice and an estimated educator, as she has linked us with her profound insight and rich experience. Judge Arbia, you are with us? I saw before that she was connected. Yes, I can see. Hello, Judge. Yeah, can I?
Yes.
We can see.
Hello. Hello, everyone. It's great to join you. I warmly thank you, Professor Petrelli, and your colleagues for your invitation and welcoming. And I have to commend your initiative, which help understand the urgent, very urgent need of wisdom, I would say, law and justice against stupidity, uncontrolled violence, unlawfulness, unjustness, loss of humanity. As you mentioned, 30 years ago, a genocide with about 1 million of victims was perpetrated in Rwanda. And that genocide could be avoided, but the international community failed to do so. So the best tribute I think we can pay to those victims is to act to avoid similar tragedies. This is a very important moral and legal obligation. The current conflict between the Russian Federation, the Ukraine, and between Israel and Palestine have revealed a worrying, in my view, attempt to empty global international organizations such as the UN, United Nations, International Court of Justice, the UN International Court of Justice, and also the International Criminal Court, and other institutions of similar nature, on empty their role on preserving the world peace and security. And basic principles such as prohibition of the use of force, or prohibition of use of force, is recognized as a norm of international customary law. But as we can see, is disregarded completely and violated without particular consequences. The binding nature of the United Nations Security Council resolution is questioned and denied. We have a lot of Security Council resolutions on the ongoing conflicts, but the effects today are challenged. So they challenge the effect of the binding effects of the Security Council resolution, even if taken under Chapter 7 of the United Charter. And the decision, this is a very important, sensitive question, the decisions and the orders, and all the orders of the International Court of Justice, and even the decision of the International Criminal Justice, which is an evident example, is the non-enforcement of warrant of arrest. This is troubling our thought of lawyers. And the assumption that in order not to undermine negotiation of peace agreement, so like the UN International Court of Justice should refrain from deciding whether a state has violated or not violated the International Convention on Prevention and the Punishment of Genocide. And you see, you can follow live the hearing in The Hague before the UN International Court of Justice, and some countries, they use this argument. The court should refrain, should suspend its decision and orders because this can disturb or can imply some negative impact on the negotiation for peace agreement, on the peace agreement. And even the ICC, I had some discussion on the possibility to act some mechanism to suspend investigation and prosecution, current investigation and prosecution, especially in the Palestine situation. So this is very, this situation, this assumptions is wrong, is illegal, is not acceptable, and also is showing a clear step backwards compared to the solemn and unanimous declaration of the member states of the Rome Statute at the first review conference in Kampala, where there is, at the end of the discussion on this topic, was in agenda, So is possible a conflict between the justice and peace? At the end of this discussion, the states decide that there is no conflict. Instead, justice is a fundamental building block of justice. So now the same states or the government or the same states, probably they have changed their view. They have denied value to this solemn declaration. And the adoption of the Rome Statute in 1998, establishing an international criminal court, has been urged by the need to put an end to impunity of crimes of international concern. So the problem, the central, the main problem today is how to fight impunity of heinous crimes, genocide, war crimes, crimes against humanity, aggression, in an environment where this rule of law, this legal order, just found in the United Nations Charter, and then mechanism, judicial mechanism, as the UN justice. Sorry. There is some problem. No?
Yes, I am looking to that. You can go ahead.
Yes. So impunity is recognized. The impunity is recognized as a serious threat for security, peace and security, world peace and security. So now I can assume that the intervention of the ICC, investigating and prosecuting and doing all the judicial work of this competence, how we can assume, how we can accept this assumption that this work will have a negative impact on peace processes. So this need to be discussed. They need to be discussed, and we have an instrument with a big potential. So before I was hearing the intervention of Professor Popowski, which is calling for many reforms at any level, and I have to say that I could agree on that, but reforms on international institutions like we can say UN Security Council or other institution, it takes time. So we have an instrument, which is the ICC, which is founded on the Rome Statute, which is a treaty, and can be amended more easily. So we should consider fundamentally this very important opportunity. So the Rome Statute is not perfect, we know. So we in Rome, where we discussed the conference, diplomatic conference for the creation of the ICC, everyone was aware of the problems, of the lacunas, of the needs of reform, of the integration, of modification, amelioration of the Rome Statute. We are aware of that. But the Kampala conference, the first review for the amendment of the Rome Statute, the revision of the Rome Statute, has shown, this is very important, that even some issue that we can consider impossible to define, and this was the issue, was the definition of the crime of aggression. So many states, and particularly the powerful states, were convinced that it was not yet the time to define the aggression. And they tried, they loved a lot to delay, to postpone this definition. But at the end, as you know, the states adopted the definition of the crime of aggression, and which crime is now all the conditions that were put for the entering into force of this amendment are in place. So the crime of aggression is one crime which the ICC can exercise jurisdiction with conditions that have to be met, but we have the definition and the entering into force of this amendment. Other few amendments were also adopted on some war crimes. So it's possible to amend the Rome Statute. So we are now, when we mentioned the possibility of the deferral, the Security Council, the UN Security Council, possible deferral or of possible warrant of arrest concerning the Palestine situation. So I think also this Article 16 can be discussed by the states parties and observers and other interested stakeholders and discussed and also reformulated. So one very little suggestion based on my reflection would be that if a decision, so to suspend or to delay or to an investigation or prosecution means a lot for victims, means a lot for justice, because the collection of evidence is difficult. And if we, at the time, is against the result of the investigation. So if we delay this important step of the important phase of the investigation and the prosecution, we jeopardize, we got to the, we cannot proceed, so the justice cannot be delivered. And for the victims is even more, is worse, because the victims, the expectation of the victim is that justice be delivered. And according to the experience we have got in the first decades of the functioning of the court, we have millions of victims who are protected by the court, who are participating in the proceeding, are expecting reparation. So the victims in a possible, and this is demonstrated that the intervention of the court is a serious threat for peace and world peace and security, should be demonstrated. And in the discussion on this issue, the victims should be consulted. So this is a possible, very little suggestion, not the only one, but according to the experience, personally, so I visited refugees camps in Chad and in other parts where the situation where the court were acting, and victims are demanding justice very, very hard. So this is one point that could be proposed, discussed, advanced. See, we cannot be scared by the difficulties of these reforms, because we have the proof that it is possible to achieve good reform, even earlier than expected. So the war crime, the crisis, the two crises, Ukraine and Palestine, are certainly also revealed according to the information we have. So we cannot have a look at the dossier of the Office of the Prosecutor of the ICC, but based on the general information and reports. So, and based also on the order of the UN ICJ, the possibility that genocide could be at least an attempt, because the genocide is punishable as attempt, complicity, and conspiracy to commit genocide, and public and direct instigation to commit genocide. So we have a scenario that is very worrying about the possibility that in Palestine, probably or in Ukraine, a genocide is committed or is on the early stage of attempt and could be prevented. has to be prevented, has to be punished. So the genocide has been the key, the occupation of my years, and I passed almost 9 years prosecuting the Rwandan genocide in the UN ICTR. It was not easy because for the genocide is a very serious crimes, because can be committed just by words, so by declarations. And this, if you read the decision of the UN Court of Justice, among the provisional measures that the court has ordered to Israel, there is this point. So to stop, to avoid that the authorities or most influential people in Israel make some speeches which could constitute direct and public incitement to commit genocide. And so for the genocide, the complexity of this crime is for the special doors, as you know, as everyone knows. So the crime, the conduct which constituted the material element of this crime should be committed with a special intent to destroy in part or all the group, the protected group as such. So the protected group, and for the Palestine side is in the Palestine situation, the group, the existence of distinct group which can be considered be protected by the Convention on the Prevention and Punishment of Genocide is recognized as even as for the purpose of the provisional measures, and not on the merit of the decision on the genocide, which will come later. So the intent, of course, the intent will be proved by inference. So the nature of the conduct, the modalities of the action, and especially this declaration, these speeches, these statements can be used and are very relevant to be considered for the purpose of the proof of the intentional elements. The UNICTR, as the legacy of the UNICTR, is focused on the genocide crime. We prosecuted also the war crimes and the crimes against humanity with a lot of problems. That is to say, crimes against humanity were a list, a not complete list. I remember it was very difficult. We had proof for sexual slavery, but was not. So it was just among the crimes against humanity was typically rather just the rape, but not the sexual assault, but not the sexual slavery. While in the ICC Rome Statute there is sexual slavery among the crimes against humanity. So we dealt with this later problem or bigger problem, but the legacy of the UNCTR is the issuance of the first judgment on the applying the Convention of the 1948 on the prevention and punishment of genocide. And in this judgment, in the Kayesu case, was also affirmed, the state established that also rape could constitute an act of genocide. Interesting also is the media case, because in the media case was the crime was committed through the speeches and through the broadcast on the radio, televisions, and also public speeches of the authorities. So this is also an important legacy of the ICTR. But ICTR, like ICTY, were the ad hoc tribunals. So one serious problem was the temporary limitation. So I remember that the Security Council decided that the tribunal should close and by a time limit, and so some need of justice that we and some case that we should prosecute were excluded, and so were was transmitted to other national or the residual mechanism. But as I concluded my observation and direct implication in this work was that the not having the possibility to complete our work. And this was the ad hoc tribunals. This was a very limited and narrowed experience. So, but now we have a permanent, and the other problem with the problem or what was missed, especially in the experience of the ad hoc tribunals, was the no possibility. There was no possibility for victims to participate in the proceedings and to get reparation. So this was missed, and we had a very we felt that was missed because we had witnesses on the bench of witness helping us in finding the truth and establishing proofs, but then there was no possibility for them to obtain compensation, reparation for the damages, for the harms suffered during the 1994. Now we have this more complete judicial mechanism, ICC. So where the victims play a very important role, can participate in the proceeding, can present views at a very early stage. This is very important, and this also for what I mentioned before, the need to consult victims if we should discuss a possible amendment of Article 16 of the Rome Statute. So the victims are can be heard at very early stage, even during the investigations, and are heard based on experience we have. So can participate and can obtain reparation. But most important is concerning my experience of registrar. So so the service, the functions of the registry, so the protection, and the protection of witnesses and victims. This is very hard task, I have to say. It's not easy to protect witnesses in the situation of ongoing conflict. It's very hard, and requires the cooperation of states, requires the dedication of our staff, which they have to act in the ground, so they cannot doing their services in the Hague, so they have to act in the Hague, and it's not easy. It's very risky, and that is the first action that the court, one intervenes and one situation is open. Is the first step is this, to inform the affected communities, so to doing outreach activities and to identify witnesses and victims potentially applying for considered as participant in the proceeding, and protect. So the protection can be done in different ways. So depends on the risk. So protection should also be extended to the family, or all the person who are at risk because their interaction with the court. So the protection requires, as I say, the cooperation of the states, and can in the most risky case, in the most serious case, is required the relocation of the witness, which is a process which involves some time, some difficulties for the witness themselves to move to other countries and to adapt themselves to new environment. So the protection is important. So as I said, starts at very early stage of the proceeding of the court, and cannot be stopped by an intervention of the UN Security Council ex Article 16 of Rome Statute. So these activities, even in case that a very, very strange or very unacceptable, I have to say, decision based on Article 16, I think very difficult, because the UN Security Council should justify that the ability to preserve peace and security, world peace and security, its ability is more performant than the ability of the court to preserve and the peace and global peace and justice, because we say that the impunity is a serious threat for the world security and peace. So it would be difficult, but even if it would be justified in some way, we don't know how, it's necessary the vote of 9 states and no veto. So we will see, now we are just discussing in a possible and worst scenario case, but important is to say that this problem will impact only the investigation, prosecution, but not the other services. And I mentioned just 2: outreach, protection witness and witnesses, and others, and not judicial work, I have to say, because as was clearly and without ambiguity decided in proceedings of the UNICTY in that each case, also the UN Security Council is bounded by the rule of law. It's not legibus solutus. So the rule of law today is still a reference. But this attempt that I just mentioned sporadically and without a very consistent manner, but just to give opportunities to reflect on which reform, which instrument we have to maintain the rule of law as reference for our proceedings, for our intervention, when this intervention is obliged, because we have war crimes, very serious war crimes, because we have destruction of entire population, we have situations which are not acceptable, we are shocking our human conscience. So in this case, if we lose this reference, so what will replace the rule of law? I think it's simple. Will replaced by the warlords law, and this will end, I think, the history of peoples, of humanity. So what rule of law? Because also when we mention human rights, international law of human rights. So in the case we have the genocide. Genocide is committed also in time of peace, not just in time of war. So is an erga omnes obligation to prevent and to punish. But if not, what about the Geneva Convention? What about the customary law? We mentioned also the prohibition of use of force. This is a principle of international customary law that is violated, and apparently there is no possibility to halt, to stop aggression, to stop violations of this principle. And in this case, we have the parallel situation that I mentioned for the Palestine. We have the parallel in the order of the UNICJ in the case presented by the Ukraine against the Russian Federation for the in order to get a decision, dismiss the assumption that the use of force by the Russian Federation was justified by a defense. So, in this case, also we had the provisional measures taken by the UN ICJ, which are not enforced. So the problem of the enforcement is that it need to be solved. So we mentioned before reforms and other possible amendments and so on. So this is one of the priority. If we would keep rule of law and the mechanism which guard this rule of law, which are judicial mechanism and should be independent mechanism, we need enforcement authority. We have to discuss how. What sanction to establish in the case where the status parts, and I'm just mentioned for the ICC experience, the status parts are not complying with the obligation, very clear obligation established in the Rome Statute to enforce the warrants of arrest and other orders which are fundamental for the proceedings and the success of the judicial activity. So we have at risk the reputation of an important mechanism, which is ICC, as I said, is not perfect, but can be improved and need to be improved. And we have, especially we have, is not, this is very important and need to be underlined. We don't have just a piece of paper, like we had in 2002. We have a court which in a few years has shown that can deliver judgments, deliver order for reparations, protect witnesses and victims. And this is the reality. So if you just see the figures of the results of the court's work, these figures demonstrate that what has been done is a very, very, very important amount of work for justice and for the transform this dream, you can say, to have a mechanism, permanent, independent, complementary, and close to the populations, because these social reports, we have filled the offices. We have not just the big buildings, the beautiful buildings in The Hague, in the seat of the court, but the court has also some offices in the field, so in the situation countries. And so the closeness to the affected population, to the affected communities, the dialogue that the court can engage with affected communities is a reality. I repeat, outreach programs are involved billions of people. So this is a reality. We cannot deny the importance of this experience. We have to continue, take into account that the rule of law should be preserved, and is the only guidance for the maintaining of security and peace of the world. Thank you.
Thank you so much, Giorgio Norbia, for this interesting intervention. What? I am mute. You can hear me? Mama weet je hoe dat met journey, hoe je aan het doen.
I cannot say.
I am in mute. Okay.
No, I cannot hear you.
Where is the guys? Where is? On YouTube. Can you hear me now? Can you hear me now?
Yes, okay.
No, the problem is that we are muted.
Now I can hear you,
Yes.
Professor Petrelli. Yes.
We have a voice. Anico.
No, not anymore.
Can you hear me? Am I able? Listen. Oh. It's your job. Okay. I'm not mine. Don't lie.
Can you hear us? Can you hear us now, Josh?
You can, no. No. You have to take responsibility now. Okay? Yes. And now what we can do is stop here. We can close.
Josh, can you hear us now? Hello.
Yes, guys, but please, we have to take care of this stuff. I cannot do it alone. Call Professor. Let him aware that I will interrupt the. You can imagine. This will be reported at the Vice Chancellor.
Hello, Rahul.
But, you know.
Hello. Rahul, आवाज आ रही है मेरी?
Yes, you are audible.
Okay.
So sorry for interruption, technical issue. So let's express your profound gratitude to Judge Silvana Arbia for his presentation, her presentation, and let's open the audience to the question and answer session. Please, any question? Yes, please.
In order to have a question that is
Yeah. I cannot hear you. I don't think that they can. Yes. We have no video now. During this camera.
It's an honor to have you here, Judge. I just had a small question regarding the prosecution of Russia in these cases. Yeah, I mean, immunity has been disregarded in many cases. Do you think that Russia could ever be prosecuted for these cases because it also has veto power? And due to that, I don't think the UN would give a referral for these cases. So I just wanted to know your opinion on this.
Josh, can you hear us?
There is no video, no.
Josh, can you hear us now? Hello.
They are in mute.
So are we.
Georgia, you are in mute. Can you just try to unmute?
mute as well.
We are all on mute. And I also called I have the number.
Hello. Hello. Are you here?
You can see that it's moved.
Very long.
It's unbelievable.
Cheers, I need to-
Thank you.
Hello. Hello.
वो जेब्रा माइक ले आना जल्दी जेब्रा माइक अरविंद लेगा दो
Hello. 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 कौन आ रही है बस? Hello. ठीक है.
चेक करता हूँ
We have 23 guests, are not my friends. I want to know who is the responsible of your office. Answer to this question.
Hello.
Hello, everyone. I'm sorry, but we are facing
Hello. Hello. Judge, can you hear me?
Now I can hear you. Yes.
All right, Judge, I'm very sorry. We're having a major technical glitch here. The mics aren't working, and Professor Paolo is working on it. Just give me 2 minutes and we'll get back to you.
Okay.
Is that all right? We're very
No
sorry.
worries. No worries. I can hear you.
Okay, good. Just 2 minutes, Professor. Professor Paolo is gonna be with you.
Sylvia, it's good to see you. It's been many, many years since we have chatted.
Mr. Paolo is trying to work on the mics, but I'm his research assistant. And you can start with your discussion, where we all can hear you, and we'll, in the meantime, fix the technical glitch.
Perfect. So I would like to start with a question, if I may, Judge. Please, thank you first for your amazing and insightful also presentation. It came to my mind of sort of three questions. My first question regards the point that you highlighted about the starting the collection of evidence in early stages and the clash with Article 16 of the ICC Statute. My question is what we can, as a suggestion, if you may suggest something to avoid this kind of clash or to facilitate or to help in terms of not prejudice the collection of data or the protection of evidence and victims, what we can propose as amendment, because it was one of your proposals was to amend the Article 16. What would be this amendment? That's my question. My second question is related to the enforcement. There was another point that was highlighted in your speech. It's always a matter, an issue that is highlighted in terms of public international law as a whole, not only international criminal law. What I see from ICC specifically is what you brought to us about the outreach in the field. So this planning of getting office in the field. My question is this a tendency? So ICC as a policy, internal policy sees that. Do you think that they see that as a way of enforcement? And we can see that more in the future, not relying only on the will and consent of states to performing well the prosecution and collection of evidence. Another third point, and I will finalize my questions, it's about if you may see the rules of procedure and evidence, the legislative power that ICC has by the majority of judges and the prosecutor, according to Article 51, paragraph 2, letter B and C of the ICC Statute. It may be a way somehow to create a mechanism within the procedure of ICC to enhance the prosecution, the collection of evidence, and the protection of witness. How do you see the legislative power of ICC as well? Thank you.
Thank you. Very, very interesting point. So I will start with the last question, to answer the last question, because it's the more short one. So the legislative power is the service of the ASP, or the Assembly of States Parts. So contrary to the experience of the ad hoc tribunals, where the judges establish the rules of procedure and evidence, in the ICC system is not the competence of judges to establish these rules. So this is a possible proposal, but not to establish rules. So this is very easy. But the proposal can be, and has been discussed many times that the rules of procedure and this is very heavy and complex bound of rules. So we need simplification. We need to find a way to make more easy the proceedings. And so this is a project, current project, and many studies have been already done and available. So I think that we can achieve the amendments of rules of procedure and evidence through the process that I said. So the ASP will have the power to make a final decision on that. On the how we could imagine amending the Article 16 of the Rome Statute. This is very difficult point. So the issues. So we have many aspects, many difficulties, and we have to solve on the legal aspect. So we have an ICC, which is an independent court. It's not an UN court. It's an independent court, and as an agreement, as signed an agreement with the UN, with the United Nations, for relationship, cooperations, and what is necessary to permit this court to act consistently with the purposes of the United Nations, which are fundamentally the how to ensure or avoid a serious threat to world security and peace, and how to ensure the effective protection of human rights. And the ICC, the way the ICC preserves this or can ensure ways to avoid this serious threat to security and peace, world security and peace, is to fight effectively against the impunity. This is the very important purposes of the court's mandate. And I mentioned that very, just to start a discussion on the possible amendment of this Article 16 would be starting by the fact that the court is an independent institution, so as a mandate which is perfectly consistent with the guarantees and with the purposes of the United Nations. And during the investigations, the court has to consider and is considering the interests of the victims. So when the prosecutor will decide how to advance his proceeding, could be the prosecution phase, the interests of the victims need to be considered. And so even for the issues of the warrants of arrest, the interest of the victims or the investigation itself. So when the prosecutor decides to open an investigation, to request for an authorization to open an investigation when the is acting proprio motu, the interest of the victims need to be considered. So the investigation should not jeopardize or put at risk or causing negative impact on the interest of the victims. So at this stage, the consultation, because I say that the victims can intervene, can start participating at very early stage of the proceedings of the court. So the consultation will be a way, a soft way probably, but a way to reinforce what would be this safeguard of the interest of the victims at that stage, and could also help the Security Council to open its door to a modern administration of this role of guardian of world peace and security, in allowing the contribution or the views, especially the views and the views of who are the directly affected by this threat of peace and security, these damages of wars and aggression, and what is the illegal criminal action of states and individuals. So the consultation is, in the experience, especially during my mandate in the ICC, the consultation is very fruitful. It's very interesting because it brings views, suggestions which comes from the concrete experience, concrete sufferings, the concrete miss of or needs of the victims and the affected community. This is just to mention as a first step, but my view, my vision, my hope, my wish will be that the United Nations Security Council will be more, will act more consistently, because when you see a referral to the ICC of situation like Darfur, South Sudan, and Libya, and then not ensuring the necessary cooperation, the necessary support to the ICC in getting, the enforcement of the decision, this is something that they need to be considered for the future function of the UN Security Council, unless we would accept that this UN Security Council is useless, because even its resolution, its binding effect of its resolution today is challenged. So this is something that needs to be done between the UN Security Council, UN and the UN Security Council in particular, ICC, with the consultation of representative. We will see what will be the way of the affected communities, affected populations. So the enforcement enforcement is a big issue. I said it could really empty the role of the justice that the ICC possibility to deliver justice, because if we can not enforce. So on this also we can find ways. Depends on the decision that the ACP will take on the basis of the suggestion of the court, the consultation with the civil society, because the civil society plays a very important role on the advancement of this project of international criminal justice. So, but to be very, to take easily, we can say, for example, warrants of arrest not enforced, you cannot proceed with the subsequent stage of the proceedings before the court. So if we decide, if we states parties to the Rome Statute, we could find a solution. We could also opt for the modify this necessary presence of the accused at trial. So the trial in absentia is a taboo. So if the warrant offers is not enforced, we can't proceed with the trial in absentia. So as been discussed, it's not a fresh issue. It's been considered, discussed, but so far this necessity of the presence of the accused at trial remains like at the moment at the time of the creation of the court, because is a cultural, judicial tradition which has prevailed in Rome and is still prevailing in the discussion of the SSP, but could be find a solution of that with the arrangement which will satisfy the countries who are come from a tradition that requires the presence of the accused. But also, what has been done, a lot of work to avoid that the non-enforcement depends on the inability of the requested state to enforce, because as not at national level is not a disposal ways and instruments to enforce the decision and orders of the ICC. And so this has been done a lot of work. So the implementing legislation project. So we have also toolkit helping the states to create at national level all the necessary instruments enabling the state and the national jurisdiction to implement, to enforce the decision of the court. Then unwilling states, this is the most difficult situation when the state has the possibility to enforce, but it has no the political willingness to do so. In this case, we have we are very weak because the ICC Rome Statute has not established the effective sanctions where in the case that the state is not willing to enforce, so to violating his obligation. And we have just the possibility for the judges of the court to refer this violation to the Assembly of States Parties. So I think it's not an appropriate sanction. And this also will be matter of amendment for amendment of the Rome Statute. So this part where we have very clear obligation to enforce, especially for this matter and warrants of arrest and other important decisions, but we don't have in the system the possibility to make a real pressure on the states with the perspective of sanctions, which can, encourage or anyway convince the national authorities to enforce. So yeah, this different situation, inability, willingness, or change some, make some arrangements that in order to give the ICC the possibility to proceed. So I mentioned trial in absentia, but also other ways, and it could be at the end of the deep discussion, I think, if the willingness is there, the willingness to solve these issues there, the solution, the legal solution, is easy to be found. So important is this, but more important is that in these two crises, so we have the Ukraine and Palestine, where the impression is the common impression, I'm a lawyer, but if you see the common people, the perception is that these courts and these tribunals are completely without any possibility to hurt or to have a deterrent effect. So, and the situation remains until one of the parts in conflict will win or will be defeated. So this is very risky, because it's a rule of law problem. So imagine a world for the future generation, for you, a world where there is no, binding rule. It's just, I mentioned the provocative sense as the rule of the warlords. This will be. So this is a momentum, very risky for
I'm sorry.
But we have to act.
Maybe we was able to fix this technical problem, so we can proceed. Sorry, Judge Appiah, if I interrupt you. If you want to conclude, please go ahead.
I concluded with my answer.
Okay. So we can actually move to the next guest, next speaker, Judge Kuno Fusser, that was here, but I cannot see him now connected. If he's not here, we will proceed with Professor Crane, and then we will give we will come back to Judge Fusser. I think he's not here. So let me introduce Professor David Crane, that is a distinguished figure whose career has been defined by his unwavering commitment to justice and human rights. A former chief prosecutor of the Special Court for Sierra Leone, Professor Crane work led to the prosecution and conviction of those responsible for serious violation of international law, including the historical indictment of the sitting African head of state, President Charles Taylor. Professor Crane's contribution extends beyond the courtroom. He is an acclaimed scholar and educator, having served as a professor at the Syracuse University College of Law, where he founded Impunity Watch, an online publication that reports on human rights violation and impunity around the world. I met Professor Crane at Case Western Reserve University during some conference where he participated, and it's a really honor for me to have him here. And I have to give him a special thanks, because right now in the United States are 6 a.m., I believe, and he wake up at 5 a.m. just to join us. And he also faced the technical issue, so I apologize for that. Professor Peng, you can hear me?
I can, and good morning, good afternoon.
Sorry again, and thank you so much to be here in early morning, early hour in New York. Thank you for joining us today, and we look forward to your presentation.
Well, thank you, and it's a pleasure to be with you today. And this is a very important conference and a very important time, a very tumultuous time, a time where we really haven't seen something like this since the late 1930s, where the world's democracies face authoritarianism and aggression around the world. In fact, we even have another axis of evil with the Russian Federation, Iran, and North Korea, and even China, who are looking at the democracies around the world straight in the eye and saying, we dare you to do something. And so at this point in time, we must do something, and we can maybe talk more about that during question and answers. But the bottom line is that we are living in times I think that 2024 is as important a year as 1938 was just before World War II. The decisions we make this year will impact the geopolitical arc of the rest of this century, and it can be a very bleak one or one of hope and promise under the rule of law. You know, I come to these issues, particularly dealing with international crimes and facing down these authoritarian figures, as obviously someone who's been doing this for almost 30 years, someone who has been looking at and taking down heads of state and authoritarian figures for violations of international crimes and bringing unrest around the world. So even though I had been a professor of law, really at the end of the day, I am a practitioner in international criminal law, one of the founders of modern international criminal law. And so when I speak, I come to you as truly a practitioner, someone who has been there, who has tasted, touched, felt, and saw the horror of atrocity in atrocity zones around the world, from West Africa to Syria, to Venezuela, to Ukraine. These are areas that I have been very much involved in over the past decades. And so, you know, my comments as the founding chief prosecutor of the UN Special Court for Sierra Leone are just that, the practical realities of seeking justice for victims. Let's put all of this in context, as I think it's very important. You know, since 1945, when we began to look at the world in a different way, hopefully to suppress aggression and to seek international peace and security, you know, the United Nations was formed, but also, as importantly, in the first wave of atrocity accountability, we saw the establishment of the International Military Tribunal at Nuremberg, but also the International Military Tribunal in Tokyo, where for the first time the world paused and thought perhaps we might want to use the rule of law to hold individuals who commit atrocities accountable. So I call this the first wave of accountability, and there are a couple more coming up. But then right after the first wave of accountability, we see the Cold War happen. And over a period of over 40 years, the world was in a death grip of potential thermonuclear war, where the world really subtly, but most assuredly, saw the destruction of over 90 million human beings. You know, the Cold War, there were more people that were killed at the hands of their own governments and elsewhere than World War II and World War I combined, because the policy of the West and frankly of the Soviet Union was, you know, as long as you're on our side, as long as you support what we're asking you to support, such as capitalism and democracy, or the other way around, communism, we'll let you do whatever you want within your own borders. And so the world kind of looked the other way. And so we saw atrocities going around the world, South Asia, Southeast Asia, Middle East, as well as, and very particularly in South America and Central America. So it was a pretty bleak and dark time during the Cold War. And as the Iron Curtain fell and the world began to come together again, we see a very unique thing happen. And this is the second wave of accountability, what I call the age of accountability, where the world looked around, saw various atrocities happening in Yugoslavia, in Rwanda, in Sierra Leone, in Cambodia, and said, we need to do something about that. And so they created the world's first major tribunals. And then throughout this 1990s, we saw the world coming together in Rome and creating the world's first permanent international tribunal, and that is the International Criminal Court. And so the age of accountability began, and we developed, I think, very importantly, the jurisprudence, the proper rules of procedure and evidence, and with all of that, a deep bench, as we say, relating to experience. We have very experienced individuals who, in the prosecution, we have experienced judges, we have experienced registrars and supporting personnel to take on the next tyrant with another tribunal, if that be necessary. So we developed a great deal over a period of about 20 years during the age of accountability, the second wave of accountability. in facing the future. So I think that that is something to be hopeful. But much to my surprise, and much to the surprise of the world, around 2015, as the major tribunals in Rwanda, Yugoslavia, Sierra Leone, what have you, began to wind down their work, we see a rise of nationalism, of looking inward, of throwing away the mantle of using the international community to solve disputes, the UN paradigm of settling disputes peacefully and only resorting to force as a last resort. We see the rise of what I call the third wave of accountability, and that is amazingly the age of the strongmen, where we now have dictators and tyrants and thugs in power, using the power of nationalism to look inward and to solve their problems, not using the UN paradigm. And this is a very, very perilous time, and we are pretty much in that right now, as I said in my opening comments, related to the 2024 being a very, very important year. So you have three waves of accountability. You have the initial phase wave at Nuremberg and Tokyo. You have the second wave, the age of accountability, from about 1993 to 2015. And then around 2015, you see nationalism grow around the world began to kind of split apart a bit, and it became a little much more unsettled. And that is the third wave of accountability, which we're in, and that is the age of the strong man. And we see the world turning away from the rule of law and the international paradigm that we created since 1993 with the various tribunals and courts, and not using them in any way, shape, or form to seek stability. However, during the second invasion of Ukraine in 2022, despite all of this looking the other way related to international crimes, we do see, in fact, the world turn to the International Criminal Court and also begin to consider other modalities related to the crime of aggression, a special tribunal for Ukraine on the crime of aggression backed by the UN General Assembly, or potentially a member state created multinational court for the crime of aggression for Ukraine, efforts of which I'm very much involved in and would be glad to chat with you at the question and answer period. So those are the ways of accountability. And what we've seen now since the turn of the century, we see these dirty little wars around the world where parties have really ignored international humanitarian law and have conducted their combat in a way that steps away from the Geneva Conventions, the Hague Rules, and various other treaties and protocols, which protect civilians, prisoners of war, and the wounded and sick. And so these dirty little wars have really perpetrated a lot of atrocity, and we've had very little accountability related to that. And right now, we're right in the middle of several conflicts in Sudan, in Israel-Hamas war, as well as the Russian invasion of Ukraine, where we see very little respect for protecting civilians, for the rule of law on the battlefield, what we call the laws of armed conflict. And so the question is, should they be held accountable? And the answer is, of course. But again, that is a political decision, which leads me to really my last portion of my remarks today, coming to you from an actual practitioner of international criminal law as the chief prosecutor. You know, when you're prosecuting, there are several things you have to think about and consider, and something that you need to be thinking about as you listen to the distinguished speakers today. But really, at the end of the day, the bright red thread of creating a tribunal to account for atrocity is politics. It's not a legal decision to create a tribunal. We can deal with that. We can do that. We can create these tribunals. In fact, I believe that you have most likely been given the package which we put together for President Zelensky to create a UN General Assembly-backed special tribunal for Ukraine, and the 7 steps of creating an accountability for aggression. We can do that, and hopefully that you'll get copies of that through the sponsors here. But at the end of the day, it's a political decision to create a tribunal or court. So my point is that when you are dealing with atrocity, international crimes, politics with a small p are very much involved in this. And I think that you have to consider that, and we'll talk about that. So when you're dealing with these dirty little wars, you're dealing with the strife around the world, what kind of considerations do you need to think about when you are going to prosecute for violations of international criminal law? The first one, obviously, is legal. That's the one that you would think would be the appropriate consideration. In other words, what is the law related to? What are the violations? What's the appropriate jurisdiction related, given through the statute that creates the courts, et cetera? And so you always have to consider the statute which helps create whatever tribunal or court that you are using. And so the legal aspects are somewhat easy to understand, but I think that really the more important avenues for a successful prosecution, upholding the rule of law and a fair and open trial, is the politics that I talked about. In fact, you must understand and think about the political ramifications of what you are doing in the particular region that you are dealing with. And so it is a naive chief prosecutor who ignores the political and diplomatic ramifications of what they're doing. And so I had to be thinking very much about when I was in West Africa and looking very closely at President Charles Taylor, the president of Liberia, and his henchmen who had destroyed over 1.2 million human beings over a 10-year period. I had to think about what are the political and diplomatic ramifications of indicting and prosecuting a sitting head of state. And that's something that we are considering even today as we are looking very closely at prosecuting President Putin for the crime of aggression. And I'm sure that something that my colleagues at the International Criminal Court are thinking as they move forward in further investigations of Putin for war crimes and crimes against humanity with the ICC. So what are the political and diplomatic ramifications of moving into an atrocity zone and investigating, indicting, and prosecuting individuals who for a period of years or decades have really been the rule of law in that region? And that was very much the way it was in West Africa. So you have to make sure that you are consulting, listening to the perspectives of all the regional players, the local players within the region. And in West Africa, I developed relationships with all the presidents, foreign ministers, ministers of justice of about 90% of the countries in West Africa, to the point where I could pick up the phone and talk to them and get their perspectives of what should be done. Not seeking any kind of favor or any kind of influence. That's, of course, unethical, but just listening, showing them the respect, getting their political and diplomatic perspectives related to prosecuting in atrocity zone. I think this is important. So, we're talking about prosecutorial considerations, the legal aspects, of course, the political aspects of this, and the third one being, of course, the diplomatic ramifications. It's interesting. You have to be very careful. Diplomats don't like when an international tribunal shows up and begins its investigation, because it upsets the apple cart, so to speak, as we say in the United States. It really disrupts the normal give and take and flow of diplomacy. And so you have to understand that and think about, as you're developing your prosecution plan for an atrocity zone, that the diplomats may or may not be supportive of your work, and they're more interested in peace rather than justice. And so when you move into an atrocity zone, you have to understand that and work that issue and develop relationships with the various key players within the region and internationally, as well as locally, diplomats who can be of assistance to you related in you working your prosecutorial plan. Another aspect, a prosecutorial aspect and consideration, and I used all of these when I was chief prosecutor in West Africa, is just what's the practical aspects of moving into an area that hasn't seen very little rule of law, very little justice, and develop a plan, use your plan. But what is the practical aspects of doing all of that and ensuring that you're not stepping on toes of the victims, of local politicians, national civil societies, what have you? So when I was in West Africa, I developed the world's first outreach program and had town hall meetings around the country and the region, going out, listening to the people of the region and telling me what took place there, what's going on, what their thoughts are, what their concerns are. And I did that for three years, walking the countryside, ensuring the practical application of what my prosecutorial plan was doing was working, and asking them what are their concerns, what have you, what can I fix, what can be done. What that does is create buy-in for the victims and the people who have suffered greatly in your atrocity zone. And so these are the considerations that, of course, we have to consider. Now, another one, and one that has never been considered other than my time in West Africa, is the cultural aspects of prosecution. In other words, you have to ask yourself this question. And I think we have to be humble when we move in from the international community into an atrocity zone. We have to understand this question. Is the justice we seek, the international community, and read that white man's justice, is the justice we seek the justice they want? You know, when I was in West Africa, you know, they have a justice system, paramount chief system, that's been around for centuries, one of which they understand justice. But is the justice that I've been mandated to use in order to account for atrocity, but again, is that justice for them? So again, this is where the town hall program was very, very important, is I would listen to that very question. Is the justice that I am seeking on behalf of my mandate your concept of justice? Is the justice we seek the justice they want? Because at the end of the day, I think we really have to understand this and use this always as a cornerstone for atrocity accountability from Yugoslavia, Rwanda, Sierra Leone, Cambodia, as well as Sudan and in Ukraine and other places. We have to understand that really the creation of a tribunal or a court or going in and seeking justice for an atrocity is the victims. This is for and about the victims. That's what we do this for. And I think it's really, really critical that we are humble enough to make sure that we are always ensuring that we are seeking justice for the victims of the atrocity, because they're the ones that need to reassert and feel comfortable with the concept of truly the rule of law. And as I told the people of Sierra Leone as I walked the countryside, I always told them that the law is fair, that no one is above the law, and that the rule of law is more powerful than the rule of the gun. And I said, you know, don't believe what I say to you, believe what I do. And so I would go back and ask them, how am I doing? What are your concerns related to that? But again, I showed the victims the respect that they certainly deserved related to my prosecution plan in Sierra Leone. So these are the practical prosecutorial considerations in implementing your mandate, implementing your plan, is the legal considerations, the political considerations, diplomatic considerations, the practical aspects of your prosecution plan, and just as importantly, the cultural considerations related to, is the justice we seek, the justice they want. I'll close with a little vignette, and I have many vignettes, but I think it's important because it shows the tie-in related to seeking justice for victims of atrocity and the unique aspects of prosecuting violations of international crimes. I used to travel around the countryside, and I always went by the Milton Margai School for the Blind in Freetown, Sierra Leone, where I was headquartered. And I think this is also kind of a side note, is that I think one of the reasons for the success of the Special Court for Sierra Leone is we were in the atrocity zone, very much like Nuremberg. We were right there with all the victims, all the horror, every day reminded us of the importance of seeking justice for the victims. So I was getting ready to leave after 3 years as chief prosecutor and say goodbye to the Milton Margai School of the Blind. And I had been meeting with them every quarter for 3 straight years. And as I always did, I always brought candy and soft drinks, something that was very rare in that part of the world, and they were delighted to have that. Some of them would come and sit on my lap while we were sitting and chatting and holding a town hall meeting. And as I went by and I got to the point where I was so comfortable with them, they called me Uncle Dave. So as I was saying goodbye to them, and we were sitting around sipping Coca-Cola and eating a candy bar, they said, Uncle Dave, we have something for you before you leave. they had this wonderful choir that sang, and they've even sang at Westminster Abbey for the late Queen Elizabeth. And so they sang me a wonderful song, It's a Small World After All. So with that, I'll conclude my remarks, and I look forward to the remarks of my colleagues, but also then question and answers. Thank you very much.
Thank you, Professor Brain, for this presentation. And please, who have questions? We have a lot of questions for this panel now. Let's start. Professor Popovsky. Let's start with Professor Popovsky.
Thank you very much, Dave. By the way, very nice to see you after 20 years when we met in The Hague working on the book on children's rights and international criminal law with the Institute of Social Science.
It's good to see. It is good to see you, my friend. You haven't changed at all.
And thank you for the brilliant expose that you did. And also, I enjoy your tie with yellow and blue. It reminds the Ukrainian flag. So very good to see.
Slava Ukraini. Slava Ukraini.
Slava Ukraine. So my question is really, we have an interesting choices to make. As you said, there could be a special court on the crime of aggression of Russia against Ukraine. We have already an arrest warrant against Vladimir Putin issued by Karim Khan in the International Criminal Court. But there are also more than 120 cases filed with the General Prosecutor Kostin in Kiev. So the choices are basically 3 or even 4 if we add to that one possible universal jurisdiction in any other country in Europe or elsewhere. So in a way, Nuremberg prosecuted all 3 crimes, the crime against peace, war crimes, and crimes against humanity. But in the case of Russia, Ukraine, those may end up in 3 or even 4 or more courts. One will be the existing ICC, following on the war crimes committed by Russians in Ukraine. Separately, we have a court on the crime of aggression assembled by the member states, United Nations General Assembly, or a coalition of states. And in addition to that, we have domestic courts in Ukraine also prosecuting war. I see nothing wrong, by the way. In fact, I don't see that as fragmentation. I will rather prefer such variety and diversity as for no crime to be left unpunished. But in your experience in Sierra Leone and elsewhere, what are the advantages and disadvantages possibly of such multiple courts taking on the Russian crimes in Ukraine? Thank you.
Well, the disadvantage is, just quite frankly, is doing nothing. That's the disadvantage. That's the horror story. That's the 1938 scenario. That's the next world war happening because we did nothing. But we are doing something. I think really the fact that we have various modalities to deal with atrocities is a good thing. It shows the flexibility of the rule of law and the ability of the international community to adjust according to circumstance. There is no black and white aspect of international criminal law. There is no black and white in the law at all. And we know this as practitioners. The bottom line is we have to deal with the circumstances as they are. So you're very correct. We have obviously the domestic system in Ukraine and the domestic systems in Europe appropriately dealing with these individuals who've committed violations of Ukrainian law or whatever domestic law within the European continent. That's fine. I think that's appropriate. That does not diminish any other types of modalities to include the International Criminal Court. The International Criminal Court is our cornerstone court. but sometimes they have the inability to deal with particular circumstances, and that's the perfect example of the crime of aggression this time around. Perhaps in the next 4 or 5 years, we can amend the Rome Statute where we can make appropriate adjustments to avoid the situation that we are in now, so that we have to create either a special tribunal for Ukraine on the crime of aggression, or another thing that we are putting together is a member state, UN member state created multinational court, which takes it out of the UNGA political bloc. Because again, as I said, it's a political decision to create a tribunal. And right now, even though there is general admiration for the idea of a UNGA special tribunal, we can't pass the 2/3 threshold right now. And you can't lose in a resolution at the General Assembly. Because again, the General Assembly can only recommend to the Secretary General that he consider entering into a bilateral agreement with Ukraine to create that special tribunal. But there's not enough political interest right now. And the reason why is simply the fact that the Israeli-Hamas war has taken all the political air out of the room, and everybody's looked elsewhere. I mean, particularly in the United States, there is very little discussion about what's going on in Ukraine. It's gone off the headlines in the newspapers. No one talks about Ukraine, other than recently related to the U.S. backing Ukraine as far as military aid, what have you. So that's, really at the end of the day, Putin understands this. Time and distraction are Putin's ultimate weapons. He knows that if he waits us out, we may just wander off. And it happened. And you remember this. It happened in Syria. I was very much involved in creating a case against Assad and his henchmen. I'm the co-author of the Caesar Report with Sir Desmond de Silva, showing crimes against humanity that he had perpetrated. And the bottom line is the world became distracted, moved on, and so the justice for over 500,000 victims in Syria isn't going to happen because there's no political interest. The distraction and the time moved on. And so Assad, in large measure, has been rehabilitated. And that is a tragedy. And my concern is we're going to see the same thing in Ukraine. But to get to your final point is the fact that we're doing various ways of seeking justice for victims of atrocity shows the power, the ability, and the flexibility of the international criminal law system to adjust to circumstances to deal with justice for the victims. So I appreciate your comments and your question.
Thank you very much, Dave. In fact, I share this disappointment, and in a similar way, I'm advocating for a 2/3 majority in the General Assembly to amend the United Nations Charter and to eliminate the veto. And that also doesn't gather enough support, although, again, we are trying hard to make that and to revise the UN Charter and to change the Security Council. That could be even more difficult than to adopt a resolution to establish a GA court on the crime of aggression. Thank you once again.
My pleasure. Other questions?
Yes. Can I add one thing, one moment, because I'm interested to this argument. So, and this linked also with the speech of Judge Orbia. I can agree with the establishment of a special court for avoiding impunity on this specific case. But at the same time, as Judge Orbia argued, we have a permanent court today. So even if I think that even if we amend the Rome Statute, will not have a retroactive effect, and so will not be applicable at the situation at hand, the same state that demonstrate this willing to create a special tribunal should ratify the Rome Statute, should ratify the Kampala Amendment, and to give support to the ICC, because we cannot just putting on the side the ICC and have a special tribunal for a special case, and then if the same state that will establish this tribunal will commit aggression, the ICC will not have jurisdiction, and we know that it's not so easy to establish a tribunal because, as you say, Professor Craig, it's a political decision, it's not a legal decision. So we want for real have another kind of Nuremberg. I think the story is changed today from 1945. What is your opinion?
Well, again, the International Criminal Court is a permanent court, and it has jurisdiction over crimes, the gravest of crimes. But that's just it. It has jurisdiction over the gravest of crimes, and it should be that. In other words, it should deal with the most grave situations and violations of international criminal law. But it's not a cookie cutter approach, and sometimes the International Criminal Court, for whatever political or legal considerations, cannot deal with a particular atrocity. And of course, we know this with the second invasion of Ukraine in 2022, and so we have to deal with the aggression as it is, not as we would like it to be, and have the International Criminal Court deal with that. Perhaps someday that will happen, but at the end of the day, we do have to establish some kind of accountability mechanism, either through a special tribunal or a multinational court, to hold President Putin accountable personally for his aggression. And we have to hold President Putin accountable because, again, he is the individual who started the whole situation based on his whatever he wants to see happen, for whatever motives he has started this. So we have to hold President Putin accountable in whatever justice mechanism that we use. And so that creating tribunals and courts outside the Rome paradigm are not signs of weakness or signs of confusion or signs of lack of respect for the International Criminal Court. We just have to deal with the situation as it is, not as we would like it to be. And there are now, and there will be in the future, times where the International Criminal Court can't or won't deal with the situation because, again, they can't prosecute every atrocity crime going around the world, and so that we may need to fall upon. In fact, the whole concept of states parties is that they should prosecute the violations of international criminal law and their domestic law, and that the International Criminal Court supports them and do it. That's kind of the cornerstone of the whole Rome paradigm. The states parties deal with it, and then the International Criminal Court itself deals with the most gravest of crimes. So I think that the fact that we are thinking about creating a special tribunal or a multinational court is not an indication of any kind of weakness or concern related to the International Criminal Court. We just have to deal with the situation as it is. So again, I appreciate your comments and your thoughts. They kind of dovetail with the previous commentary, but at the end of the day, we have to deal with the world as it is. We have to deal with the aggression perpetrated by Vladimir Putin, and we have to create a justice mechanism to hold him personally accountable. And as the prosecutor versus Taylor, prosecutor me versus Charles Taylor, we have shown the world, and that the Special Court for Sierra Leone Appellate Division has shown that a head of state is no longer immune through head of state immunity for international crimes that head of state commits while being head of state. So that's really, really critical, is that we now have the ability to take on heads of state who commit international crimes. But again, thank you for your comment.
Okay, we have another question.
Thanks, Professor Kane, for that really insightful talk. Whenever I teach my students about the special courts of Sierra Leone, we refer to your work in great depth. And one thing that I can't help notice as a conflict arises between the special court and the Truth and Reconciliation Committee that was set up in Sierra Leone, especially in terms of primacy and jurisdiction over detainees. So purely from a prosecutorial angle, my question is, how highly or how vital do you think history and truth are in the prosecution of international crimes? And secondly, if you think there exists a hierarchy between prosecutorial organs or judicial organs and organs that are designated to finding truth and perhaps setting up legal history. Now, thank you very much.
Great question, great comments. Indeed, we had the privilege of having a Truth Commission and an international justice mechanism working together. And most of the world, when I was putting together my prosecution plan, stated that they'll never get along, that this won't work. You can't have a Truth Commission doing its work and an international investigation doing its work. Well, I understood that, but at the end of the day, before I went to Sierra Leone in July of 2002, I announced to the world that I would not use, and this was the big concern, is I would take all the materials that the Truth Commission had gathered and use it in my prosecution. I announced to the world that I would use no facts or evidence that the Truth Commission was compiling to seek the truth through their Truth Commission, and that I support the Truth Commission and wanted to work closely with the Truth Commission to ensure that we're working together. Because at the end of the day, as I told the world, truth plus justice equals sustainable peace. Let me tell you that again. Truth, TRC, Truth Commission, plus justice, international mechanism, equals sustainable peace. And that's exactly what happened in Sierra Leone, is that they have a sustainable peace since the creation of the court. I worked very hard. One of my best friends was the chairman of the TRC, Bishop Humper, and I announced on 1 December of 2002, publicly, standing underneath the famous cotton tree, which unfortunately no longer exists, and announced to the world that the Truth Commission of Sierra Leone and the International War Crimes Tribunal in West Africa, called the Special Court for Sierra Leone, were going to work together, and we did for a year and a half, and the TRC published its report, and we moved on. So we showed the world that the Truth Commissions and international criminal international courts can work together in seeking justice and truth for the victims. There is no hierarchy in this business. Again, it goes back to the thing that I had mentioned earlier, is that we don't do this for power. We don't do this for personal gain. We don't do this for anything other than, and we should only do this for the victims. So however we can seek the truth, seek justice for them, then that is the best way to do it. So there is no hierarchy. So I appreciate your comments. Thank you very much.
Thank you very much, Professor. On to the next question. Professor, it's great to hear from you. I just had a small question regarding the tribunals that you talked about. Weren't we?
I'm sorry. I'm having trouble hearing you. If you could speak a little louder, thank you.
Sure. I was saying, as you mentioned the topic about the tribunal itself, I had a question. Wouldn't bringing in the tribunal in Russia also not a way that's there right now because of the ex facto rule that is present? So maybe there for the future problems that might occur in Ukraine rather than now. So what are the precautions that we can take for the Russia and Ukraine war that's been going on?
I apologize. I could not understand what you were asking me, and I guess that's more my problem than yours. So if someone could rephrase the question.
So if I understood, the student asked if this could create a precedent for them with another tribunal also in Ukraine.
Related to Ukraine or what?
Yeah, I think that she had a little bit of confusion. So she wants to know if creating this special tribunal today for Ukraine will create a precedent for the establishment of a similar tribunal also in the future.
Well, anytime you do something in law, it establishes precedent, and there's nothing wrong with that. There's nothing wrong with creating justice mechanisms in whatever way that's appropriate, again, to seek justice for the victims. And so if the justice for the victims is through the International Criminal Court, that's important. But again, they're set up to prosecute the gravest of crimes. But in those dirty little wars that I was talking to you about, sometimes they're not within the appropriate jurisdiction of the ICC, and so they have to be dealt with regionally or domestically, or perhaps with another international tribunal to deal with the situation. So it's not a bad precedent at all. In fact, it's encouraged that we do these kind of things, and that we found that the model for the Special Court for Sierra Leone, which I created back in 2002, is really kind of the model by which we prosecute future atrocities if the International Criminal Court does not have the capacity to do so. Because, really, at the end of the day, the International Criminal Court jumps in to deal with atrocities when a state's party is unwilling or unable to prosecute, then the International Criminal Court or the international community can create a justice mechanism by which they can deal with the situation in that country or that region. So the precedent is already there, and the precedent is a good one. But thank you for your comments.
Thank you, Professor. We have a slew of questions coming up, so please bear with us. We're going to the next question.
Professor, can you hear me?
Are you talking to me? I can hear you well. I can hear you fairly well.
My question was pertaining to your perspective as a chief prosecutor in a special court regarding the recent rumors that are circulating around pertaining to issuance of arrest warrants against Benjamin Netanyahu, and how certain media outlets are claiming that in order for ICC to issue effective arrest warrants, they require the United States support. And I wanted to know your perspective about it, because in my opinion, I feel like requiring support from a non-state party to the Rome Statute kind of changes people's perception about the court's reputation being an independent tribunal. So I wanted to get your perspective about this.
Well, that's a great question. It's also a very interesting question, and maybe even a dangerous question. You know, again, any nation of the world who commits international crimes or allegedly commits international crimes should be held accountable for that. And certainly, all the parties. You know, this is a classic example of a dirty little war where both parties are ignoring the basic tenet that civilians should always be protected, and that a civilian can never be intentionally targeted during a conflict. And it certainly appears that the state of Israel is violating that principle and therefore is committing war crimes and crimes against humanity. There should be an appropriate investigation, an appropriate consideration by the appropriate body to consider whether those are international crimes and should be dealt with. And so, you know, if you're the prosecutor of the International Criminal Court, you have to look at the world as it is, and you have to deal with it as it is. The fact that the United States might not support that, in my thinking, if I was prosecutor, and I certainly had that problem in West Africa, really the United States was dead set against most of everything that I did dealing with Charles Taylor. They did not want him to be prosecuted or, you know, indicted, investigated, and prosecuted. They finally came around to supporting that, but they were very angry with me and when I took Charles Taylor down in June of 2003. So, you know, the bottom line is you have to deal with the rule of law and not what other countries think you should do. And so I know that Kareem Khan, my colleague and friend, will do the right thing and consider the facts and the law and make appropriate decisions. But certainly, President Netanyahu has certainly opened himself up for criminal consideration as the way he has prosecuted the conflict in that part of the world in Gaza. And so I would support a movement forward in an appropriate investigation to find the facts and decide whether the law has been broken, regardless of what anybody thinks. Because as a chief prosecutor myself, I didn't care what people thought as far as what I should do with seeking justice for victims. I was more interested in getting their input, looking at the facts and the law, and seeking justice for them. So, you know, those are and these are my considered personal opinions, but I think Netanyahu has really opened himself up for criminal liability, to be sure.
Hello, Professor. Am I audible? Professor, am I audible?
I'm sorry. Are you asking me a question? I can hear you, but I'm not sure what you're.
Professor, am I audible? Can you hear me?
I can.
First of all, thank you for interacting with us, Professor. It's an honor to have you here. My question is, with regards to the two cases that have gone to the ICJ over the past few years, which is Ukraine, which is Russia, and South Africa, which is Israel. We've seen both the parties to such cases clearly violate the provisional measures that have been ordered by the court. we've seen the US comment that Resolution 2728, which is passed by the Security Council, and call it a non-binding resolution at large. And we've seen Russia and Israel both call out the United Nations while blatantly disrespecting its jurisdiction. On the other hand, we've seen other countries intervene in such cases and uphold the jurisdiction of the UN and call upon it to act in such cases. So my question here is: are we seeing a direct confrontation between the international order at large and the power of the few superpower states? And if that is the case, do we see a scenario where the international order does come out as a winner, unlike the previous cases, for example, the Nicaragua judgment or the Chinese response to the PCA judgment in Philippines versus China?
Well, as I've said, we're in a very tumultuous time, very tenuous time. We have confrontations where could cook off into world conflagration. World War III looms dark in the horizon. We have the world's three powers, the United States, Russia, and China, who are not parties to the Rome Statute, who are outside the paradigm which seeks justice for victims, is a real problem, a real challenge. We don't see any, even though the United States tends to now cooperate with the International Criminal Court, we see very little cooperation between China and Russia, two authoritarian governments who have really, in some ways, are now starting to step away from the UN paradigm. Certainly, Russia has done that, and China is also testing the limits of what is going on. So, you know, again, when you have the cornerstone International Criminal Court, the cornerstone concepts of the age of accountability that put together the process by which we hold individuals who commit international crimes accountable for those crimes, we have to stand firm, we have to support, we have to move forward. It's not perfect because, again, at the end of the day, as I've told you, the bright red thread of accountability and creating courts is political and politics, of which you have to consider and work with. It's not the perfect situation, but you have to, again, hold to the rule of law and hold to the principle that the rule of law is more powerful than the rule of the gun. And those who pick up the gun need to be held accountable for that, regardless of how powerful they are, or regardless of what their position is related to the ICC or what have you, because at the end of the day, the rule of law does in fact show the victims and the world that it is the way by which we govern ourselves. That's why we have to stand firm before this axis of evil with the Russian Federation, Iran, North Korea, and even China, and show them that the rule of law is more powerful than the rule of the gun, and that we have to stand firm and hold accountable those heads of state who stress and test and spread their wings, trying to step away from the United Nations paradigm for their own nationalistic purposes, which is a very scary time, as we say, as I've said, in the third wave of accountability. We are currently in the age of the strongman. So that's why I keep stressing it is so critical, so important that the world hold Vladimir Putin accountable for his aggression against Ukraine, because if we don't, then the rest of the strongmen around the world who are watching like crocodiles will now begin to move forward. And we could see North Korea invade South Korea. We could see China take Taiwan. We see the Ayatollah in Iran flexing his muscle and attacking directly Israel and other nations that they feel that they need to do that. So it would become a very unsettled world indeed. And the question I need to pose for you before I've finished all my remarks today, and I've really enjoyed this, is if we don't do this, then why have a United Nations? The United Nations was set up to deal and prevent aggression. So if the United Nations does not have or cannot get together and deal with the aggression, the question is begged, why do we need a United Nations? And so we have to show the world united that those who commit aggression in any way, shape, or form have to be held accountable.
Professor King, just the last question that comes from the virtual participants. And this the Academy, the Academy of African Development. So the question comes from the Académie africaine de la pratique du droit international, from the Secretary General, and she asked, I have a question about substantial international criminal law. There is an important ongoing debate among professionals about the qualification of genocide in Ukraine and in Palestine. Do you have an opinion in this matter?
Well, I do. It's interesting, and I've been asked this question many times, and it's one that we have to consider. The crime of genocide is what we call a specific intent crime. You have to show a specific intent to destroy peoples in whole or in part. In some ways, you have to have a smoking gun. Looking at it practically as a former chief prosecutor, I have to have evidence to show that a head of state or someone who controls the military direct those organizations to destroy in whole or in part a particular peoples. And so that, genocide is a very difficult crime to prove because you need to have that evidence. And so in this particular time, there certainly seems to be a willingness by the parties to, through mass destruction, affect the battlefield. So using mass destruction as a tool by which they submit, they cause their enemy to submit. That's kind of medieval kind of approach. Just mass destruction in order to win a conflict is something that they did back in Rome, the time that they did things in the Holy Roman Empire and the battles in Europe and what have you. That's inappropriate. Whether it rises to a genocide or not, again, you have to have that smoking gun, that direction to destroy the Palestinian people in whole or in part. And certainly one can argue that seems to be the impression, but certainly they're using a tool of mass destruction, as is Vladimir Putin as well. So, the facts will bear out as the conflicts continue. One could certainly argue that there appears to be an intent to destroy in whole or in part, but I'm not sure that, and we certainly have to continue to investigate and consider that, and also incitement to genocide is also an aspect of that that needs to be looked at. So again, it's just bad policy to intentionally target civilians, period, whether it be genocide or war crimes or crimes against humanity, because I think it's really important, and I'll finish my comments with this, is we don't have a tiered system in international criminal law. In other words, war crimes, crimes against humanity, genocide, and aggression. There's no number one, there's no number two, there's no number three, there's no number four. 50,000 people who are destroyed by a party don't care whether it's a genocide, a crime against humanity, or war crime, what have you. It is still a crime, and so that we have to be very careful. And this is where the diplomatic and political aspects of prosecutorial considerations comes into play. Is you have to make sure that the politicians and diplomats understand it doesn't matter what the crime is, it matters that we do something about it. So I think that that's really critical. There's no tiered system. And so just because we may not be able to prove genocide doesn't mean anything. It's still an international crime and it has to be accounted for.
Please join me in extending your deepest gratitude to Professor David Crane for his compelling presentation. Thank you very much, Professor Crane, for your invaluable contribution to this panel and for your enduring effort and in advance the cause of justice around the world. Thank you so much.
Thank you very much.
Okay, so now we can move to the panel 3, titled Understanding and Prosecuting the Crime of Aggression. This panel will delve into specific aspects of international criminal law, focusing on legal nuances and challenging on prosecuting crime of aggression. We have two invaluable guests today, speaker on this topic. Let me introduce both of them and then I will give them the floor. The first, I have the honor to introduce Professor Astrid Reiser-Corsini, a prominent scholar whose work has profoundly impacted the field of international criminal law, particularly in the realm of the crime of aggression and international jurisdiction. Astrid serves as faculty member at the University of Salzburg, where her teaching and research focus on the nuanced intersection of international law with a keen interest in how legal standards are applied in complex global conflict. Her expertise span across critical analysis of international treaty and the role of international court in enforcing legal norms against state and non-state actors alike. Her scholarly contribution include a host of respected publications that have been cited widely for their depth and clarity on issues such as jurisdictional challenge faced by international courts and the evolving jurisprudence of the ICC. Thank you, Professor Corsini, to be here with us, to join us today. The next one, the second guest of this panel, and I am pleased to welcome is Dr. Kerry McDougall, a leading scholar and lecturer at the University of Melbourne, who has made significant contribution to the field of international criminal law with a particular focus on the crime of aggression. Her work is renewed for in-depth and precision, especially in analyzing the intricacy of aggression under international law. Her expertise extends to examine how aggression is defined and prosecuted in international forums, making her a pivotal figure in debate concerning the evolution and application of this critical area of international law. Together, our estimated panelists will guide us through the evolving landscape of international law it's related to the crime of aggression, discussing both theoretical framework and practical application. So let's embark in this journey and let's start with Professor Corsini. It's your floor, please.
Yes, thank you very much for this kind introduction. Is the sound okay?
Yeah.
Okay. Okay, wonderful. I do not really see the participants in the list of participants. So I'm talking a little bit into the void, but I understand they are sitting in classrooms, if I'm not mistaken from the discussion just before. So our panel, and I'm extremely happy to be on the panel with Kerry McDougall. In a way, we are going to distribute our task in accordance with Article 5, Paragraph 2 of the Rome Statute that was adopted at the Rome Conference in 1998, when the crime of aggression was accepted as falling within the jurisdiction of the ICC. But the exercise of jurisdiction was delayed until a time a provision would be adopted defining the crime and setting out the conditions for the exercise of its jurisdiction. And what we are going to do is I will cover the first part of that provision that was eventually been taken in Kampala in 2010 at the first review conference. So I'm going to talk about the definition of the crime of aggression, and then Kerry will concentrate on the conditions for the exercise of jurisdiction and jurisdiction more broadly. So we will probably, our presentations will complement each other. Now, talking about the definition of the crime of aggression, and I was asked to explore a little bit the development of the crime. We have already heard from Professor Crane references to Nuremberg, of course, where aggression was one of the main crimes at the time called the supreme crime, not because we had a hierarchy in international criminal law, but because of the focus on the prosecution dealing with the crime of aggression as the circumstances that in fact allowed the commission of the other crimes. But we could take a step back. And if we think of what the crime of aggression is, it's individual criminal responsibility for the unlawful use of force. And for me personally, I have three defining moments in this development. And one would be even before Nuremberg, and probably many of you have heard of this example that is often being brought, at the end of the First World War and the Versailles Peace Treaty that arraigned Kaiser Wilhelm II of Germany for a supreme crime, a supreme offense against international morality and the sanctity of treaties. Now, this is a very imprecise definition of a crime, and one wonders what the sanctity of treaty or international morality at the time would entail. But we are talking about a time when there was no general restriction of the use of force in international law. So one could not really establish a crime that violated such norms because the norms didn't exist under general international law. But what was given at the time were bilateral and multilateral treaties that Germany was a part of that guaranteed the neutrality of Belgium, for instance. So we have certain non-aggression pacts and treaties guaranteeing neutrality that enshrined a certain prohibition of the use of force, a very specific prohibition of the use of force. So when we're talking about a supreme offense against the sanctity of treaties, in that context, we are talking very much about a specific, not universal, but specific use of force. But at a time where a general norm under international law had not yet developed. Now, the second point in time, I think, that is relevant is exactly the end of World War II and the definition of the crime of aggression at the time, crimes against peace, in the Charter of the International Military Tribunal, but also in the Charter of the Tokyo Tribunal. And international law has changed to some extent because in the interwar period, there were not only attempts to define what an aggressor means, but we also had the Kellogg-Briand Pact in 1928, which outlawed the use of force as a means of international politics. So what we had under general international law was a prohibition to use force against other states. So we have the norm under international law prohibiting force in general terms at the time. I think you will all be aware of the discussion that, of course, the Kellogg-Briand Pact did not create any norm with regards to individual criminal responsibility. And this was one of the major discussions accompanying the Nuremberg and Tokyo trials, the question of whether also a crime had developed at the time of the beginning of the Second World War. But probably the theory that was most compelling at the time, and you can see hints to that in the judgment of Nuremberg, was not so much to prove that a criminal norm has developed, but rather that there was a clear violation of international law and a general principle that grave breaches of international law would also entail individual criminal responsibility has developed in the meantime. So we are taking a step in the development of the use of force, the use in bello, from the end of the First World War to the end of the Second World War, but not yet a very clear codified definition of the crime until the charters after the outbreak of the two world wars. Now, the third instance that I think is of relevance, and I'm getting closer to our current understanding of the crime of aggression, is of course the definition that was adopted in Kampala in 2010. And this is a definition that was adopted in the framework of developing the Rome Statute of the International Criminal Court, but it has impact beyond that. You may know that the working group that worked on defining this definition was not only constituted of states parties to the Rome Statute, but it was a special working group, special in terms of being open to all states on equal footing. So we had states parties as well as non-states parties to the Rome Statute negotiating the definition of the crime of aggression. And one of the objectives that was voiced during the negotiations was also to codify customary international law, the customary definition of the crime of aggression. So coming back to the underlying norm under international law, the prohibition of the use of force, we have had major developments after the Second World War with the creation of the United Nations, with the adoption of the Charter of the United Nations, and a very broad prohibition of the use of force that was enshrined in Article 2.4 of the UN Charter. Now, if you spin the development further in a way that I had tried to outline it, one could argue, well, the underlying norm of international law has changed. We are developing from partial prohibitions of the use of force at the time of the First World War to a general prohibition of the aggressive wars in the Kellogg-Briand Pact, to a much broader general prohibition to use and threat armed force after the Second World War. So one could also argue that, well, if the definition that was enshrined in the Versailles Peace Treaty reflected the prohibition norm at the time, and if the Nuremberg and Tokyo definitions of crimes against peace reflected the state of prohibited use of force at the time of the outbreak of the Second World War, one could try to argue, well, now we have a very broad prohibition of the use of force, and accordingly, this also needs to be criminalized, because whatever is an unlawful use of force could also entail in international individual criminal responsibility. Now, this way has not been taken. And if you look at Article 8 bis of the Rome Statute, it does not entail the whole scope of protection of the prohibition of the use of force. Threats to use force are not covered. There also needs to be an armed use of force, and most importantly, not even every act of aggression that is being defined under Article 8 bis entails criminal responsibility. We have the so-called threshold clause that foresees that only acts of aggression that by their character, gravity, and scale constitute a manifest violation of the UN Charter should entail individual criminal responsibility within the system of the Rome Statute. So we are talking about acts of aggression that are arguably already the most serious violations of the prohibition of the use of force, and then not even all acts of aggression, but only specific acts of aggression, those which also constitute a manifest violation of the UN Charter, could be prosecuted before the ICC in terms of the definition. Now, if we have a look at Article 8 bis and the different elements of the crimes, we can distinguish at least three different elements. We are talking about the individual conduct. which describes what an individual needs to do, how an individual needs to participate in an act of aggression by an entity, by a state, in order to be criminally responsible. We have the so-called leadership clause, which is part of the definition of the crime in Article 8 bis. Not everybody can commit the crime of aggression. Only qualified perpetrators can commit the crime of aggression. And the definition that you find in the Rome Statute is those persons that are in a position to effectively direct or control the military or political actions of a state. So we are looking for persons that are very high up in the hierarchy of a state, those that can really take the decision to bring a state to war. And there was quite some discussion in the special working group on the crime of aggression, but also before that the aim was really to exclude foot soldier from needing to carry criminal responsibility for an act of aggression, the outbreak of which they were not able to influence. And the third element of the crime of aggression, this is the most contentious one, is the underlying act of state, the collective act. What type of the use of force is relevant, needs to be proven in order to establish individual criminal responsibility. And the way Article 8 bis proceeds is, first of all, to use the terminology of an act of aggression, which is the terminology that you also find in Chapter 7 of the Charter of the United Nations, which is frequently referred to as being the most serious use of force, the most serious violation of the prohibition of the use of force. And it defines acts of aggression in accordance with a General Assembly resolution, that is GA Resolution 3314 from 1974. And it is defined in a general way. An act of aggression is the unlawful use of force, and so on, very closely drafted also to Article 2.4, the general prohibition of the use of force, but it's tighter in that it does not include threats, for instance. And then the Resolution 3314, and this is taken one-to-one into Article 8 bis, also provides a list of acts that in any case constitute an act of aggression. So the drafters of Article 8 bis took an existing definition that stems from a General Assembly resolution. So you could argue that per se in itself, it might not be binding because it's only a recommendation. Actually, it was meant to be a recommendation to the Security Council to help the Security Council establish acts of aggression in their implementation of Chapter 7. But we do have a court judgment, the judgment of the International Court of Justice in the Nicaragua case, that accepted that one of the acts listed in this list of acts reflects customary international law. And that is the one that was most discussed and was most rejected, the sending of armed bands or groups. So you could argue in a way, well, if the most disputed act in this definition reflects customary international law, one could bring the argument that the entire definition of an act of aggression that you find in Resolution 3314 might reflect customary international law. So this is the basis for defining the underlying act of state, the underlying act of aggression. And then, as I already said, the second part of the collective element is the threshold clause that limits individual criminal responsibility. So the Rome Statute leaves the general definition of an act of aggression intact, but takes a decision not to prosecute all those acts. Now, you can find two explanations of that in the literature, and these were also the main strands of argumentation that was present in the negotiations. One was that one might accept that the use of force, the law on the use of force, has developed with after the Second World War, with the introduction of the UN Charter and the general prohibition of the use of force, but that this did not influence the criminal norm of what constitutes a crime under international law. And for that, the authority would still be the definitions of crimes against peace in the Tokyo and Nuremberg Charter, and they refer in particular to wars of aggression. So there was one argument that an act of aggression might be a broader term than war of aggression, and because of that, if we use the terminology of an act of aggression, criminality also needs to be limited in order not to broaden the criminality beyond what is generally understood as customary international law. The second argument that you could bring is that with developments in the underlying norm of international law, with changes in the law on the use of force, this also influences, of course, the criminal norm. And there was a parallel development, and as I said before, maybe one could even argue that all violations of the prohibition of the use of force could lead to individual criminal responsibility. If you follow that argument, then the justification for a threshold clause would be more a policy one. It's a general policy of criminal law under national as well as international law that criminal law is the last resort. We very often use the Latin phrase of ultima ratio, that you would not prosecute everything, but only the most severe cases. So the threshold clause, therefore, either reflects the restrictions of the criminal norm under customary international law, or can be considered as a policy element to restrict individual criminal responsibility. In both cases, in any case, the threshold clause is one of the defining elements that needs to be observed. Now, maybe just one point at the end, because the question of non-state actors has come up. So if you read the definition, it's extremely state-centric. All the definition of an act of aggression always uses the use of force of one state against another state. The list of examples uses the armed forces of one state against the armed forces of another state, and so on. So you find the notion of state very often in the definition. The only part where the definition as such deals with non-state actors is the last point of the examples that are already mentioned, the sending of armed groups and bands. But it's not as such a responsibility of those individuals or groups, but it's again the sending of a state of such actors is the decisive element to establish an act of aggression. So even in that case, the underlying act is linked to the action of a state. And also in the definition of individual criminal responsibility, the leadership clause does not go as far as to demand that the perpetrator needs to be a state organ, but it needs to be in a possibility to direct or control the actions of a state. So you have several ties to statehood in the definition. And at the time that was done on purpose, there were a few attempts after 9/11 to possibly broaden the definition to maybe include non-state actors as entities that might also be able to commit acts of aggression and thus incur individual criminal responsibility for the crime of aggression. But this was not generally as accepted during the negotiations. So it was left out. So in a way, the definition remains very conservative in that regard, or in both regards, with regards to non-state actors, but also with regard to the level of criminalization, which is extremely tight and very confined. And I would close with that to leave time for Kerry. And then I think, if I understand correctly, we come back in questions and answers. Thank you very much.
Thank you for this comprehensive presentation and clear. I am impressed on the way that in so short time was able to explain in a so clear way the issue under the definition and the evolution under the definition of aggression. I know that you have to leave for another conference, so I would ask just you one question that is in regard with the definition, because as you well explained, we have two parts in Article 8 bis. Paragraph 1 and paragraph 2. Paragraph 1 is, you explained very well the three elements: the individual conduct, the leadership requirement, and the manifest threshold. And I think that I want your opinion on that. On that, the only one that can be a little bit problematic is the manifest threshold in a case where the use of force is not against the territorial integrity or political independence of a state, and we go in the gray area of aggression, as we call it. But I think that this with doctrine and jurisprudence could be fixed, this criticism, because we talk about humanitarian intervention, now it's too long, but we have the way to sustain, to argue that in any case humanitarian intervention is unlawful. The major issues, in my opinion, and this is my second question, is about the list of acts, because my knowledge is majority of scholars sustain that the list of acts is closed. So some crime, like cybercrime, would be excluded. I am not of this idea. What is your opinion? I think that also this is not a limit under the definition of crime of aggression.
Yes. So with regard to the threshold clause, I think it's if you go back to the elements of the definition, you can trace back even the language to other texts. So the individual conduct comes directly from the Nuremberg Charter. The definition of the act of aggression comes from General Assembly Resolution 3314. The really new part is the threshold clause in terms of language. I don't think it's new in terms of contents, but because it was really meant as a compromise to link the term act of aggression to an arguably more narrow understanding of the criminal norm of a war of aggression. So the contents is not new, but the formulation of the threshold clause includes a new wording. It was never formulated in that way. So I don't think it's overly vague, but as you said, new text needs jurisprudence. I think most legal system don't only have the crime of bodily harm, but also of severe bodily harm. And unless you have judges that deal with the question of what means severe, it's a term that you could argue is vague, but it will be filled with jurisprudence. And for me, this is the same with regard to the threshold clause. So not new in terms of contents, but the formulation certainly is one that will profit from jurisprudence. with regard to the list of acts, yeah, no, I do not think it's a closed list. You have the general definition there, and that makes it rather clear that what follows are examples, and other acts that might fulfill the general definition could also be understood as acts of aggression. If I may bring an example from the national level, for instance, Austria, when Austria implemented the crime of aggression into its national code, and the Czech Republic, for instance, also went the same way, they did not include the list of acts. The list of acts was included as an explanation or a point of reference in order how to interpret the general definition. But for the criminal norm, we only use the general definition and do not include those examples. But certainly there have been different views on the question of closed, open, and in the end, I think the term that was used as a compromise language was the semi-open list. But you do have a number of states, in particular Latin American states, that have a very strict understanding of the principle of legality, and they argued that such a list could not be open under their understanding. But other states have a different understanding of that. So I think as long as an act fits within the general definition, you can argue that also other acts could fulfill the elements of the crime of aggression.
Thank you so much. So I'm sure that we have other questions. However, if you have to leave, we understand and we know that you have.
Yeah. Well, I can still be here for some time, but if you want to give Carrie the floor first, I'm just listening.
Another question, please.
Thank you, Professor, for your notes. I just wanted to ask, because you had mentioned that the definition of acts of aggression does not include non-state actors, and you refer to it as a conservative definition on this regard. Is it beneficial to expand the definition to non-state actors when the crime of terrorism already exists?
I think I mainly understood the question. Please correct me if I got something wrong with regard to non-state actors. So I don't see any will or tendency at the moment to change the definition of the crime of aggression in order to open it up to non-state actors. In a way, you could say that the attempts to adopt a comprehensive definition on terrorism would be the equivalent to the use of force by non-state actors. It took almost 100 years to arrive at the definition. So the focus was really state action and acts of state, the use of force by states. So I don't see this anytime soon that the definition would be changed to open up to the use of force by non-state actors.
But would expanding the definition have any benefits?
I did not understand it.
I'm sorry. I need to ask, would expanding the definition of acts of aggression to non-state actors have any benefits?
I'm not sure I get it. So the definition, the acts that we have.
The question is, would it be beneficial to extend the definition of act of aggression also to non-state actors?
Okay, so sorry, I understand now. Well, beneficial, you would have a broader scope of protection. because different uses of force could be covered by the definition. But I think the state of customary international law is certainly not going as far as to include non-state actors. Then you could argue we could also go further with regards to treaty law, but there's just no appetite. For me, the crime of aggression, this was one of the difficulties in the negotiation of this crime, was exactly because it was concentrated on an act of state. Also, other crimes can be committed by state officials, for instance, but there's a broad application also to non-state actors. In some way, this concentration on non-state actors also helped in defining them, or made it easier to adopt those definitions. And this was certainly one of the difficult parts with regard to the crime of aggression, because it was understood as states-centric and going to the very core of the decision-making of a state that made it so difficult to be defined. So I think for me, any attempt to reopen the definition is certainly a dangerous path. So I think beneficial. I think states have quite an interest to punish persons, non-state actors, to use force against them. So the need, I think, is probably more limited to having an international criminal court being able to prosecute this. And the focus should really be on that use of force where states are rather reluctant to prosecute. And this is exactly the case when we have state aggression.
Thank you so much. Other questions? Briefly, because Professor Darren.
Hello. Thank you, Professor, for your explanation on the crime of aggression. I wanted to know if, according to the definition, it wouldn't be really easy to politicize the definition or the words of the definition, especially when we talk about the manifest violation of the UN Charter, in the context of, as it has been raised, humanitarian intervention when they are not legitimate.
Yeah, so I think there are still some scholars out there that would argue for the lawfulness of a humanitarian intervention. They're certainly a minority. I'm not one of those. So for me, I'm like to prefer to strictly apply the Charter of the United Nations and the two exceptions that you find in the Charter, which are self-defense or collective action on the basis of Security Council authorization. So for me, humanitarian law is certainly an unlawful use of force. But one purpose of the threshold clause was in a way to exclude some areas of unlawful use of force if there is sufficient arguments or uncertainty with regard to the legality of the use of force. So in Kampala and also in the time before, this was one of the main questions with regards to the threshold clause. And you might be aware of the so-called understandings that were also adopted together with the definition of the crime of aggression in Kampala. And one of them is more specific with regards to the threshold, that at least two of the three elements that are being mentioned need to be there. And we have two quantitative elements, one qualitative element. And the argument that is usually brought that at least one qualitative and one quantitative element probably needs to be there. Whether we really still have a discussion, a genuine dispute over the lawfulness of a humanitarian intervention, I would rather doubt it. If you accept that, then the arguments could be brought that the threshold clause excludes the criminality of humanitarian interventions, even if there are strong arguments to say that they are unlawful. So I think one of the scholars that probably goes deepest into that question is Klaus Kress, who shaped the notion of the gray area. I'm not so much I'm less I'm less open to the idea of a gray area, because for me, if you have a norm that is even considered to be jus cogens, and you want to create additional exceptions from that, you need more than just a few states and some state practice. So why we would not just consider those as violations of the norm, but allow a genuine discourse that might influence the criminality, I'm not so convinced. But the policy behind the threshold clause was certainly to exclude such cases where the unlawfulness might be disputed.
Thank you.
Okay, thank you so much, Professor Taram. We will leave you Professor Persin. We will leave you free. I was thinking at the next panel.
Thank you very much.
Free to go to your commitment, and thanks to joining us and for your participation at this event. That's so important and relevant. I think that we can move to the second esteemed speaker for this panel. If I understood, now we will move to the jurisdiction over the crime of aggression, and this will be the presentation of Dr. Carrie McDougall. Please, the floor is yours, Carrie.
Thanks very much, Pipaolo. I have not been given permission within Zoom to share my screen, so if someone could just enable that.
Yes, give me 1 minute.
Thank you. So while getting ready to share slides, let me just say thank you. That it's a real pleasure to be here with you, hosting. As an aggression scholar, really wonderful to be talking about these accountability issues.
I'm sorry to interrupt you. You can share your screen now.
Thank you. Wonderful to be, talking about these aggression issues in India. India is, of course, not yet an ICC state party, but it has, of course, played a really critical role in shaping a lot of the rules that we're talking about today. So if I've clicked all the right buttons, can I just confirm that you can see the slides?
Yeah. Yes, we can see.
Yep, great. Thank you. Also wonderful, of course, to be sharing a panel with renowned aggression expert and my good friend, Astrid. So she has, of course, already painted a really clear picture of the definition of the crime of aggression. And as she indicated, I'm now going to talk to you a little bit more about jurisdiction. So I want to briefly mention some of the challenges to any exercise of domestic jurisdiction over the crime of aggression before turning to the ICC's jurisdiction. But what I really want to focus on is the proposed amendment of the conditions governing the ICC's jurisdiction over the crime to bring it into line with the court's jurisdiction over genocide, crimes against humanity, and war crimes. So let's start with domestic jurisdiction. The first point to make is that, states can uncontroversially prosecute their own nationals for aggression. And now almost 80 states have something that approximates at least the crime of aggression, crimes against peace, I should say, on the books. But of course, it's likely only in the context of a government's overthrow that scenario is a likely one. The question of whether a state can prosecute a national of another state for the crime of aggression is more complicated. It's widely agreed that a crime of aggression is committed on the territory of both the aggressor and the victim state. And so that means that victim states will undoubtedly have territorial jurisdiction. The position of third states, though, is less clear. Some states assert something that is close to the protective principle, although that's never been judicially tested. At least 18 states assert universal jurisdiction over the crime of aggression, and that is consistent with things like Princeton Principles on Universal Jurisdiction and Lord Millet's judgment in the famous Pinochet case. But aggression scholars are divided on the issue, and more often than not, the crime of aggression is missing from the list of crimes said to attract universal jurisdiction in more general works. Sorry, I've got this terrible cough, so I'm going to just put for a minute and have a sip of water. Sorry about that. They're not mentioned in those judgments in the arrest warrants case, and identify crimes that attract universal jurisdiction. And I can tell you, based on my first-hand experience, that it's not a crime referred to in the context of the General Assembly's annual debates on universal jurisdiction. Even when jurisdiction exists, the prosecution of any foreign state national is likely to be fraught. First and foremost, you're going to run into the issue of immunities. So you're probably well familiar with the fact that the ICJ in the arrest warrants case made it clear that at least head of state, head of government, and foreign minister will have immunity from criminal proceedings in foreign jurisdictions for their time in office for both official and private acts, even when accused of serious international crimes. Now, it has been argued that while the Troika enjoy personal immunity, there is an exception to functional immunity for serious international crimes, meaning that the Troika could be prosecuted after leaving office. Sorry. And that others who meet the leadership qualifier would not be able to claim functional immunity. And there is support for that view in the ILC's draft articles for immunity, on officials from foreign criminal jurisdiction. But while the ILC has concluded that functional immunity doesn't apply to certain international crimes, it omitted the crime of aggression from that list. And while the ILC recently called for state views on this, the submissions made by states are actually divided on this issue. So, I mean, you might be able to argue that an exception to functional immunity for the crime of aggression is in the process of crystallizing, but I think it's difficult to maintain a claim that it reflects existing customary international law. Other challenges will include the fact that domestic proceedings are inevitably going to be charged with criticisms that it's victor's justice or maybe victim's revenge. And at least, for my money, I actually think it's really undesirable to have national courts that in all likelihood will lack expertise, making decisions about which is such a such a significant part of international law in relation to which states have such strong vested interests. And so all of these challenges with domestic prosecutions mean that the ICC's jurisdiction over the crime of aggression is actually particularly critical. But as you likely already know, the ICC's jurisdiction over aggression is severely curtailed compared to its jurisdiction over other crimes. So to put this in context, the full-scale invasion of Ukraine by Russia in February 22 gave rise almost immediately to allegations that crimes of aggression are being committed against Ukraine. And of course, as we've already heard today, while the ICC has jurisdiction over other crimes as a result of Ukraine's ad hoc acceptance of the court's jurisdiction, the court can't investigate crimes of aggression because of the carve-out for acts of aggression involving non-state parties, absent a Security Council referral, which of course is not going to be forthcoming in the current context. So to plug this jurisdictional gap, as a number of other speakers have mentioned, it has been proposed that an ad hoc international tribunal be established. I'm not going to speak to that now, but let me say it is an initiative that I'm strongly in support of. I've in fact been one of the advisors to the government of Ukraine on this issue, so I'd be very happy to take the issue up in Q&A. Importantly, though, in order to reduce concerns about selectivity, and more important, to ensure that these types of limitations on the ICC's jurisdiction won't bar ICC action in relation to future crimes of aggression, it has in parallel been proposed that provisions governing the ICC's jurisdiction over aggression be amended. And indeed, already in 2010, we agreed that 7 years after the beginning of the exercise of the court's jurisdiction over aggression, that we would review the amendments. And that's a clear indication that from the outset, many states were dissatisfied with these limitations put on the court's jurisdiction, which were, of course, the price paid to the P5 for securing agreement on the amendments. So last year, the Global Institute for the Prevention of Aggression, or GIPA, prepared model amendments addressing these jurisdictional problems. GIPA has also prepared a draft resolution under which the model amendments could be adopted, and an explanatory memorandum to assist states in consideration of these texts. So together with other members of the Council of Advisors of GIPA, including Astrid, as well as Jennifer Tran, GIPA's convener, who will speak later today, I was the principal author of these documents. So I want to spend a little bit of time just explaining how and why we think the jurisdictional provisions should be amended. So, of course, the key provisions we're talking about are 15 bis and 15 ter of the Rome Statute, and they contain a number of unique restrictions. Two of those restrictions found in Common Article paragraphs 2 and 3 have now been satisfied, and so they're really only of historic interest. And this means actually that there are now no ongoing restrictions affecting a Security Council referral under 15 ter, but there are a number of ongoing restrictions under Article 15 bis. So paragraphs 6 to 10 of 15 bis essentially concern the need for a special authorization of an investigation of a crime of aggression. In summary, if the Security Council has already determined that an act of aggression has occurred, or make such a determination after notification of the situation before the court, the prosecutor can proceed with the investigation. Excuse me. If the council doesn't make a determination within 6 months and also doesn't use its deferral powers under Article 16, again, the prosecutor can proceed, but in this case, he or she needs authorization of the pre-trial division that is constituted by 6 or 7 judges, and it's distinguished from the pre-trial chamber, which is usually made up of just 3 judges. And so we see 3 conditions unique to aggression here. First, the possibility of the Security Council greenlighting an investigation. Second, the alternative authorization by the pre-trial division. And again, it's the only time that the division meets to serve any sort of judicial function under the Rome Statute. And then you've got the fact that a decision outside of the OTP is needed in the case of state referral, because of course you need a trial chamber's authorization for any proprio modo investigation of any crime. Now, some states and commentators find this process objectionable, and they would have liked to have seen it deleted. But together with a majority of experts involved in the drafting of the model amendments, I think that it's actually quite reasonable to make some concessions to those states that are concerned about politically motivated referrals or investigations. And so for this reason, GIPA isn't recommending the amendment of paragraphs 6 to 10. Rather, the focus is on paragraphs 4 and 5. So and let's take them in reverse order because 5 is much more straightforward than 4. So it's very clear that an act of aggression involving, committed by or against a non-state party is excluded altogether from the ICC's jurisdiction under 15 bis 5. And of course, this is a really significant departure from the ordinary jurisdictional regime set out in Article 12 of the statute, whereby the ICC's jurisdiction is enlivened by the acceptance of that jurisdiction by either the state on whose territory the crime is committed or the nationality of the alleged perpetrator. The court's jurisdiction in relation to ICC states parties is also curtailed. So under paragraph 15 bis 4, states parties can opt out of the court's jurisdiction. And here we get to the heart of things, because in the years between the adoption of the aggression amendments in Kampala in 2010 and the activation of the court's jurisdiction over the crime in 2017, a sharp difference of views emerged as to the proper interpretation of this paragraph. So what tends to be referred to as in negotiations as the broad interpretation, the one held by a majority of states parties and commentators, is that ratification of the aggression amendments by one of the victim or aggressor state party is enough to give the ICC jurisdiction. The narrow interpretation, championed by a small group of states, led by the US, the UK, France, Norway, Canada, and Japan, is that both the aggressor state and the victim state must have ratified the aggression amendments. And of course, in both scenarios, the aggressor state has opted out. So the resolution of this interpretive question in effect determines whether the ICC's jurisdictional reach is limited to crimes of aggression occurring exclusively between the 45 states that to date have ratified the aggression amendments, or whether it extends to a crime of aggression that involves at least one of those 45 states, so long as the other party is an ICC state party and the aggressor hasn't opted out. Proponents of the narrow view argue that this paragraph on the screen, 15 bis 4, has to be read together with Article 121, paragraph 5, second sentence. So Article 121.5 is the provision under which states parties agreed the amendments enter into force. The second sentence, and that's covered in the first sentence, the second sentence relates to exercise of jurisdiction, and in the context of other crimes added to the Rome Statute, states parties do seem to have agreed that that second sentence requires double ratification, so by the territorial state and the state of nationality. Proponents of the broad view essentially deny that this second sentence of 121.5 applies, and that's on the basis that exercise of jurisdiction is actually covered exclusively by the language of 15 bis, and so 15 bis is lex specialis. And I personally think that is undoubtedly the better interpretation. It's more faithful to the ordinary meaning of the words of 15 bis 4 and 5. And it is also the only interpretation that is consistent with the fact that in the lead up to Kampala, we had one group of states saying, we want the ordinary Article 12 jurisdictional regime to apply. You had another group of states saying, we want the second sentence of 121.5 to apply, and we think it means double ratification. So the whole rationale for the opt-out mechanism was a compromise to bring these two groups of, or these two parties together. So rather than an opt-in, it's an opt-out scenario. No states in the lead up to Kampala or at the review conference itself were arguing for opt-in plus opt-out. Now, going beyond that very brief overview of the legal arguments is a complex exercise. It requires a detailed technical analysis of Article 15 bis and 121.5. We have to look very closely at the language of the resolution under which the amendments were adopted and study the negotiating history. And none of that leads itself to an oral presentation, particularly over Zoom. So if you're interested, you can read the 51 pages in my book that are dedicated to this issue. Hopefully there'll be a summary of those arguments being published in an article coming out with the Journal of International Justice later this year. But for now, for the sake of argument at least, let's assume that I'm right and that the proper interpretation of 15 bis 4 is that ratification of the aggression amendments by either a victim or aggressor state party will give the ICC jurisdiction over the crime of aggression committed by a fellow state party as long as the aggressor state hasn't opted out. Indeed, as I mentioned earlier, I'm not alone in preferring this interpretation. A clear majority of states parties are on the record as supporting it. Despite this, operative paragraph 2 of the resolution adopted in December 2017 that activated the ICC's jurisdiction over aggression clearly endorses the alternative narrow interpretation. Simple reason for that is that the UK and France refused to agree to activation unless the Assembly included language in the activation resolution that endorsed the narrow interpretation. So exhaustive efforts were made to reach a diplomatic compromise that failed. A vote was politically unrealistic. So those states that favoured a broad interpretation conceded the point in order to secure activation, as a number of them expressly stated for the record immediately after the activation resolution's adoption. Now, it's noteworthy that OP3 of that same resolution reaffirms those provisions of the Rome Statute that relate to judicial independence and the fact that ultimately it is the judges of the court that are responsible for interpreting the statute. And proponents of the broad interpretation clearly hoped that this would be a hook for the ICC's judges to look beyond OP2. And I think the ICC's judges should look beyond OP2 because in my view, it doesn't amount to a subsequent agreement for VCLT purposes. There's lots of evidence on the record that there was not a substantive agreement on states reflected in OP2. All of which is to say that I think the broad interpretation is the better one, and I think it remains open to the court's judges. Now, most proposals to amend 15 bis, including, if I'm frank, those are initially contemplated by GIPA's drafting group, would simply delete paragraphs 4 and 5 or substitute them with a cross-reference to Article 12. And I am of the view that that's a really unwise approach to take because what it would actually do is remove the lex specialis regime from 15 bis, which I think opens the door quite widely if the sentence of 121.5 applies. And the effect of that would mean that the aggression amendments would have to be ratified by both the aggressor and victim state before the ICC would have jurisdiction. The national of a non-state party could only be prosecuted in the event their state ratified the Rome Statute and the aggression amendments as amended. And so rather than closing the jurisdictional gap, you're arguably widening it by going down that path. So to keep the door closed as firmly as we can on that double ratification requirement and to avoid any ambiguity about exercise of jurisdiction, I argued for and GIPA members have supported the replacement of paragraph 4 with language that mirrors the text you find in Article 12, paragraph 2 of the statute. So this amendment that you see on the screen before you is intended to make it clear that ratification or acceptance of the aggression amendments by either the territorial state or the state of nationality, so in aggression terms, the aggressor or victim state, is sufficient to enliven the ICC's jurisdiction over the crime of aggression. And the court would have jurisdiction if this amendment was enacted, whether the second state was a state party that hasn't ratified or accepted the aggression amendments, or indeed a non-state party. The second substantive part of the amendments is to replace paragraph 5 with the language that would mirror Article 12, paragraph 3 of the statute. And that would make it clear that the mechanism whereby non-states parties can make an ad hoc declaration accepting the court's jurisdiction also applies to aggression. The prevailing view is that it currently doesn't. So the mechanism would be available to, in fact, to both non-states parties and to states parties that haven't accepted the aggression amendments. I might just very quickly touch on a couple of additional issues. One actually really important issue is whether, if we're going to amend the amendments, which amendment provision in the Rome Statute applies. So it's you may be familiar with the fact there was a big debate about this, in fact, in 2010. For my money, we're dealing with an amendment to 15 bis. I think the better argument is that 121 paragraph 4 applies, because 121.5 expressly states that it applies to the amendment of Articles 5, 6, 7, and 8. That would mean if we relied on 114, that the amendments would enter into force for all states parties once 7/8 of them had ratified the amendments, which is obviously a very ambitious target. I do agree, however, that a defensible argument can be made that 121.5 applies based on the history of the aggression amendments. So states had this big debate about which amendment provision should apply to the 2010 amendments. And based on the mandate given to them under Article 5, paragraph 2, states parties ultimately agreed that the aggression amendments should be treated as a package and that entered into force in accordance with the first sentence of 121.5. And so the history of the aggression amendments does provide a basis to argue that any further amendment of 8 bis, 15 bis, or 15 ter should similarly be governed by the first sentence of 121.5 for reasons of consistency. Because the matter isn't clear-cut, though, the resolution we prepared leaves this issue open with square bracketed text to reflect the two options. And in fact, it was very deliberately crafted to give states some room to manoeuvre in negotiations on this issue. We tried to be comprehensive and cover off on technical issues. So one issue that I thought needed to be addressed is what would be the impact of the adoption of an amendment. So we wanted to make it very clear that the court wouldn't lose its existing jurisdiction over the crime of aggression. And so we've included a transitional provision that specifies that the 2010 amendments continue to apply to ratifying state parties until the new amendments enter into force generally, assuming we rely on 121.4, or until an individual state party has ratified the amended version of the amendments in the event we rely on 121.5. For similar reasons of clarity, there's a provision in the resolution setting out that future states parties will only have the option of accepting the amended version of the amendment. So assuming this proposal got up, there would be no option for states to go back in time and accept the 2010 version. They would only be able to ratify the amended version of the aggression amendments. Just finally then, I think it's important to draw your attention to the fact that a number of states are now on the public record as supporting the proposed removal of these limitations on the aggression jurisdiction. Germany has taken a particularly prominent role in the discussions. It has convened a group of friends to take this work forward, and they are looking at tabling an amendment, and GIPA's text is being considered in that context. Now, an important side note to make in that context is that Germany's foreign minister has, on a number of occasions, suggested that through this process, it would be possible to provide the ICC with jurisdiction over crimes of aggression being committed on Ukrainian territory. And there is some support for that contention among experts, but together with a majority of us involved in the twin efforts to establish a special tribunal for Ukraine and to amend the Rome Statute, I don't share the foreign minister's views. 3 quick reasons. First, it's likely to take a very long time to agree on these amendments and then for them to enter into force. And so I think it would really undermine the deterrent potential of such an approach. Second, Astrid's explanation of the definitional evolution has given you some insight into how controversial the crime of aggression is. You also see that in all of the special conditions attached to jurisdiction. Given that long history of controversy, I think it's politically unrealistic to suggest that states would agree to a retrospective enactment of an amendment. But I also think it's legally problematic. So Astrid and I think, differ a little bit on this particular point. But in my view, the customary definition of the crime actually reflects the Nuremberg and Tokyo understanding, which is very much focused on the law of aggression. And I don't accept that the manifest violation threshold is coexistent with that understanding of the crime. And that's at least in part because states parties expressly rejected the war of aggression formula on the basis that it was unacceptably narrow. So, yes, the customary definition of the crime may well evolve if sufficient states embrace Article 8 bis, and generally that is part of customary international law. My study of state practice and opinio juris leads me to the conclusion that that has not happened yet. Now, to be clear, Russia's aggression against Ukraine would meet the customary definition of the State Act element of the crime. There's no question about that. But any ASP decision about retrospective application of amendments would have to cover all possible cases. And so for that reason, I think it would be inappropriate, because I think you'll run into potential violations of the nullum crimen sine lege principle. So that conclusion about Ukraine in no way undermines the case for amending the ICC's jurisdiction over aggression. I think it's absolutely imperative for states that are committed to the jus ad bellum and international criminal law and who want to seek the protection of the ICC. Certainly, it's been suggested to me that in the current, complex geopolitical context, it's a little bit naive to be thinking about expanding the ICC's jurisdiction. My response to that is, at this very moment, when the prohibition on the use of force is under such strain, it is actually more important than ever for states committed to the rule of law to do everything they can to reinforce that keystone of the international legal order, and quite frankly, to address persistent complaints about double standards and hypocrisy. Thanks. I'm going to work out how to stop sharing my screen. Cool.
Thank you so much, Carrie, for your profound contribution to your discussion today. Your explanation of the jurisdiction, the exercise of jurisdiction over time of aggression has further enriched the session. And I think we can move now to the question and answer session. If someone has a question. No? I have a question. You talked about amendment to an amendment to the amendment in practice, no? And that and I think that we have already a date for a new revision conference of the Rome Statute, right? In a few years, or I'm wrong? Ready? Can you hear me?
Yes, sorry, I didn't catch any question though.
The question is, we have already a date for a new revision conference of the Rome Statute where we can amend the amendment to the crime of aggression? And do you think there will be we call it the Kampala Compromise, and what come out from the Kampala Compromise is a system of consent in Article 15 bis with regard to state referral and prosecutor proprium investigation. Do you think that today something changed in the willingness of states in respect to Kampala 2010, and therefore there will be enough support for an amendment to the Kampala amendment by state party, I mean?
Okay, so please steer me back on track if I've missed it. The audio is not great. But yeah, I mean, yes, the states have already agreed to review the aggression amendments. Any under, the rules of the Rome Statute and the working practices of the Working Group on Amendments, any state can in fact send a proposed amendment to the UN Secretary General in his capacity as depository of the treaty, and then it automatically goes to the next Assembly of States Parties meeting. There are arguments for and against having a dedicated review conference focused on this amendment, and states and experts have a range of different views on that. It comes down to political strategy, really. Certainly, like from a mechanical point of view, there's a multitude of ways this could be done. It's more about the political will, which is, I think, really the focus of your second question. If I caught it properly, you're asking what the prospects were of having a more ambitious jurisdictional provision, given we couldn't get there in 2010. The way you framed it, I think, was, what's changed, and I would say an awful lot has changed. I think that, the geopolitical landscape is just vastly different, and in a way, support for the ICC is not as strong, I think, as it was in 2010. But I think in a funny way, like if we think back, the International Court of Justice isn't an exact parallel, but we've seen, in the past when the court sort of came under challenge, if we think of something like the Nicaragua decision, when P5 members have sort of pushed back on international justice institutions, that has actually underscored exactly how independent they are, which has caused a wave of support from small and medium powers. And so I think there is a sense that, I hate using the term global south, but I'll use it so you understand broadly those states I'm referring to. I think, or perhaps we could say non-Western states or small and medium states, are really quite frustrated and angry at this moment in time about at least perceptions of hypocrisy and double standards, whether or not you think they're valid perceptions or not. And so I think, there is a large group of like-minded states that make up the ICC states parties. And while historically states have been very reluctant to vote on amendments, because that does risk fracturing the consent-based nature of the ICC, if there was to be a huge swell of support around this proposed amendment with the aim of trying to reduce double standards and hypocrisy, I think there is a prospect, in fact, that we might be able to isolate those states that are prepared to nakedly defend their own self-interests, much as the same way as those states were isolated in Kampala for slightly different reasons, because of the politics involved. But I think it's worth giving it our best red hot shot. That's for sure.
Kerry, in Kampala, we have powerful states like UK and France, but also observer states like United States that had a great influence on the compromise that then we reached. And so my question is to myself, these states Do you think that they will change their mind and have a different behavior today?
I think if I understood correctly, the question is directly about the US. Look, I think, the ICC over the years has convened meetings under the formula that are only open to states parties. I think it's unrealistic to suggest that that would happen or that the US or other non-states parties would be excluded from any discussion about the amendment of the amendments. And I personally think it would be unwise to exclude non-state parties because we want this to be a court that ultimately all states would like to join in the long term. I guess you can, having been an aggression scholar and involved in these negotiations for, 20, 25 years now, I get used to being branded as an optimist, and I'm happy to carry that mantle on this occasion as well, because I tend to think at some point, powerful Western states surely will wake up to the fact that at least perceived perceptions about double standards are harming their own self-interests. It's just become, I think, very unpalatable for states to champion accountability, the rule of law, the importance of the prohibition, and not be prepared to see those rules applied equally to all. So I would like to think that at some point, all states will realise that it is actually in their collective best interest to make sure that the international law order generally, and particularly the prohibition on the use of force, is something we all very vocally commit to. And part of that involves criminalising the most serious violations of the prohibition, which is embodied in the crime of aggression, as Astrid has outlined. So, do I think it will be an easy sell? No. Do I think it's hopeless? Equally, I don't think it's hopeless. I think it's worth at least giving it a big push.
I appreciate your optimism because I think that is what we need right now in this specific historical moment. So I really appreciate it. Thank you so much for your answer. Other question in person, online? If someone wants to write in the chat. No, we can conclude here, I think. Okay, so please, I want to extend my deepest gratitude to your esteemed panelists, Dr. Astrid Resinger-Corazzini and Karen McDougall, for this invaluable contribution today and really clear explanation of the crime of aggression and the challenge on prosecuting crime of aggression and what can be the proposal to overlap this challenge. Kelly, thank you so much. I saw that you participated since the beginning this morning, and I really thank you for your participation and your contribution to this important event for us.
Thanks very much.
So we can actually take 10 minutes of break. Just stretch your legs, refresh yourself, and come back for your fourth and final panel of today. Ladies and gentlemen, thank you for staying engaged, and we move into our final panel of the day, panel 4, which focuses on the role of the Security Council in addressing global conflict. This panel will examine the Security Council intervention in international conflict, exploring its successes, challenges, and the area where reform may be necessary to enhance its effectiveness in maintaining global peace and security. I am honored to introduce our distinguished guest for this session, who bring wealth of knowledge and diverse perspective on international law and functioning of global governance structure. The first guest speaker of the day, and I am pleased to introduce Professor Jennifer Tran. Professor Tran is a distinguished academic practitioner, deeply engaged in the intricate layer of international law, particularly in the context of United Nations Security Council and his role in global peacekeeping and conflict resolution. Professor Tran currently serves as a clinical professor at New York University, where she imparts a vast knowledge of international law to future leaders and legal scholars. Her academic journey is marked by significant contribution to our understanding of international criminal law and justice reform, making her a leading voice in debates on the effectiveness and challenges of the Security Council. Please join me in warmly welcoming Professor Jennifer Tran.
Thank you for that lovely greeting. We decided that it would be better for Professor Stereo to lead off the presentation. So she's going to lay the foundation for the problem that exists. And then I'm going to propose one solution. So if our moderator would be so kind as to introduce Professor Stereo, that would be greatly appreciated. Thank you.
If you agree, I will introduce all three the panelists for this panel, and then you can do whatever you want. Okay, so the second speaker, and I am thrilled to introduce Professor Milena Stereo. As a respected scholar and expert in international law, Professor Stereo brings a wealth of knowledge and insight to your discussion on the complexity of global governance and conflict resolution. She held the position of Professor of Law at Cleveland Marshall College of Law at Cleveland State University. Her scholarly work span international criminal law, international humanitarian law, and human rights, an area where she published extensively, influencing academic and policy discussion worldwide. Her insights are particularly valuable in today's global context, where legal and humanitarian perspectives are crucial in shaping effective response to international crises. So let's give a warm welcome to Professor Milena Stereo, please. Then we have a third guest that I have the honor to introduce, that is an institution in international law, particularly renowned for his extensive work on human rights and international criminal law, Professor William Shabas. Professor Shabas is a professor of international law at Middlesex University in London, and also serves as professor at Leiden University in Netherlands. He has a distinguished career that includes positions at National University of Ireland and Irish Center for Human Rights. His expertise spans several critical areas, including genocide, war crime, and death penalties, making him one of the most foremost authorities on international criminal justice and human rights law. Professor Shabas has been part of numerous international human rights missions and has served on the United Nations Commission of Inquiry on 2014 Gaza conflict. Without further ado, please join me giving a warm welcome to Professor William Shabas. And now I will give the free space to your estimated guests and panelists for this interesting, and the heart of this, I believe, the heart of this roundtable panel on the Security Council role and reform of the Security Council. Thanks so much for your participation and to join us today.
Thank you so much, Pier Paolo. That was a lovely introduction. And since we're the last panel of the day, we had to be a little bit contrary and not go by your very specific instructions. So we changed the order a little bit, as Professor Trahan mentioned. And then instead of each of us speaking for 30 minutes, what we're going to do is we're going to do 2 rounds of comments by each of us. And then hopefully in the second round of comments, we'll be able to respond to what each one of us has said. I don't anticipate that there will be significant disagreement, so I don't think it will be a rebuttal, but we'll be able to at least comment and pick up on some of the comments previously offered by my distinguished colleagues. So we're here to talk about the actions and challenges in the Russia, Ukraine, and Israel-Hamas conflicts, and we're supposed to discuss any proposed reforms to the Security Council. As we all know, this relative inaction of the Security Council in the face of situations where human rights violations and atrocity crimes have occurred has been well documented and has been discussed numerous times. The UN General Assembly itself has held numerous debates, and I would particularly emphasize a debate that took place back in November of 2023. This is in the wake of the October 7th attacks by Hamas, where the General Assembly, various representatives of many states specifically expressed the view that there is a structural reform necessary for the Security Council. And the UN Secretary General himself, in February of this year, speaking at the opening of the UN Human Rights Council in Geneva, said, quote, that the Security Council was unable to act on the most significant peace and security issues of our time. And then he added, the Council's lack of unity on Russia's invasion of Ukraine and on Israel's military operations in Gaza following the horrific terror attacks by Hamas on October 7th has severely, perhaps fatally, undermined its authority. The Council needs serious reform to its composition and working methods. But as we all know, such reform is easier said than done. And Professor Trahan in particular will focus on some of the most interesting proposals, including her own, which have to do not so much with structural reforms to the Security Council, but with possible legal limitations to the use of the veto power in the face of atrocity crimes. Now, before I begin to talk specifically about the Security Council, I did want to just add the following observation, that from the perspective of state sovereignty, which is a fundamental principle of international law, it makes at least some sense that the Security Council would be limited in its ability to act and to impose sovereignty encroaching measures. One of the most famous scholars of international law, Louis Henkin, famously wrote, quote, the essential quality of statehood in a state system is the autonomy of each state. State autonomy suggests that a state is not subject to any external authority unless it has voluntarily consented to such authority. And so here, yes, we're talking about a system where states have, through the United Nations Charter, consented to have their own sovereignty limited, abridged in some ways. But from that perspective, I do think that it makes sense that the Security Council can only act in limited cases. So let me go back and offer just some brief remarks about the background, the history of the UN and the Security Council. I'll talk a little bit more about the veto, and then I'll focus more specifically on some of the resolutions that have been voted and some of the resolutions that have failed in the context of both Ukraine and Gaza. So as most of you know, the UN Charter was negotiated in the wake of World War II, when victor countries recognized the need to participate in this new global organization in a joint effort to preserve peace. But these victor countries also wanted to hang on to their superiority and wanted to preserve their own political advantage in the global arena. And the compromise that emerged after multiple rounds of negotiations back in San Francisco in 1945 really reflected this tension. So the United Nations, the new organization that was created, was structured as a global forum with multiple organs within it, the General Assembly, where the concept of state equality and sovereignty is present and where each state gets one vote, but also the Security Council, where the super sovereign states preserve their political and military advantage through the veto structure of the Security Council, where 5 permanent members, including the United States, UK, France, the Soviet Union, and China, maintained veto power. And these countries thereby preserve their right to basically unilaterally determine the outcome of future sovereignty encroaching actions by the UN, such as, for example, the authorization to use force against a member state. Now, I wanted to just pause here and offer just facts, detail about the use of the veto power, not just veto power in the face of atrocity crimes, but veto power generally speaking. So since the UN's creation, Russia / the USSR has used veto most times. So the USSR and then its continuation for the purposes of the Security Council, Russia, as of February of 2024, has used its veto power a total of 155 times. Second place goes to the United States, which as of February of 2024 has used veto power 90 times. China has used it 20 times, the UK 32 times, and France 18 times. With the important note that France and the UK have not used their veto power since the end of the Cold War. So I just wanted to throw in these statistics to illustrate that, yes, the use of the veto power is problematic, and I think it's particularly problematic when we're talking about major human rights violations and atrocity crimes. But some countries, for example, the UK and France, don't really use the veto power anymore. Obviously, they could restart at any time, but they don't use it as much. And then it's really the USSR that has used, and Russia now that has used it the most, with the US in second place, having used it 90 times. Now, when it comes to the specific authorization to authorize the use of force, we know that here the Security Council has been pretty much paralyzed. So to look back to the history of the Security Council, it authorized the use of force one time back in 1950 in Korea. And the reason that it was able to do so back in the day is that the Soviet Union at the time was temporarily boycotting the Security Council, so wasn't present to cast their own veto. Then the Security Council did not authorize the use of force from 1950 until 1990 in the first Gulf War in Iraq. And obviously, this is a time where the Soviet Union was dismantling. And so it's a time of sort of relative activity, a time period where the Security Council was able to actually act. And then since the end of the Cold War, the Security Council has been somewhat active, although as the examples of Ukraine and Gaza mentioned, not so much anymore. But in the 90s, at least, it acted multiple times and has authorized the limited use of force by UN peacekeeping operations in places such as the former Yugoslavia, Somalia, the Democratic Republic of the Congo, Kosovo, and East Timor, and also by regional arrangements such as ECOWAS, the ECOWAS mission in Côte d'Ivoire, the European Union force in the Democratic Republic of the Congo, and also the African Union mission in Somalia. And then it also authorized the use of, quote, all necessary means and all necessary measures by multinational forces in Somalia, Haiti, Rwanda, Albania, Bosnia-Herzegovina, East Timor, the DRC, Liberia, and Iraq. And probably the most recent example of Security Council authorization to use force against a member state was Resolution 1973 in 2011, which authorized member states to take all necessary measures to protect civilians under threat of attack in Libya. But what we see from these instances of Security Council approval for the use of force is that most of these approvals for the use of force have involved either limited mandates for the use of force. So, for example, in Libya, the mandate was limited for the protection of civilians or for specific peacekeeping operations in places such as the former Yugoslavia, Somalia, East Timor, or such authorization for the use of force has been limited in situations where we have missions led through regional organizations, such as the case of ECOWAS, the European Union, or the African Union. Instances where the Security Council has approved the general use of force by all necessary means against a UN member state have really remained limited and rare throughout the organization's history, and this state of affairs really exemplifies the Charter's preferred system, where the use of force is a rare and limited exception, and where state sovereignty and this, political and military superiority of the P5 countries truly prevails. There have also been numerous instances where the UN Security Council has not acted in situations which truly have reflected major human rights violations and the commission of atrocity crimes, and where arguably the UN Security Council should have acted. And these situations include the genocide in Rwanda back in 1994, the situation in the then Federal Republic of Yugoslavia in 1999, and then more recently, Syria, Ukraine, and Gaza. And in each of these situations, we have dealt with instances of veto or a threat of a veto, exercise of a veto by either Russia and China on the one side or the United States on the other side. So let me now shift and speak just a little bit more specifically about the situation in Gaza and then Ukraine. So when it comes to the situation in Gaza, there actually have been 3 resolutions that the Security Council voted on Gaza. So let me mention the 3 resolutions. There's Resolution 2712, which was voted back on November 15th, 2023, which called for humanitarian pauses and the establishment of humanitarian corridors in Gaza. And when it comes to this resolution, Russia, the US, and the United Kingdom abstained. So they did not veto the resolution, but they abstained. There's also Resolution 2720, which was voted on December 22nd, 2023, which called for increased aid for Gaza, demanded the opening of the Gaza border crossings to humanitarian aid, proposed the immediate appointment of a senior humanitarian and reconstruction coordinator in Gaza. Again, a resolution focused on humanitarian need. And when it comes to this resolution, both Russia and the United States have abstained. So again, didn't veto, but abstained. And then last, there's Resolution 2728, which was voted on March 25th, 2024, which demands an immediate ceasefire in Gaza during the holy month of Ramadan and demands an unconditional release of all hostages. And when it comes to this resolution, the United States abstained, again, didn't veto, but abstained. In addition to these 3 resolutions that were actually voted, there have been several failed resolutions in the context of Gaza. So back in the fall of 2023, the US vetoed a draft resolution that would have asked for a humanitarian pause in the Gaza Strip on the grounds that this resolution did not mention Israel's right of self-defense. And then more recently, in March of 2024, there was actually a US-led resolution calling for a ceasefire between Israel and Hamas, and that one failed to pass the Security Council in the face of Russian and Chinese veto. And Russia particularly claimed in that instance that the resolution was politicized and contained an effective green light for Israel to mount a military operation in Rafah. So when it comes to Gaza, there have been a number of failed resolutions, but the Security Council actually managed to act and managed to pass 3 different resolutions, each of them focused on the humanitarian lead, each of them calling basically for the need to allow humanitarian assistance into Gaza. When it comes to Ukraine, the situation is a little more dire. The only resolution of the Security Council that was passed was Resolution 2623, which was adopted back on February 27th, 2022, so in the wake of the Russian invasion of Ukraine. And this resolution passed despite Russia's no vote, because this was actually a procedural resolution, not subject to the veto, because it called for a special session of the UN General Assembly on the subject of Russia's invasion of Ukraine. And so procedural resolutions in the Security Council are not subject to the veto power, and that's the only reason that this resolution passed. Any other, possibility of a resolution when it comes to Ukraine would have been immediately vetoed by Russia. Now I should mention that there have been a number of UN General Assembly resolutions that have been passed on Ukraine, calling for humanitarian aid in Ukraine, basically calling for the suspension of the rights of the Russian Federation in the Human Rights Council, establishing the territorial integrity of Ukraine, specifically specifying there has been aggression in Ukraine, etc. But as we all know, these UN General Assembly resolutions are not subject to the veto and can then pass. And so with all of that, we see that the UN Security Council acts sometimes. We see that when it comes to the authorization to use force, it has remained relatively inactive over the years. And we also see that because of the veto power, which thus far has been unlimited, these P5 Security Council permanent members are able to block any action of the Security Council if that action would threaten their own interest. And so in light of that, there have been numerous proposals for UN Security Council reform. Now, as a preliminary matter, in order to actually structurally reform the Security Council, you would need a vote of 2/3 of the UN member states to vote to amend the charter. Plus, these states would need to ratify this type of legislation domestically, and you need all P5 members to agree. So it's somewhat akin to amending the US Constitution, where in theory it is possible, but it is really extremely difficult. Now, I should mention also that back in April of 2022, in the wake of the Russia's invasion of Ukraine, the UN General Assembly unanimously adopted a new rule that triggers a debate in the General Assembly within 10 days of a permanent member using their veto power. So this is an example of the General Assembly acting not to restrict veto power because it doesn't have those powers, but to at least say, hey, anytime that there is the use of the veto by a permanent member, there ought to be a debate about this in the General Assembly. Now, in addition to this, there have been calls for other types of proposals of the Security Council. And I'll just briefly mention some of these, and then I'll yield the floor to my colleague, Professor Trahan, who can talk more specifically about some of these proposals. So there's one proposal known as the G4, which would be to give India, Germany, Brazil, and Japan permanent seats on the Security Council. There's another proposal for African countries to be given 2 permanent seats. Folks have talked about, for example, Nigeria and South Africa as perhaps being those 2 countries, but there's certainly oppositions to that idea as well. There's another proposal that has been dubbed Uniting for Consensus, which would be to expand the number of non-permanent members in the council from the current number, which is 10, to 20, which would be to have, just more wider representation on the Security Council. And this proposal also suggests that states should be allowed to reapply to be on the council after their 2-year election ends. Some scholars have also talked about that another way to reform the council would be to subject its decisions to approval by the International Court of Justice, where the ICJ could rule on whether the Security Council decisions are in line with international law, as a way to put some checks and balances on the Security Council. But as we all know, enforcement of ICJ decisions is notoriously difficult, so I'm not sure that this proposal would actually change things significantly. And then last but certainly not least, US President Joe Biden, in a September 2022 speech to the UN General Assembly, said that the United States now endorses not only permanent seats for the nations that the US has supported, such as Japan, Germany, and India, but also permanent seats for countries in Africa and Latin America and the Caribbean. And this announcement, which is somewhat surprising, has kicked off the latest flurry of diplomacy efforts and discussions about this seemingly, intractable challenge of UN Security Council reform. And there's another proposal, which I briefly mentioned, which Professor Trahan has written about extensively, which is not about structural reform to the Security Council, but again, it's about imposing legal limitations on the P5 countries' ability to use veto power when we're talking about situations of atrocity crimes. So I will stop here. I'll yield the floor to Professor Trahan, and I hope then we'll have time for more comments in our second round, and then we all look forward to all of your questions. Thank you.
Good morning. I want to first thank the organizers for convening this conference, and I'm so pleased to participate. Thank you to Professor Steria for laying the groundwork here. But before I start, I just want to also endorse the remarks in the last panel of Professor McDougall and Professor Reisinger-Corricini. Professor McDougall presented the proposal of the Global Institute for the Prevention of Aggression to amend the Rome Statute and harmonize the jurisdiction of all the crimes. And I'm actually convener of the Global Institute and have worked very much with Professor McDougall and Reisinger-Corricini on this proposal. And I could not agree more with Professor McDougall's words. It's more important than ever to expand the ICC's jurisdiction and so the court can actually be able to use the crime of aggression. So turning to the topic of our panel, Professor Stereo gave us various history I want to just draw attention. Already in 1946, the UN General Assembly passed a resolution saying the Security Council needs to be restrained in its veto use. So it's 1 year after the institution was formed that we already have these pleas. I have written a book, Legal Limits to the Veto in the Face of Atrocity Crimes. And atrocity crimes in my book, I define as war crimes, crimes against humanity, or genocide, although some of my arguments also apply to the crime of aggression. So my remarks are not going to focus on use of force more broadly, but inaction in the face of atrocity crimes. And I'll try not to go over what Professor Stereo already introduced, but to add a few additional situations. She mentioned Kosovo, Rwanda, South Africa. We see extensive veto use. And Richard Goldstone has said without a doubt that delayed the dismantlement of apartheid is how he has put it. Professor Stereo talked about actual veto use. And when you line up the numbers, yes, you do see Soviet Union, then Russia in the lead and the US. But what we also have are veto threats. So what you're not seeing when you look at those numbers are situations that a veto and a threat is not something made in threatening language. A threat could be, we don't want that word genocide used. And then the rest of the council is left guessing, well, would they veto? Well, you know, they may well. And I would suggest the threat of the veto is equally as pernicious. And this is used more often than not by China. So the other situations that I would add to the table would be the situation in Darfur, 2003, 2004, the height of the killing. China is watering down what the rest of the council would have done. China weakens the sanctions imposed on the government of Sudan. And remember, in this time period, the government of Sudan is complicit with the Janjaweed militia in committing the crimes in Darfur. And then China delays the peacekeeping deployment and weakens their mandate. That's what China does in the face of what is most clearly a genocide. I know we've been quibbling back and forth, but it has all of the indicia. And by the way, it's continuing today. So please look at Darfur today. These are not crimes of the past. Sri Lanka, in the face of massive atrocity crimes, the Security Council does basically nothing. And this is, again, because of China's veto power. And the same is true of Myanmar. We have one actual veto that early on would have condemned crimes in Myanmar. And that, you know, the resolution doesn't pass. And that's almost like a green light to the perpetrators. You have a protector on the council. And then regarding the crimes against the Uyghurs, members don't even put proposals on the table. They know nothing will pass, and they don't want to take on China. So the world is not really seeing the extent of the harm in the way the veto is construed as above all law, as if it's irrelevant. It can be used to aid genocide, essentially, no problem. And I'm obviously going to take that on. Professor Stereo walked us through a host of resolutions in Gaza. I counted them up. I think I had a few more, but just so I'm more focused on what didn't pass. And we have, you know, October humanitarian assistance doesn't pass. Another one, October 18, humanitarian pause doesn't pass. Then condemnation of the terrorist attacks by Hamas doesn't pass. Then a call to cancel Israel's evacuation order doesn't pass. Then a demand for immediate humanitarian ceasefire already in December 2023 doesn't pass. Again, fails in February. We have another veto in March. So there are a lot of additional measures that other members on the council would have taken in the situation of Gaza and that get vetoed. And Professor Stereo mentioned the situation in Ukraine, where after one veto, shortly after the invasion, the council basically has been silent. When a permanent member is the state that invades, the council can really do nothing. They did what they could, which was pass a Uniting for Peace resolution, kicking the matter to the General Assembly. But the General Assembly doesn't have the same confidence as the Security Council. It can't undertake Chapter 7 measures. And this is true even if there's a Uniting for Peace resolution. It's an extra maybe mandate, please take this on. But the General Assembly has the confidence it has under the UN Charter. So, and simultaneously, in all of the situations that I've mentioned, we have clear indicia of atrocity crimes. I won't go back to all of these, but just to mention in the Israel-Palestine situation, already October 2023, the Independent International Commission of Inquiry on the Occupied Palestinian Territory, including East Jerusalem and Israel, is opining there's clear evidence that war crimes have been committed by all sides. The ICC prosecutor indicates the same, December 2023. December 2023, President Biden says Israeli airstrikes are indiscriminate bombing. And then we importantly have the grant by the ICJ of provisional measures in January 26 of 2024 on the basis at least some of the rights asserted by South Africa are plausible. So we have these clear indicia of atrocity crimes, and the same, of course, is in Ukraine. I won't go through all the details, but we know warrants have been issued by the ICC for war crimes and crimes against humanity. And of course, the Russian Federation is clearly implicated in the crime of aggression by virtue of its invasion, an aggression that arguably commenced in 2014 with the invasion of Crimea. So we have mass atrocities and then indiscriminate veto use. So how have states responded so far? Two initiatives, the French-Mexican Initiative and the ACT Code of Conduct. And these basically say to the permanent members, please do not use your veto in the face of genocide, war crimes, and crimes against humanity. And the ACT Code of Conduct goes one step further and says all states should vote in favor of credible draft resolutions related to trying to prevent genocide, war crimes, crimes against humanity. So these are important in galvanizing momentum at the UN that such rampant veto use, particularly in the face of atrocity crimes, is really a problem for the functioning of the Security Council and therefore the functioning of the UN system. And the good news is 2/3 of UN members have endorsed the ACT Code of Conduct, and over 100 have endorsed the French-Mexican Initiative. So we have strong support for these. The difficulty is both are soft law documents. So the French-Mexican Initiative is a political declaration, and the ACT Code of Conduct is a code of conduct. And maybe our biggest problem is 2 of the permanent members have endorsed these, the UK and France, but 3 of the permanent members don't. So therefore, Professor Stereo mentioned Liechtenstein's important initiative for every veto cast. There is now mandatory discussion in the General Assembly. So none of these measures stop the veto in the face of genocide, war crimes, crimes against humanity. They're all effective in shedding light on the problem. I could break my remarks here for the second round, but maybe I should just lay out for the others to comment my ideas. on going to the International Court of Justice. So I have in the book, I argue that the veto sits within the context of a system of international law. And we need to recognize this. And I slightly quibble with Professor Sterio's framing. I don't think the veto was ever unlimited. Jus cogens has existed for a long time. Other obligations of international law. So I would even say in 1945, there was no capability to give a veto power that was above the law. So my initiative would not be to impose limits on the Security Council, but recognize what the rest of our system of international law has to say about the veto. So imagine that there is genocide occurring and the council has a plan to try to stop it. And the plan to stop is vetoed. Well, that veto, I would argue, aids the genocide. So, simple question, can you aid a genocide through your veto? I go to Judge Lauterbach in the Bosnia arms embargo case, and they were looking whether the arms embargo on Bosnia was facilitating the genocide by the better armed Serbian side. And he said one reading of that resolution, if it's aiding genocide, it would be void. So he suggests a resolution aiding genocide must be void. And there are many ICJ decisions. The Security Council is bound to adhere to international law. So my question is, well, if you can't aid genocide in your resolution, can you really aid genocide or war crimes, crimes against humanity in your veto? And obviously, I'm arguing that you can't. And, you know, here I draw on the ILC's Articles of Responsibility for Internationally Wrongful Acts. And they say no state may aid or maintain a situation where a peremptory norm of international law is being violated. Well, that's exactly what the veto is doing. They're helping a state aid or maintain the violations of the law. And genocide, war crimes, crimes against humanity are all prohibited at this level of jus cogens. So is aggression, by the way. And, you know, so then with Russia's veto of the condemnation of its own aggression right after its invasion and a whole host of other measures, that is essentially aiding its aggression. So I think we need to evaluate the vetoes in terms of, are they in conformity with the obligations of jus cogens being a higher level of authority than the UN Charter. My second argument in my book is that we have to consider the veto in the framework of the UN Charter. It is one provision in the Charter, but the Charter is framed by its purposes and principles in Articles 1 and 2. These include good faith, adhering to international law, cooperation in solving matters of humanitarian character. You know, not vetoing humanitarian assistance, cooperating. Are the vetoes conforming with these other obligations of the Charter? Because the Council's powers in 24.2 say they must adhere to the purposes and principles of the UN. And the purposes and principles of the UN are also framed to apply to UN member states. So I think there is an obligation at two levels on the Council as whole, but also the P5 in particular, they also UN member states. And a third level I look at in my book, and I'll come to a close soon, are those obligations from treaties, such as the Genocide Convention and the obligation to prevent genocide. Is this what the Council is doing when they veto in the face of plausible claims of genocide? Are they adhering to their obligation to prevent genocide? And one can also ask the same question, and we too often, I think, forget this. Common Article 1 of the Geneva Conventions, the obligation for a state to respect the Geneva Conventions, but also ensure that other states respect the Geneva Conventions, an obligation the ICJ has recognized as binding in its case law. Are they ensuring that war crimes are not committed? This does not seem to be what they are doing in their behavior. So in my book and a separate initiative that I am leading, asking states for support on these, I ask states to raise issues about questioning the legality of the vetoes, bringing out these other legal obligations, because I think if we're going to go beyond the Act, Code of Conduct, and French-Mexican Initiative, I think we need to look at outside international law. A charter amendment is nearly impossible. So the charter says it's 2/3 of all UN member states would need to ratify it, and all P5 need to agree. So the veto is going nowhere, and I don't think we're going to change it within a formal charter amendment, certainly. So I'm thinking go to an outside actor, the International Court of Justice. The ICJ could ask a simple question about the legality of veto use in the face of genocide, war crimes, crimes against humanity. Might also add crime aggression to that formulation. And or states could draft some of this into a GA resolution and recognize some of this. And I'm really encouraged that states are starting to take up these issues. And on the record, in the proceedings at the ICJ, I saw the United Arab Emirates as well as Spain calling for taking these questions to the ICJ, or they called for the ICJ to resolve these issues in the context of pending cases. I don't think they're actually formal enough before the court in the pending cases. There may need to be a separate advisory opinion request. And then Pakistan as well has made this call to look at the legality of the legal obligations related that are at issue when the veto is used, and to stop regarding the veto as if it is above all law. I'll end there. Thank you.
We can open the floor to the first session of question and answer. Yes. We have Professor Bukowski that I believe want to intervene. Professor Bukowski, please.
Yes, thank you, Jennifer, and thank you, Milena. I agree 100% with your disappointment, to put it mildly, and all the actions that you listed have been taken with very little outcome and result. And I'm at the point where I see no other chance to change anything unless we rewrite the UN Charter, and there is no power of veto in it. I agree that a formal amendment might not be ratified by the P5, but then after that, the next step should be a majority of the member states, 140, 150, 160, doesn't matter, rewriting the UN Charter and abolishing the veto and ratifying the new charter, effectively re-establishing the UN without veto. You may say, well, but United States and China and Russia will not join. Fine. They have a choice to join or not to join. Either way, there is no veto. If they do not join, there is no veto in the new United Nations. If they join, they have to accept there is no veto in the United Nations. So let's start with new United Nations Charter, propose it to the member states, and tell them, look, for 30 years you complain about the veto. All the Global South, all the member states at every General Assembly complain about the veto. Why don't you do a simple thing? Get together, all you 150 or 160 states that complain regularly about the veto, and adopt a new charter without the veto. Simple. And put those in the corner, Russians and Chinese and Americans, and see what they can do. Actually, I already do this. I'm in a working group that prepare a revised UN Charter without the veto, but also with many other changes. And we are proposing this to the Summit of the Future in September in New York. And we will distribute this to the member states. Asking a simple, I agree with everything Jennifer said. Actually, I calculated the victims of the veto. Even without Ukraine and Gaza, if we take only Syria, Yemen, Sudan, Myanmar, it will be over 1 million. Can we allow another 1 million people to perish in the next 10 years because China, Russia, and sometimes United States with veto resolutions? I don't want that to happen. In other words, if we don't want another 1 million to perish like they did in Syria, Myanmar, Yemen, and Sudan, and Gaza and Ukraine, we need to change the UN Charter. And there is an opportunity. We have 109 articles in the Charter saying there should be a review conference. By the way, in 1946, in the first General Assembly, the delegations were talking about removing the veto. Uruguay, Philippines, bunch of other countries. They're actually proposing that review conference under Article 109 to remove the veto. Already, we are talking about 1946, the beginning of this United Nations. There are many members who are not happy with the veto. They challenge it even in San Francisco, Australia, New Zealand, Brazil, Poland, half of Europe, and all the Latin Americans were against the veto back in 1945. And that's why they drafted Article 109. So there is a lot of history here that the veto happened simply because Stalin persuaded the British and the Americans to have it and was absolutely adamant to. But by the way, and that's also, there are a lot of myths. And one myth is that the veto saved us from the Third World War. When did it happen? Which veto? In which situation? By whom saved us from? I asked ChatGPT to tell me which veto saved us from Third World War. And the answer was ridiculous. The Cuban Missile Crisis. There was no veto in them. Never ever the great powers discuss in the Security Council anything which concerned their vital national interest. So the veto was always murderous and useless and didn't save us from anything. I'm asking the panel, which veto and when did something good for the world? Thank you.
Well, if I might just intervene, those were lovely words by Professor Popovsky. I could not agree more with the harm of the veto. But somehow we inadvertently skipped over our third panelist, Professor William Schabas. So I'm waiting with bated breath to hear his remarks. Bill.
Thank you, Jennifer. I didn't want to be to jump in, and I thought we might have a little Q&A. And thank you, Vesman, for your remarks as well. I'm going to probably take a slightly more contrarian approach to what appears to be a unanimous understanding of this question. I didn't attend all of the events today because I had engagements earlier in the day. but I've attended this panel and also the previous one. The problem I have is trying to figure out, whether I want the Security Council. So let's put the veto aside, the Security Council, which would be obviously in some way configured differently than the General Assembly, and that it would be a smaller council. And would it have, permanent members, or would it simply be like a body like the Human Rights Council that would just have elected members and no sense that there were certain members that were entitled to be there as of right? I think that's probably a better question than the way Veselin presents it, because, the Charter of the United Nations begins with this wonderful phrase in the preamble about how twice in our lifetimes untold suffering has been brought about by, and they're referring obviously to the two world wars. But I doubt there's anybody in this session, anybody who's present in this meeting online or elsewhere, who experienced a world war in their lifetime. I don't know if I'm the oldest person here, but I'm probably close, and I've never experienced a world war. Although I remember my parents for decades really being haunted by the idea that it was something that came around again and again every 20 or 30 years. We've now been 79 years without a world war. And in some ways, it's been, although it doesn't seem that way, one of the most peaceful periods in human history. And so the question is, the United Nations system, as it's configured, you cannot just say, remove the veto from the United Nations system and then repackage it as if it's the source of all of the problems, or as if it's the secret to the success. It's just part of the package that was agreed to in 1945. And objectionable as it is in so many respects, it's also a system that has provided us with this very lengthy period of relative peace in the world, I think. The other thing that I'm concerned about is that to talk about the 5 permanent members or the big powers is maybe not the most accurate way to view the world either. We live in what is still a very unipolar world, where one great power dominates. It dominates economically, and it dominates militarily. I think it's still true that the United States has more aircraft carriers than the rest of the world combined. It certainly has more than the next 5 countries totaled up. It has bases in 140 countries, military activity in 140 countries. And my fear in all of this is that any redefinition, any reconfiguring of the charter will ultimately just become a tool that the United States is going to use in what is clearly a system where it dominates the world, and it wants to continue doing so. For example, when we're suggested that there should be in the case of genocide, that the Security Council should in some way not allow states that are allegedly implicated in it to use the veto. Who will define genocide? And I know that the United States loves defining genocide. They do it when it comes to states that they don't like China. And they don't do it when it comes to states that they like Israel. And so I don't know that we're going to solve the problem, as Jennifer suggests, by saying, let's remove the veto. Once we're dealing with genocide, then we don't have a veto. We can't have a veto operational. The problem is we're still going to be at the mercy of perverse applications of terms like genocide and war crimes and crimes against humanity. And so my concern is we're not going to be further advanced at dealing with what is a global system characterized, others have used the term, by double standards and hypocrisy. I want to give you just a little anecdote that arose in the last week or so. When I was introduced by the chair, he referred to my position as a professor at Middlesex University, which is my main job. But I also have a part-time employment at Sciences Po in Paris. And my students this year, with whom I spoke a great deal about the situation in Israel and Palestine, were among, I think, the ringleaders of the demonstrations and partial occupation of the premises of Sciences Po in the last week or so, which has got a lot of media attention. I know it's been written up in The Guardian. I don't follow all the media. I'm not sure whether it makes it to CNN News. I get most of my news from Al Jazeera English, and they've certainly given them a lot of attention. So here's one of the issues we're confronting at Sciences Po. The students have made a demand that Sciences Po should break off ties with universities in Israel. It has agreements, like most universities do, with a couple of it has agreements with universities around the world, including 2 in Israel. Well, the administration at Sciences Po has argued that they shouldn't break them off because boycotting universities is just a bad idea. It's a wrong idea. Universities are composed of academics, of scholars, of students, and if anything, when relations break down between states, the universities and those contacts, they should be maintained and they shouldn't be disrupted. And it's a very persuasive argument with which I'm very sympathetic by the administration, that this is not the way to go in breaking off academic relationships. But it turns out that 2 years ago, Sciences Po canceled relationship agreements with 2 universities in Russia. And so they turn to our students and they say, no, this is a wrong idea. And the students shoot back at them and said, but you've done it, and you did it in Russia. There's another example. The students have also called upon the university to issue a statement condemning the government of Israel for genocide and for what it's doing to the people of Gaza. And the university says that's not for universities to do. We're not a government. We don't issue such statements. We don't make declarations condemning states. But it turns out that the university 2 years ago made a declaration condemning Russian aggression. So this is the problem. What am I as a simple academic? I have no interest in the administration of the university, but it's an institution that I'm proud to be associated with, and I enjoy teaching, and I love my students there. So how do I explain this to them? Well, what is the explanation? And that's kind of the problem we're dealing with on a larger scale, and all of these issues about veto in the Security Council and so on seem bound up with those problems of double standards and hypocrisy, which just infect the system. So let me go back now. Let's leave Paris and Sciences Po aside, and let me talk about some of the issues with the Security Council. Sometimes I think it's a question of whether I want the Security Council to have more power or less power. And I sense that ambiguity in all of the conversations I've been hearing, because some call for it to be able to do things without a veto, and others would like it to do less. And I know that in many, there are depending on the circumstances, that's definitely my reaction. I would like it to have more authority to intervene in situations where atrocities and atrocity crimes are being committed. On the other hand, I would like it to have less power when it claims to want to control the agenda, for example, of international courts and tribunals, and to enforce the regime that we've created with the amendments to the Rome Statute. It was also to some extent in the Rome Statute even before the amendments, whereby the Security Council has the power to control prosecutions of the crime of aggression before the court. And I'd like it to have less power there. So sometimes I would like it to have more power, and sometimes I would like it to have less. In both cases, of course, we find ourselves running up against this mysterious veto. Milena's reference to the numbers and the statistics, I agree. I think Jennifer made the point that that can be misleading to some extent, and it's important to look at the time period when those vetoes were imposed. Britain and France haven't used it a lot, but there was a phenomenon for many years known as the triple veto. And this was in the Security Council back in the 60s and 70s, when the whole world, with a few exceptions, wanted to get at the apartheid regime in South Africa and wanted the Security Council to take action. There was no problem getting the General Assembly to authorize action against South Africa, but to get the Security Council with the teeth that it gets from the Charter of the United Nations. And there were the three countries that imposed the veto, two colonial or formerly colonial powers, and one of them sort of a colonial power, but more than that, a global hegemon, the United States, France, and the United Kingdom. So there's something that, in a way, I'd like it to do more of, and that's sanctions, which was what was being called on for South Africa. The problem with sanctions is not the ones that are imposed by the Security Council. It may be partly with the inability or the failure to impose sanctions, but there's another problem with sanctions, which is that the powerful economic states, the so-called Western states, employ sanctions all the time that are called in UN jargon unilateral coercive measures. They're condemned in resolutions of the General Assembly. They're condemned in resolutions of the Human Rights Council. And these are just mechanisms by which wealthy, powerful countries that control things like the dollar economy and international banks use force, but not armed force. But nevertheless, they use measures of force which can be devastating for the economies of countries. And they do that without Security Council authorization. And of course, it would be impossible to get the Security Council to condemn them because some of the ones doing this are permanent members. The second area where I think we would like to see more in principle is in the area of humanitarian intervention. There have been various calls for this. The problem, again, is not really with humanitarian intervention authorized by the Security Council. It's really the lack of humanitarian intervention of the Security Council, but also the claim by some states that they're entitled to intervene without the Security Council. In the case that's still pending before the International Court of Justice, this is the case filed under the Genocide Convention by Ukraine against Russia. More than 30 states have intervened. They are all essentially European or Western states, the Canada, the United States, Australia, New Zealand, and the members of the European Union have all submitted interventions. In one case, they did it jointly. In another case, it was kind of thrown out. This is the case of the American intervention, but that's because the US made a reservation to Article 9 of the Genocide Convention. And they were discussing the issue that was put forward by Ukraine in those proceedings, that Russia was invoking genocide in order to justify the use of force against Ukraine. And that they said they've asked for it, and they may still get it, as a declaration by the court that Ukraine has not committed genocide. In the interventions from these more than 30 states, they addressed the question of whether it is possible legally to use the allegation of genocide, either under the convention or under customary international law, as a justification or an excuse, depending on how you view it, for the use of force against another state. In other words, is it an excusing condition, or is it a justification that you could invoke, for example, in a prosecution of the crime of aggression before an international court? And the answers from the 30-odd states are literally all over the map. Some of them say never. Some of them say you can never do it. And this was a view expressed by Ukraine when it argued the provisional measures back in March of 2022. I think Ukraine sort of softened its position when it saw what other states were contending. And we have a number of states who say that, that it's possible to have unilateral use of force, humanitarian intervention when genocide is committed to prevent a genocide that is where there's a serious risk of genocide being committed. And others who say, well, you could do it, but only collectively. Anyway, there's no clarity whatsoever about this issue. The second place, or the third really, I've spoken about sanctions, I've spoken about intervention, is international justice. And until the International Criminal Court was created, following the adoption of the Rome Statute, international justice, at least international tribunals administering international justice, had essentially been a monopoly of the Security Council or a body resembling it. We can go right back to the Treaty of Versailles in 1919 to find the proposal, it's in the treaty, that there be an international court created by the United States, the United Kingdom, France, and in that case, Japan and Italy, who were considered the other two great powers at the time. Then we go to Nuremberg in 1945, and again, it's the United States, the United Kingdom, and France, together with the Soviet Union, who create the International Military Tribunal. And then in the 1990s, it's the Security Council with the agreement of the 5 permanent members. So the US, the UK, and France have always been there. They've always been at the center of creating international judicial institutions, except for the ICC. And the Rome Statute is in many ways a rejection of the Security Council. And there are a number of elements of it. Probably the most important is the fact that the decision about the selection of situations for prosecution is essentially left to a prosecutor acting alone, a prosecutor with a 9-year mandate, a task, the political determination of the situation for prosecution that prior to the adoption of the Rome Statute had always been in the hands of great powers. We have a few compromises as well in the Rome Statute. We have the possibility of the Security Council referring a situation to the prosecutor under Article 13b, but the prosecutor still has the authority to refuse to proceed, subject to what is a very modest and ineffective form of judicial oversight. And then there's Article 16. And Article 16 allows the Security Council to block temporarily any intervention by the court, any proceedings by the court. And there's been talk from time to time about it being used. I think it's being discussed again as a tool that the Security Council could use to stop a prosecution of the leaders of Israel. I don't think it would be very hard to get the France and the United Kingdom to go along with the United States on such a resolution. I doubt that Russia or China would be in the mood for agreeing with it. So those provisions are not really very effective. But the aggression amendments are, and the aggression amendments are terrible because they leave so much control in the hands of the Security Council. So I totally agree with the proposals to amend the statute and to remove them. There are a lot of technical difficulties and complications, but I'm on the same wavelength on that. I don't know if it was discussed earlier in the day. I think some of the earlier speakers are enthusiasts for the idea of creating a specialized tribunal of some kind, an ad hoc institution. That's not going anywhere. I've been hearing this talk now for 26 months. About how such a tribunal would be created by the General Assembly, by the European Union, by a coalition of various states. But frankly, the P5 are still opposed to it. When I say the P5, I might as well say the P3 as well, because they're the ones who are talking about it. France, the United Kingdom, and the United States, none of them has really unequivocally supported the idea of creating some kind of international mechanism that would not leave the control over the determination of an act of aggression in the hands of the United Nations Security Council. And one final point that arises in the context of the ongoing conflict in Gaza and in Israel and the occupied Palestinian territory more generally it's a minor issue, but one that's not insignificant. A few weeks ago, there was a vote in the Security Council where 12 members of the Security Council voted to admit Palestine as a full member of the United Nations. The General Assembly's already done that. One state stands in the way of Palestine becoming a full member of the United Nations, and that's the United States that imposed its veto. So I'd just like to add that issue to the discussion, because when we're talking about how objectionable the veto is in certain circumstances, this is not a question of using force. This is not a question of imposing sanctions. This is not the Security Council doing something dramatic that threatens sovereignty or anything. It's simply recognizing a reality that the people of Palestine already have a functioning government. It doesn't entirely control its territory, but it's been recognized, not quite universally, and one state can stand in the way, the United States of America, to Palestine becoming a full member of the United Nations. Thank you.
Well, as we promised earlier, we're going to do a very quick second round, but very quick, and then we will have time for all of your questions. So just a comment following up on Bill's intervention. I think, Bill, you're right when you talk about this idea that, is the veto power a good thing or a bad thing? And I couldn't help but wonder, could we ever, let's say that there was no veto power, and let's say that the Security Council could act with a majority vote or a super majority vote. Could we ever envision a situation where the use of force, we're not talking about other measures, but the use of force is seriously contemplated against a country like the US or like Russia or like China? I do fear that would trigger a nuclear global war. And so in that situation, you kind of wonder, despite all the problems associated with the veto power, you kind of wonder whether the use of the veto is sometimes the lesser of two evils. And then I have two very quick questions for Professor Jennifer Trahan in light of her proposal. So two quick questions. One, do you think that Security Council veto, when a P5 country exercises in veto power, do you think that this is a legal act, in which case the legal obligation, for example, to prevent genocide applies, or could you argue that these are political acts, right? So how do you draw that line between legal and political? And then second question for Jennifer is, you're talking about the ICJ, and the ICJ could potentially answer a question about the legality of the use of veto power in the face of atrocity crimes. But how do you enforce an ICJ decision? So, for example, in the context of Gaza, we know that the ICJ has ordered provisional measures, which Israel has so far totally ignored, or at least partially ignored. So how do you go about enforcing an ICJ decision? And, you also talk about, for example, having a UN General Assembly resolution that could also say, for example, the use of the veto is illegal in this situation. But we already have multiple examples of the General Assembly voting resolutions in situations where a similar resolution is vetoed by the Security Council. So, so how is this any different? How could the GA help in this instance? Thank you.
Thanks so much, Milena. Those are great questions. So yeah, we did agree we'll do a quick lightning round, a second lightning round. Yeah, so that is one of the dangers. So the court could dismiss, say, oh, it's kind of like a political question. We have this in the US. I think they've kind of disfavored that more at the International Court of Justice, but I do think it would be really important in the way you ask the question. And we've also seen the ICJ duck questions, or, give a half good, half bad. So I think the framing is very important to try to say, this is a legal question. There are legal obligations that are at issue. This is not just a political act, because there is, if they see this, it's, but I think there was one, I think it was a certain expenses case. They said, well, voting at least must be required to be in good faith. And I think, and that's one of the obligations under the UN Charter. So in that case, they were looking at voting in terms of a substantive requirement. So that made me think we could perhaps couch it that way. Enforcement, that's a great other question. So being in New York, seeing things happen in the Security Council or not happen, or initiatives, we tend to move incrementally. Like we tend to, you know, what is our next step? And I have seen this in, you know, we talked the French-Mexican Initiative Act Code of Conduct. Before them was the S5 initiative. 2005, and 5 small states said, we're going to take on the P5. And they proposed basically veto restraint in the face of genocide, war crimes, crimes against humanity. Their initiative was completely quashed. So, but then they emerged in 2013, and I think the Act Code of Conduct by then had 23 or so member states. And then they got the initiative going, and the French-Mexican, and the vetoes initiative by Liechtenstein. So I think we have to move incrementally. And indeed, if we got an advisory opinion, they're not binding. But I think it's step one. So my idea is ask kind of a general question to the ICJ. That would be non-binding, but I think highly influential. A GA resolution echoing some of these ideas would also be non-binding. You could also imagine a particular veto if in the face of genocide, going to the ICJ for an interpretive question under the Genocide Convention. Same is available under the Torture Convention. So some of our conventions have the provisions, you can go to the ICJ. That would be a binding ruling, but it would be in a particular veto. I don't know if you get your answer in time for it to be helpful in that particular context. So you could also try to get an enforceable question. I'll just quickly respond maybe a little to Bill. I see Veselin's hand raised, so maybe I'll respond to Bill, and Veselin will chime in next. And Bill, I'm not quite sure the order we're going on. But it is with this approach of, I think, of chipping away at more abusive veto practices. You know, I'm a little skeptical about getting rid of the UN system, getting rid of the permanent members. I've already, in a blog post with Direct Ladi, accused me of being conservative because I'm trying to fix the system we have. So perhaps with my limited blinders on, I am trying to fix the system we have, because it seems that incremental change is perhaps the most achievable. So I'm not trying to remove the veto power, but Bill raised the important question, you know, genocide in whose eyes? You know, do we just have the P5 calling it? Well, no. So we often have commissions of inquiry, commissions of experts, fact-finding missions, and they opine on these things. Now, they may not, you know, they're not going to say beyond a reasonable doubt, but they may say, you know, there's a reasonable case to be made, or some standard. So I think we could use these outside bodies. And indeed, I think there is reference in the Act Code of Conduct of referring to the outside bodies, because the French-Mexican Initiative Act Code of Conduct faced the same issue. In whose eyes, you know, when do we accept the determination? And in my talk, I did refer to some of our, you know, outside body determinations. For instance, we did have the fact-finding mission in Myanmar opining that they believed that genocide was occurring. So this could be our trigger. You might also have a trigger in the resolution if 9 permanent members say there's reasonable grounds to believe war crimes are occurring. That could potentially be a trigger. So I could see 2 ways of addressing this. Bill has raised a huge number of questions about humanitarian intervention and R2P. I'd love to address, but this isn't a panel on R2P, humanitarian intervention, so I'm going to try to resist addressing. These are fascinating questions. And, you know, the veto has, as I think Milena started by mentioning, blocked, or how we read the veto above all law, They never went for an authorization for the Kosovo intervention, knowing it would face a veto. So the veto has been used to block, or the veto, our knowledge of how the veto is read does tie into this issue. And I will just make two remarks on the crime of aggression. The Security Council doesn't have control over the crime of aggression. It has no more control than it has over the other crimes in the Rome Statute. So 15 ter of the amendment allows the council to refer situations, including the crime of aggression, but 13b of the unamended Rome Statute says the council can refer and defer related to genocide, war crimes, crimes against humanity. So the Security Council has a certain referral and deferral power that's already in the Rome Statute, other than one minor procedural step that is also in the 15 bis 15 ter. There really is no difference. And finally, I will end with, it's too soon to call it special tribunal on the crime of aggression. These negotiations are occurring every 2 months, different European capitals. And I think having started with two very different competing visions, the international tribunal that I and others who were speaking today have backed, and the US, UK saying, oh, a Ukrainian chamber with some international elements with head of state immunity applying. So we've been at loggerheads for months. There is now a call for a third way, and I think we are narrowing down on the third way. I'm still optimistic that there will be a special tribunal on the crime of aggression for the situation of Ukraine, for all the reasons Professor McDougall stated, that the amendment procedure is going to take a while. We should probably simultaneously get going on the special tribunal. So I'm still optimistic on that. Veselin, did you want to weigh in?
Quickly. Thank you, Milena Stereo, for this hypothetical situation where a future Security Council with supermajority may impose use of veto on United States or China. No, they will not do that. It's very hypothetical. They will not be naive and stupid to do that. But what they can do, and it's very important, is to impose sanctions. And that's what I answer every time when somebody say, what would have changed if there is no veto in terms of Russian-Ukrainian war? A lot would have been different. Imagine a Security Council imposing sanctions on Russia, and all 192 members of the world are absolutely under legal obligation to stop any trade with Russia. That applies to China. That applies to India. And if China doesn't listen, there will be sanctions on China as well. And 85% of the Chinese revenue comes from exports to Europe and America. So imagine a world without the veto, where any aggressor will face global sanctions and cannot continue a war for 26 months being supplied with Chinese and Indian money. That's a huge difference. This war would have stopped if China and India did not trade with Russia. And that's a big difference, Milena. And by the way, why everybody is worried to talk about changing the UN Charter? Bill, everything you said is absolutely correct. We need to think about what Security Council do we need. Stronger, weaker, interventionists, non-interventionists. All of this will happen only if we rewrite the UN Charter. Enough incremental changes. We had small changes for 30 years. It did nothing. Nothing happened with small changes, with academic debates. We need to persuade the member states to get together and to start rewriting the UN Charter. Everything will be fixed. All the great ideas. Global Environmental Agency, fine. UNEP, fine. A new purpose of climate change, fine. New humanitarian, United Nations Emergency Peace Force. They are brilliant ideas. Take the whole list which goes to the Summit of the Future this September. All of this will happen only if there is no veto in the Security Council. enough incremental changes. We need to go to the core of the disease in the middle of the body and remove it, which is the veto. Again, I'm asking the panel, which veto, when did anything good for the world? Well, I have an answer, by the way. The only time the veto could be good is Article 16 of the Rome Statute, when it can stop a deferral of the situation. Thank you.
Can I jump in? Can I? Leslin, yeah, the problem with Article 16 is it's not in the charter. We put it in. It's in the Rome Statute. Shouldn't have been there. And it was put in out of deference to the Security Council, quite a watered down version of what had been proposed. And I remember it well from the Rome Conference, how you know, all of the P5 resisted any encroachment on them. And even when Article 16 was agreed to, some of the P5 took the view that it didn't matter because the Security Council could always stop a prosecution at the ICC, and it wasn't restricted by the limits that Article 16 of the Rome Statute put on it, a one-year time horizon subject to renewal, and so on. You know, people, I'm often asked by students and others, you know, why can't we just agree to change, as you say? It sounds like a wonderful idea. Have a conference and revise the charter. We had one in 1919 in Paris. It created the Covenant of the League of Nations. Another one in San Francisco in 1945 that created the United Nations. So all we need is a third world war, and then we can have a new charter.
Wait. I always listen to this.
I'm not finished yet. I'm just trying to provoke.
For nuclear disaster, why do we need a third world war to change the charter?
The only point is that these things we have inherited in the charter.
The charter.
We've inherited the hegemony of the 5 victorious big nations, and they're not giving up the power. And the question is whether the cure for that is amending the charter or changing it. One of the other things that's happening, I think, that's of interest, is that states are going outside the framework or looking not at the Security Council, but looking at other institutions, giving them more strength, giving them more influence as a way to remediate, in some ways, the deficiency of the charter as it's been applied. So, as I said, the ICC, it's not even a UN institution. It was created because it had to go outside the framework of the charter. States wouldn't have accepted an ICC that was under the heel of the Security Council. We see the reforms of the United Nations human rights machinery in 2005 and 2006. When Kofi Annan proposed the reform in 2005, he said, what we need is to have another council. We have a Security Council, we have an Economic and Social Council, and we should have a Human Rights Council. The idea was to elevate the Human Rights Council, you know, no veto, of course, but to, in some way, to reconfigure or to repackage the Charter of the United Nations. Something that we've seen in the last year or two, which I think is absolutely astonishing, is the willingness of states to go to the International Court of Justice. We have this phenomenal level of activity now at the International Court of Justice, erga omnes cases, 3 or 4 of them now at present. It's absolutely 4 of them. It's unheard of in the past. We have 4 of them that are based on erga omnes principles, and they get a lot of interventions. More than 30 in the Ukraine case. We have now close to 10 states that have intervened in the Myanmar case. We've got 2 that have intervened formally in the South Africa case, but there are going to be many more. And that's a sign of states going, they like the International Court of Justice because there's no veto at the International Court of Justice. There are 15, 16, 17 judges, but they display. On the one hand, we've seen it in the recent orders, a high level of unanimity, actually, and a willingness to, you know, nobody can claim that the International Court of Justice, in the way it's behaving, is beholden to a few powerful military states like the United States or the European powers. But I have a question for Jennifer, who keeps pointing us to the idea of an advisory opinion of the International Court of Justice. You seem very convinced, it's pretty much assumed in your proposal, that if you get a General Assembly resolution, that you're going to get the opinion, the advisory opinion that you want. I'm not convinced at all. I'm not convinced at all. You know, you may get that politically. You may get a bunch of small countries in the General Assembly who want this. But to get those judges at the International Court of Justice to go along with what you're proposing, I wouldn't be confident at all that you would succeed. So do you have a plan B?
I do, Bill. So, or actually, I would say precursors to getting to the ICJ. I actually think the more that states speak out now about their understanding that international law is relevant to veto use, this could help us when we get to the ICJ. So for instance, Ambassador Bob Ray, speaking on behalf of Canada, has said, it is our understanding the veto must be used consistently with international law and the UN Charter. And now I mentioned 3 other states who have spoken similarly. My ideas are not completely new to me. Zaid had these ideas years ago when he represented Jordan and spoke about them. I saw Louise Arbour writing the veto in the face of genocide, suggesting it would be void. So there are others. I think it's important to socialize these questions, get these ideas out there. And some have also said, well, how do you know you will get a good answer at the ICJ? And I said, well, another approach would be to put your understanding in a GA resolution. So if you don't like asking an open-ended question to the ICJ, you could take some of the ideas and write them in the text of a resolution. The GA would control that text. But I will still say I'm somewhat bullish on the ICJ. You referenced their tremendous activism or activity. I don't know how activity in going to the ICJ. So we're certainly looking at atrocity crimes so much more by evaluating legal obligations, the duty to prevent genocide. Countries are using the ICJ as a forum to litigate under the Torture Convention, under the Genocide Convention, whenever they, so I have new optimism in utilizing the ICJ. But my book also, all of the law in the book is from decisions of the ICJ. So I feel that there are many decisions. They say the Security Council is bound by international law, and they have opined on good faith obligations and what this means. So I make my arguments and I use their Wall and Chagos cases. I'm really making my arguments out of ICJ law. Now, it doesn't mean we get a fully good, answer. We've all read the nuclear weapons decision. So the ICJ is famous both for ducking questions, which shows the importance of how we frame it, and giving half good or half bad. But I would say right now we read the veto, go ahead, veto anything. You know, humanitarian assistance, who needs that? Veto the humanitarian assistance. Preventing genocide, who needs to do that? So I would opine that right now, there's absolutely no limitation. So I actually don't see the downside of going to the ICJ. I think I had a few other, I also am not a big fan of Article 16, that the Security Council can defer and muck with the ICC's work. But it is there. I think I had a couple of other ideas, but I don't.
On Article 16, I give it as an example, only example, where the veto can do something good.
The veto blocking the ICC? I'm
the veto will.
I'm not sure I see that as something good.
The other way around. It is the other way around. The veto will stop the blocking of the prosecutor.
Oh, I see. Stop the blocking. I'm sorry, Vesely.
Out
Yes.
of the fight will raise a hand,
Yes, I'm sorry.
and the prosecution can go on forever.
Thank you. Sorry. I miss. Yes, you're
no
absolutely right. The
You can just
veto
imagine the
stop
United
the block.
States will go to the Security Council and say, please adopt a resolution stopping an indictment against Netanyahu, and the Russia or China will say veto. So then we can praise Russia and China for their great contribution to world peace.
Yeah, that's my fear, Bill, as well. On this
you
one,
cite Jennifer, you cite Bob Ray saying that he thinks the Security Council should operate in accordance with international law. Who could agree? Who could disagree with that? That's not the issue. The issue is whether the International Court of Justice should sit in judgment of whether the Security Council and its members are acting in a manner consistent with international law. It's not the same question at all. And back in the old Lockerbie case from 30 years ago, the court made it clear that we're not here. This is not like a government where you have or a state structure where you have a constitutional court that can conduct judicial review of executive action or of legislative action. It's not the same thing. That's not the nature of the United Nations. So I would be concerned about that. But there's one other element that some of you have mentioned. I think people say this all the time. The ICJ, the International Court of Justice, doesn't have any enforcement powers. I mean, this is characteristic of international courts generally. The European Court of Human Rights doesn't have enforcement powers either. But does the Security Council have enforcement powers? Ultimately, the Security Council, if it's going to enforce something, they call for the US Marines. That's about the extent of its enforcement powers. I'm not saying they're not capable of doing it, but it doesn't really either. Look at the recent resolution about Gaza. Is it being enforced? It's being enforced as much as the two orders of the court are being enforced. So I don't know. Most orders of provisional measures of the ICJ are enforced voluntarily by states. And I think it's probably true of most resolutions of the Security Council as well. But we have a few countries in the world, Israel isn't the only one, who think they're above the law.
well, I don't think Bill and I are going to decide all of this one today, but I do note on that last resolution for a ceasefire, right after it passed, the US said, well, that wasn't binding. And one of the difficulties, the council often isn't clear, is it under Chapter 6 or is it under Chapter 7? And it said it deplores, and I thought, of course, decisions are binding, and it used deplores. So I thought that's a stronger word than decides. It must be binding. But then the US said, oh, that's not binding. So they
say decides.
Sorry?
They have to say decides.
They have to, so they didn't say decides. So then the US says, oh, that's not binding. So when the US suddenly says that's not binding, that undermines the ceasefire. So we finally have a ceasefire not vetoed. And then the US says, oh, not binding. Maybe they didn't use the magic word decides. And that undermined. I will just point out, I'm into incremental fixes. One of the other things that states could do now is make more use of Chapter 6. So 27.3 says in decisions under Chapter 6, and a party to a dispute shall abstain from voting. If they used more Chapter 6, they could have the council could have recommended a special tribunal on the crime of aggression being negotiated between the UN and Ukraine, how they created the special court. And if they actually use this language, Russia, a party to the dispute, would have to abstain from voting. So I don't know why the council doesn't use this language. It last used it in 1960 in the Eichmann case. Argentina abstained. Too often, I think it's left to council members, but for Russia to say we're not a party to the Russia-Ukraine, situation, I think is implausible. So I think the council members need to try to make more use of this provision. And if the GA is interested in trying to push this question, again, the tools would be to draft a GA resolution alerting the council to this important provision in the charter. One could also go to the ICJ, or the council members could simply start using this. So that's my maybe last idea on incremental reform. I guess the panelists need to ask for guidance from Pier Paolo. Do you want to ask for audience questions? Are there any?
I can say wow, because I anticipated an interesting panel, but it was impressive, so I don't want to interrupt you. Yes, we can open the floor to question and answer session. We have one question. No.
Firstly, I'd like to say it's an honor to get your insights, professors. So I'm a student that has studied in India, and trust me, I'm just in my first year. But it's always been in my mind as someone who did study political science, in high school, that why did India never get a chance to be a permanent member, knowing that we've contributed more than 2 million troops in the, UN peacekeeping forces, world's largest democracy, now even having the world's largest population, while also fulfilling the representation of cultural diversity, with the fastest growing economy. We've also been contributing economically to the UN. So if I could say the word, why are the permanent members fearing getting India as a permanent member, and why do we always get vetoed on the same? And what would happen if India does become a member of the Security Council, and how would that impact, all the genocide conventions and crime against humanity, any laws that would further come up? Thank you.
So I would just briefly chime in, but yeah, Bill, you can, I'll be super brief. It has been, one of the proposals that Jennifer mentioned and that I had mentioned as well, known as the G4, would be to give India, Germany, Brazil, and Japan permanent seats at the council. So at least we know that it has been, sort of proposed and debated. But I think that it's a great question. I don't know that we quite have the time to answer it because it's very complex. But I see that Bill has his hand up, so I'll yield the floor to Bill.
Well, just to answer the question, I mean, all of this happened in 1945 when India was not yet an independent country. The United Kingdom, which was, of course, going to be one of the permanent members and which had been central to the drafting of the charter, was sure that some of the founding members, several of the founding members of the United Nations, were in effect what they used to call dominions or colonies of the United Kingdom, not just India, but also at the time, South Africa, Australia, New Zealand, Canada were all going to give them 5 votes in the General Assembly instead of 1, which they should have had. And that's why, for example, the Soviet Union came along and said, well, you have to give us, well, first they wanted to have all of the Soviet republics, and the British and the Americans vetoed it or objected to it. And they said, no, but you can have Ukraine and Belarus, which is why they are both founding members of the United Nations. As the United States, they didn't have colonies, but they had most of the Latin American states were pretty loyal to them and they controlled them. That's why. But India was a founding member of the United Nations and in 1946, and it played a hugely important role in the early years of the United Nations, dealing with racial discrimination, fighting against South Africa, proposing the resolution on the Genocide Convention. So it's a great subject for you to study, but India in those days was a beacon and took advantage of its new position, where it had a voice in an international organization, something that had not really happened before, where it wasn't under the thumb of the United Kingdom. Amongst other things, there's another clause, no one talks about it very much these days, but there's Article 2, Paragraph 7 of the Charter of the United Nations, which is the domestic jurisdiction clause, and India blew a huge hole in that with a resolution that it proposed in the General Assembly in 1946. So maybe when Nelson Mandela got out of jail, the first thing he did, he went to New York to the United Nations and he thanked India for the role it had played in dealing with racial discrimination and with apartheid in the United Nations.
Yeah, if I may add a few words on that. I often receive this question from my student about Indian permanent membership. And I used to receive the same question in Japan when I was there from Japanese students, why Japan is not a permanent member. And my kind of answer to all of this over the last 20 years is, why do you really want to join the club of aggressors and war criminals? Do you like to be part of that club as they are currently? You are too peaceful and too beautiful to join the club of aggressors. Actually, the position should be exactly the opposite. Do not join the Security Council as permanent member and demand reform where there will be no veto and no permanency. What India should do, and Japan and Brazil and South Africa and Germany should do, is actually to pioneer the change and to say we had too many, not too little permanent members. We don't need permanent members. We don't need veto. We need a democratic system. The veto has been the problem, and the permanency has been the problem of this Security Council for 79 years. We need a new world. And that will attract the rest of the world, not the permanent membership of India and Japan. If you need two-thirds majority in the General Assembly, India should drop the demand to be permanent. Japan should drop the demand to be permanent. India should join the Rome Statute of the ICC, and India should stop trading with Russia. That is my advice to India. Thank you.
Thank you, Professor Stereo, Professor Shabas, and Professor Pogowski for this provocative answer. Provocative answer. We have other two questions from the audience. I will send you my question by email because we have to conclude. Please.
Good evening to all the professors there. First of all, I'd like to thank you all for such an interesting session. So my question is based around the functions of the UN, which includes the veto in a more specific sense, which is their collaboration with the ICC, the International Criminal Court, under Articles 13b and 16. So before coming to my question, I say that I do agree with Professor Shabas and Professor Jennifer on the fact that Article 16 in itself needs to be removed. I had this discussion with Professor Pogowski in one of the classes where Article 16 in itself has also been misused, even with the power of the veto being available to cancel it out, which was Resolution 1422 and 1428. So my question revolves around Article 13b, which is the referrals to the ICC by the United Nations. We've seen criticisms against it with regards to the veto power being used to stop such referrals. So one of the solutions that I had provided for was, can such a power be granted to regional organizations such as the African Union or the European Union or SAARC or ASEAN or other such regional institutions, so that there is more accountability and more democratization of a referral process, and there's more accountability to the same.
Thank you. I think I understood the question. It was just a little hard to hear, and I think it was to me. And I think it was about, could there be referrals by regional organizations? And there actually, at one point, I think was a proposal. It may have been put forward by Kenya. It was not really pushed very much, but I think there was a proposal that GA should be able to make referrals because they were objecting to the Security Council didn't grant them a deferral in the Kenya situation, which they had wanted. And then they wanted the General Assembly to be involved. So Rome Statute amendments are possible. There's a working group on amendments. So, you know, I've been active with Professors McDougall and Reisinger-Corricini on the amendment on jurisdiction on the crime of aggression. there's certainly no limitation that you could have regional organizations referring situations. You know, it's really what the appetite in the room is, and would states support this? And, you know, I can imagine, you know, like if the AU says we should be able to make referrals, of course, countries in other regions would say, well, we should be able to. So then it would be the different regional actors, and not all of our regions have such active regional groupings. But I think it is possible. And then you probably would have the question, would they be subject to, could they do deferrals? And could you have a regional organization refer and then the Security Council defer? It could start to be very political, which is why I'm just never really a huge fan of these outside bodies being involved in the ICC's work. I kind of just want the ICC to be left alone to do its work where the evidence leads. So I'm maybe not a huge fan. I don't even like the council having power over the Rome Statute system. But I don't see that there's any reason this could not be put forward and proposed.
And I think, Jennifer, just to jump in on this too, Bill, you're next. I see you as well. You know, I think the question might be also, are we talking about a regional organization referral that's more akin to when a state party refers a situation, or are we talking about a situation where the regional organization is acting like the Security Council? And I think if it's the former, I think it's less, I'll say, problematic, right? If it's the latter, then it opens up a whole host of other issues. Bill.
I think that the issue of referral isn't really a problem, because if you're going to have a regional organization, you're almost inevitably going to have member states in that organization who have the power to refer under Article 14. So I don't think it's a practical difficulty. We had a referral against Venezuela that was done by something called the Lima Group states. I don't think it's a formal international organization, but there is some of that going on. But of course, if there's a member state of the court, a state party, then you don't need the organization to do it. And the real problem is with Article 16. And I think that that's where the issue, there was an amendment proposed by South Africa, I think, or by Kenya, maybe it was South Africa, to add to Article 16 the General Assembly, that the General Assembly could block a prosecution by a resolution as well. And I think we've probably discussed this enough. What we need is not more power in Article 16, but less. We need to remove Article 16 altogether. The other thing is, as we see right now, our real problem with getting the International Criminal Court to behave in a more appropriate manner is not with interference by the Security Council, not with the political problems of the General Assembly or states parties, but it's with a mysterious prosecutor who is not pursuing investigations in a visible and aggressive way where he should be doing so, and seems to think that the crisis in Ukraine, which has a perfectly functioning justice system that's both willing and able to prosecute war crimes committed on the territory, doesn't really need the ICC. But there are places in the world that do need it, and it's not getting his attention.
Okay, we can have the last question for you, and then we conclude this part.
I did want to just add that Milan is right that there are two kind of uses of the word referral, and I wasn't sure which one the question was asking about. So states can refer, but it doesn't create jurisdiction. There has to otherwise be jurisdiction. So it would be one thing for a regional organization to refer, and it doesn't create jurisdiction. I mean, that would still need a Rome Statute amendment, and I don't think you need it, because as Bill pointed out, if states in the region support it, then they should just send it. But a different way one might envision is, would it act like the Security Council? Because the Security Council's referral under 13B is a referral as in a trigger, but it's a referral also that creates jurisdiction. So
That won't happen because then you'd
I
have
think that
League
won't
of Arab
happen.
States might
Yeah.
refer to the situation in the United States of America.
Yeah, I think that won't happen. But just pointing out, yeah, there are these different. And then if it's only to kind of get things going, the trigger of the investigation, then states can already do that. So we kind of don't need to go through the lengthy Rome Statute amendment process. The problem with amendments is not only agreeing on the text, but then you have to get all the ratifications to make them enter into force. And the states, you know, they're like, oh, starvation in civil war, that should be a Rome Statute crime. They all seem to agree. But when it comes time to actually ratifying, we see very poor ratification records. So these amendments are, you know, and it works very differently if you're under 121.4 versus 121.5. But it can be a very lengthy process. So amendments, they're not so simple to get.
Yeah, I fully agree with this, Jennifer. It will be very by the way, earlier today we had because you joined later, there was a very interesting debate between Dave Crane, the ex-prosecutor for Sierra Leone, about the possibility of a special court on the crime of aggression in Ukraine. And somehow the opinions very much divided, whether we need a special court of the General Assembly only on the crime of aggression in Russia, or to have a lengthy process of amending the Rome Statute of ICC to allow for the crime of aggression to be prosecuted. So I wonder what the panel thinks on this.
Veselin, I'm sorry that I missed that panel. I think I've been involved in this issue since the weekend after Russia invaded, when I was working with Liechtenstein and we said, don't we need a tribunal here? And we put together what became the proposal for the General Assembly to recommend the creation of a tribunal with it established by bilateral agreement between the UN and Ukraine. And a number of states supported that, but then unfortunately other states did not. I refer to the US, UK, and now we're struggling to do a middle ground. But I stick with the position I heard Professor McDougall say, Carrie, that the Rome Statute ideally it's a two-step. We do a Ukraine tribunal now on the crime of aggression, and we fix the Rome Statute. So we don't want selectivity. We want to fix this across the boards. It can't be just when Russia invades that we have justice. So those of us who are working on this, I think strongly believe it is a two-step. We don't only support the crime only in this one instance. We want to fix the Rome Statute. But it is in part because of, first you need to agree on the amendment, and then it's the adoption procedure. And if we do 121.4, Roger Clark, who many on this will know, said to me, if you do 121.4, that requires 7/8 of state parties to ratify. He said that will not be achieved in my lifetime. So those are words that I will not forget. So it's a difficult process, and unfortunately we anticipate being fought by countries that don't want accountability when it comes to the crime of aggression. And these are the same countries that have fought back against an international tribunal because they don't want the precedent. And what they're doing is granting impunity to Putin and top-level leaders. And it's despicable. And I refer to the G7 states who say, oh, Ukraine can prosecute this. And why? Because they know under the ICJ Eurodia decision, a national prosecution cannot prosecute the Troika. And of course, I think they would not mind Putin being prosecuted if it only applied in that situation, but it sets precedent for prosecuting high-level leaders. And I think in the long run, certain countries are afraid of this precedent. You know, what's good for the goose is good for the gander. We can't do aggression prosecutions vis-a-vis Russia without creating some precedent. And yes, that precedent should be created, because if we ever want to deter from the commission of this crime, We need a strong response. We need a strong response to deter China or any other actor from blatant invasions, manifest violations. The crime of aggression only criminalizes a manifest, a super clear invasion. That's why we need both the aggression tribunal and the amendment proposal. Sorry, Veselin, I care very strongly about this issue. So
that was very much the spirit of that discussion earlier today.
good,
And thank
excellent.
you for joining that advocacy. Bill, you want to?
I don't think you should pick on China. Who has China invaded in the last 50 years? Pick on the countries who've invaded. Pick on the United States and the United Kingdom, who invaded Iraq in 2003. That's, who bombed Yugoslavia in 1999. That's where our problem is with all of this. And that I'm not enthusiastic about this idea of a two-stage amendment or two-stage process, because we'll never get to stage two. It will just be an ad hoc attempt to deal with Russia, and we'll never get it resolved. When the Rome Statute amendments were adopted, I think you were there in the room, Jennifer, in Kampala in 2010, and I remember when just before they called for a vote and before the amendment was adopted, the Japanese ambassador took the floor and he said, this is a flaw. This is a legally flawed amendment. It's legally flawed because we're trying to get around the amending provisions of the statute, and we're not doing it properly. And he said it's going to come back to haunt us, because maybe decades later, you'll have a legal challenge to it, and some will point out that these amendments were not adopted and didn't enter into force properly. Maybe the answer is just to say, instead of now what we're trying to do, now what the proposal is to repair the flawed amendment. And maybe we'd be better just to rip it all up and start again. Have a resolution of the Assembly of States parties recognizing that that amendment was totally flawed, and adopt a simple amendment that just adds Article 8 bis to the statute and nothing else, and prosecute Article 8 bis like the other three crimes. That's my suggestion.
And if I can just jump in on the question, that's a great suggestion, Bill, a topic for a whole other panel for sure. On this issue of the special tribunal for aggression, if we do care about international law principles, such as, Jennifer mentioned head of state immunity, the Eurodia case, it does matter as to how this tribunal is set up. To be able to circumvent head of state immunity, you truly need an international tribunal. I know that there are others who, Kevin John Heller has written, Jennifer knows Kevin John Heller has written about this and has argued basically that even, in the Eurodia case, when it said an international tribunal, international criminal tribunal could prosecute a head of state, the Eurodia case the judges must have contemplated a regime where that's actually part of some kind of a treaty, that basically you can't, encroach on state sovereignty in this way, sort of in the abstract. I don't know if I quite agree with that, but, it would matter as to how the tribunal is created. And I go back to what, something that Bill said earlier about the political will. The United States, unfortunately, the United States has clearly endorsed the approach of a hybrid or sort of, national tribunal supported by the international community. So we know that the United States is clearly not in favor, definitely in light of the 2003 invasion of Iraq, aggression, if you will, in Iraq and other situations. So I do worry that the political will is just not there.
The United States proposal on Ukraine is, they call it, I think the term that Ambassador Van Scott used was a tribunal rooted in the Ukrainian justice system, but with an international component. I know what that's going to look like. It's going to look like what they did in Iraq. It means it'll be formally a Ukrainian tribunal, and it'll be run by a bunch of State Department lawyers.
That would be the preferred U.S. approach for sure. I agree with you. Absolutely.
Last question, because there is the students here waiting for 30 minutes. So
thank you so much, professors, for this discussion. We read your work in class, Professor Shavis, so it's incredible to hear from you actually. My question was towards Professor Trehan. You had mentioned that once the way to take incremental decisions towards removing the veto power is by first starting with an ICJ advisory opinion. What then would be the sequence of steps, assuming that such an opinion is in favor of the veto being removed? What would be the next sequence of steps till the final goal is achieved?
So I'm not sure I totally understood the question. It did mention removing the veto power. So I do want to say, I'm not saying remove, I'm just saying that we need to adhere to other obligations of international law. But I'm not sure, can someone, one of the other panelists help me? I didn't really understand, I just didn't hear part two.
I heard a sequence of steps. I think sort of like how you would
How would
achieve.
we operationalize this?
Yeah.
So yeah, I guess my sequence is for states need to speak out, and we, you know, it could even start building some opinio juris if states start speaking out. Could we be building customary international law? So maybe speak out, General Assembly resolution, eventually reach the ICJ. As mentioned, that's non-binding, but I think they're highly influential. It still would be really important. Again, it wouldn't be so much removing the veto, but saying you have to, you know, other obligations. You cannot be defeating jus cogens, the UN Charter. So first, kind of, we need that general proposition. And eventually, you know, one could imagine a question on a particular veto. But I think even working in this direction puts pressure on Security Council members. Stop your veto in the face of these crimes. There's obviously, you know, 2/3 of the UN General Assembly says, don't use the veto, and they're not listening, right? So we need to up it and up the pressure. And I say, take them to the ICJ. You know, and maybe that can start to change the behavior. Maybe they don't want to reach the ICJ on this question. Maybe they don't, they fear a ruling that could somehow say, yeah, law matters in terms of your veto power. Who knows? Maybe then they say, okay, we endorse the French-Mexican initiative, Code of Conduct. We agree, at least voluntarily, we will not use the veto. Even that would be a good step. Veselin portrayed it so starkly, you know, counting up 1 million fatalities from the vetoes in a number of the situations. The veto is killing individuals on the ground. And we need to make this linkage. We need to make it clearer. We need to pressure states to work on this. And even the E10, I think, can play a greater role. Put resolutions on the table. And particularly for China, they're like, oh, we don't want to put it, they would veto. But then we don't see why there's not accountability internal to Myanmar. Never will be accountability for the crimes against the Uyghurs. We're not seeing the influence of China or Sri Lanka because it's happening behind the scenes. Well, the E10, they also have a responsibility. They need to be putting resolutions, because I talked about the obligation to prevent genocide. It's not just on the P5, it's on every state. So they need to be taking on these questions as well. I hope somewhere in there I was responsive to the question, and I apologize if I was not.
I believe that you answered to the question. So if we don't have other questions, we can proceed to the closing remarks. I would first of all to extend my deepest gratitude to Professor Taran, Professor Stereo, Professor Shabas, and Professor Popovsky for this huge contribution to the today discussion. And of course, I want to also say thanks to all the estimated speakers that have participated today this first roundtable on confronting global conflict and the rule of law organized by the Center for Study of the United Nations at Jindal Global University. As we conclude, I hope that the knowledge and perspective gained today will help us all of us to continue advocating for justice, accountability, and peace in international relations. Once again, thank you all for your participation. Thank you also at this wonderful audience that asked interesting question and accentuated the debate among, between the panelists. Once again, thank you, and I wish you all a pleasant evening, Friday evening for us. For you is still morning, right? So a good day. Thank you again, and I think we can conclude here.
Thank you so much.
Thank you. Bye. Thank you.
Bye-bye.